The speakers for today is Advocate Ronaldo. You'll be the first speaker, and followed by Dr. Bonani and Mr. Osefo and God's Glory. So each speaker would have 10 minutes, and the last speaker on that panel, Rachel, how do you pronounce that? Yes, I almost got it right. Rachel, she wasn't able to make it. So we have the other speakers 10, 10, 10, 10. And then we'll take some questions, comments, additions, and subtractions, right? So without much further ado, I'd invite the advocate to come and give us a presentation on Kenya.
Good morning once again. As rightly introduced, my name is Ronald Alamano Mudi, and I'm here in the company of Peter Yangwin Mudei, together with whom we have been able to prepare this paper. I must admit it's my very first time meeting Professor Charles Format, and I was quickly struck by a sense of humility in the face of all that he's been able to accomplish. And as the African saying goes, he's indeed a giant who walks with his shoulders low. Our paper is titled Constitutional Limits on the Application of the Political Question Doctrine, a study of Kenya and South Africa. And this paper was largely influenced by the tension that exists between the judiciary on the one hand and political branches, and therefore the need to ensure there is a principled approach for ensuring achieving institutional committee. Those of you that have read Professor Charles Format's articles will notice that he frowns upon the idea of absolutism of either of the branches within its territory. The principle of constitutional supremacy, which has been embraced by Kenya and South Africa, in our view, is a very harbinger for impermissible intrusion and absolutism of either of the branches within their territory. And those of you that have taken time to engage in scholarship around the political question doctrine will realize that there has been a transition from the traditional conception to the modern conception, where courts are saying, in as much as you may want us to shy away from political questions, that is not what we are going to do. We are going to review these questions for their constitutionality. You'll also remember Marbury versus Madison, the leading US Supreme Court decision on the political question doctrine, where the court was very emphatic in the position that questions in their nature political can never be made in court. What this paper says is these questions must in fact be made in court. And it is then the interaction of the court with these questions when they are made in court that becomes of significance to our paper, because they can either yield a constitutionally permissible intrusion or a constitutionally impermissible intrusion. How do we describe a constitutionally permissible intrusion? We find that such an intrusion arises when a court narrowly interprets the text of the Constitution and its institutional authority in a way that remains conscious of the discretion that has been committed to political branches. And how do the courts do this? They narrowly interpret the Constitution by affording constitutional text their plain meaning. And by doing so, they run away from the threat of rewriting the Constitution in the name of interpretation. We also say that a constitutionally permissible intrusion will present itself when courts acquiesce to a constitutional design that allows political branches to supply determinacy to constitutional text that is indeterminate. I will also take us now through what a constitutionally impermissible intrusion entails. And we find that this kind of an intrusion arises when courts expansively interpret the text of the Constitution and the institutional authority. And as they do so, they will then be able to find constraints that are not evident in a plain reading of text and apply it in countermanding the actions of political branches. When they are also expansively interpreting the authority, they will take it upon themselves to supply determinacy to constitutional text that is indeterminate, forgetting that we have a design that then empowers political branches with the duty to supply such determinacy. Impermissible intrusions have a danger of eroding the hallowed principle of separation of powers, and they feed into the argument that judicial review is undemocratic, as Jeremy Waldron has very often argued. Kenya and South Africa have taken a very similar position on the justiciability of political questions. In Kenya, under Article 165(3)(d)(2) of the Constitution, the High Court has interpreted its jurisdiction as unfettered insofar as pronouncing itself on political questions is concerned. In South Africa, under Section 167(4) of the Constitution, the Constitutional Court has interpreted its jurisdiction as conferring it exclusive authority over political questions, which it describes as questions relating to the sensitive areas of separation of powers. And for this, you will be able to make reference to the case of Doctors for Life International, or the Speaker of the National Assembly. Common in the two jurisdictions is a two-step inquiry that courts engage in when they are confronted with political questions. Firstly, they ascertain that indeed this question has been committed to a political branch. And then number two, ascertain whether this branch has acted within the constitutional limits of its power. Therefore, the idea that the political question doctrine is dead is clearly evident in these two jurisdictions. In a recently decided case by the Supreme Court of Kenya, Edwin Dande versus Inspector General of the National Police Service and others, the Supreme Court affirmed the place of merit review of political determinations without being elaborate on the confines of this nature of review. And we have taken the position that the finding by the Supreme Court opens other courts to intrusions that we find to be impermissible. In the case of Martin Nyaga and 4 others, the Speaker of the Senate and 6 others, the Court of Appeal in Kenya made two critical assertions that we find to be constitutionally impermissible. Firstly, they made a finding that they have the power to determine what entails a gross violation of the Constitution in the impeachment process of governors, whereas a clear reading of Article 181(1) of the Constitution vests this power in the Senate and the County Assembly. The second position that they took is that they had the power to ascertain whether charges filed against a governor amounted to a gross violation of the Constitution, a position we find positions the Court of Appeal then and other courts in an appellate position over a decision that has been made by political branches. Interestingly, in the case of Justice Kariuki Mate and another versus Martin Nyaga and another, the Supreme Court interpreted the standing orders developed by the County Assembly as a limit to the wide and unfettered jurisdiction of the High Court under Article 165(3)(d)(2) of the Constitution. While the High Court and the Court of Appeal found the Speaker and the County Assembly as having acted in contempt of an order of the High Court stopping the impeachment process, the Supreme Court upheld the strict timelines embedded in the County Government Act and the County Assembly's standing order as a fetter to the seemingly wide and intrusive jurisdiction of the High Court under Article 165(3)(d)(2) of the Constitution. Yesterday, we had occasion to listen extensively to a conversation on the Nkandla case, which we have also discussed. And in the Nkandla case, you remember the Constitutional Court found Section 44, subsection 3, and Section 55, subsection 2, as failing to prescribe how the National Assembly was to fulfill its constitutional obligation of holding the executive accountable. However, it proceeded to find that the National Assembly had in setting aside the Public Protector's report, had in setting aside the Public Protector's finding and remedial action failed to fulfill its constitutional obligation of holding the executive accountable. In the exercise of its oversight role, nothing in the text of the Constitution or the National Assembly's standing orders precluded the National Assembly from setting aside the report of the Public Protector following a parallel investigation conducted by the National Assembly. We therefore, as we conclude our paper, make 3 recommendations that we feel will be very significant in ensuring that the kind of intrusions conducted by the High Court in Kenya, the Constitutional Court in South Africa, are of a nature that are permissibly intrusive. Number 1, judges should abide by the plain meaning of constitutional text in matters that impact on separation of powers and avoid finding constraints that are alien to the text of the Constitution and applying them in reviewing political determination. And number 2, judges should remain cognizant of the institutional limits of the authority and find as binding on them normative standards developed by political branches, not unless they contravene identifiable textual constraints. Number 3, when they are faced with indeterminate constitutional text, they should run away from the idea that they have the constitutional power to supply such determinacy and leave it to political branches to supply the same determinacy. Thank you.
Thank you so much for your intervention. The courts must address the political questions. And now we are moving to another political landscape in Zimbabwe with Dr. Zamboni giving us a paper on the conundrum of the courts and the political landscape. 10 minutes.
Okay. Good morning, everyone. I'm quite delighted to be here today. And I actually thought there were different meeting rooms until I realized that there's only one meeting room. And it means I will be presenting in front of the Godfather and all our Godfathers around here. So I am Bonani, and I'm from the University of Limpopo. I'm presenting a paper co-authored with Brian Chihera, who is attending online. The title of our paper is A Comparative Perspective of South Africa and Zimbabwe, the Conundrum of Courts of Law and the Political Landscape. Combat says, democracy flourishes best where free and vibrant political parties are permitted to openly compete for political power. The conditions must be such that the ruling party in power will not be able to manipulate the rules in order to reduce the competitive pressures from other parties and entrench itself in power. We can all agree that South Africa and Zimbabwe share a history of one-party dominant-led governments. In Zimbabwe, the ZANU-PF has led since its independence from Britain, led by Robert Mugabe, up to his ousting in 2019. Despite some political opposition from the MDC, ZANU-PF has consistently won elections, often amid allegations of electoral fraud. Zimbabwe, often described as a de facto one-party state, effectively has 44 years of one-party dominance with limited space for opposition parties to challenge its rule. On the other hand, the ANC has dominated South African politics for almost 30 years, with active opposition of the DA and EFF gaining ground. While South Africa is a pluralistic democracy with functioning opposition parties and relatively fair elections, Proformat suggests that despite much progress in transitioning to multi-party elections, there is a regression back to one-party systems due to the way elections are managed and manipulated by the ruling party. This has led to political parties resolving to seek resolutions of some of the impasses by involving the judiciary, which has since shaped the direction of politics in recent years. This paper assesses the constitutional provisions that guarantee electoral freedoms in South Africa and Zimbabwe. It analyzes recent elections in South Africa and Zimbabwe, overshadowed by controversy due to the involvement of courts in resolving political disputes. Some of the questions that we seek to answer relate to judicial independence, for example. Are opposition parties being subjected to judicial persecution? Do courts serve political interests or uphold democratic principles? Is there legitimacy in the matters brought before the courts, or are courts tools for political maneuvers? For example, concerning the court system itself, can the electoral court withstand the pressures of elections? For example, it took 22 days for the electoral court to deliver its full reasons in the Umkhonto weSizwe Party versus Electoral Commission concerning Jacob Zuma's candidacy for parliament in the elections that took place in May 2024. MK Party is a good example illustrating how the judiciary was central in the many disputes that were brought before the courts, including the contentions that the ruling party has regarding the name of the MK Party, its logo, and obviously the determination of whether Jacob Zuma can form part of parliament, amongst others. Some matters before the court included the interpretation on the amendments to the Electoral Act allowing independent candidates to run in national and provincial elections. In the case of Chamisa versus Mnangagwa, there was contestation over the election results. A unanimous decision was given to dismiss the matter, and it took a year for the reasons of the judgment to be given. The delay in reasons for judgment raised concerns about the transparency of the judicial process and the potential for executive interference in the judiciary. The Kasukure in Zimbabwe case involved a former Zimbabwean cabinet minister who wanted to stand for presidential elections. However, his matter was dismissed on the basis that he was absent from Zimbabwe for over 18 months. In both the MK Party and the Kasikuwere case, the critical issues relate to judicial independence, the fairness of the electoral process, and the transparency of court proceedings. The delays in handing down reasons for judgments are also a concern. While both countries' constitutions emphasize the principle of judicial independence, their historical context and political landscapes have led to different practical outcomes. Combat posits further that in many African countries, the problems were not caused by the absence of the constitutions. Rather, it was the ease with which African leaders had rendered constitutions dysfunctional by regularly ignoring their provisions or arbitrarily amending them when it suited them. When we define judicial independence, it is, how am I doing this? Okay. Yes. All right. Mzika-Manda defines judicial independence as the existence of strong democratic and judicial institutions working in general harmony with each other, with independent judges who strive to apply the law neutrally and within a culture that seeks to do justice according to the law. Chiduza states that judicial independence can be measured by how judges are appointed, how judges are removed from office, remuneration of the judges, and most importantly, if the judiciary has the powers to decide matters without outside influence. The South African case of economic freedom fighters versus Speaker of the National Assembly affirmed the judiciary's role in holding the executive accountable for his failure to implement the public protector's remedial action. This case demonstrated the strength of judicial independence in South Africa. However, in recent years, there has been an increasing politicization of the judiciary with claims of judicial overreach and public criticism of judges, particularly by political leaders. A notable challenge was the imprisonment of former President Jacob Zuma for contempt of court in 2021, which triggered violent protests. Despite these tensions, the Constitutional Court's firm stance in holding Zuma accountable reinforced its independence. In order to safeguard the rights entrenched in both the 1996 and the 2013 constitutions, elections must provide the primary means through which citizens express the general will of the polity. In this regard, we have 5 recommendations. In conclusion, firstly, a need to strengthen judicial independence through transparent appointments. Secondly, to enhance the role of civil society and international oversight. Thirdly, there is a need to apply the law impartially without the interference of the political elites There is a need to apply the law impartially without interference of the political elites. Last but not least, promote electoral and judicial reforms to build public trust. And finally, proposals to build the electoral court's capacity in terms of resources such as budget and candidature. Thank you for this opportunity.
Thank you so much, Nigel. On the question relating to judicial independence, looking at the politics side of things, and I'm sure by now you've noticed that this is a comparative session. The first presentation was a study between Kenya and South Africa, and now South Africa and Zimbabwe. We are going to invite Mr. Osebo and Ghost Glory to give us a take on Nigeria and Botswana, looking at judicial independence. I'm giving you 7 minutes each. That is not giving us corruption. I guess it's not corruption.
Well, it can be because we come from the same jurisdiction. Good morning, colleagues. My name is God's Glory. I'm very honored to be here to meet Professor Fombad. I think I'm the youngest of his old students. He taught me in 2006 and 2008. And so, Prof, it's really an honor to be here. And then Professor Dunokopila also taught me in 2011. So I have 2 of my lecturers here. That's why I have the advantage that's given me. Thank you. Okay, so I'm going to be we're talking to you, myself and my co-author, will be talking to you about judicial appointments in Botswana and Nigeria. Because we have such a short time, I'm going to squeeze all our presentation in 7 minutes. So we have 6 bullet points to our paper. You're going to see the contents, and I'll be dealing with the first 4. My colleague will be dealing with the last 2. I will not bore you with the tenet of judicial appointments and the principles of judicial independence. I think that all the scholars here agree on principles, and Professor Fombad has done a very good job of writing on this, as well as Professor Dunokopila as well. We saw a recent article by Professor Fombad, 2021, where he draws a comparative analysis of Botswana, South Africa, Kenya, and Nigeria to an extent, and we've also borrowed heavily from that book. Let me talk about the legal framework of judicial appointments in Botswana and Nigeria. So Professor Fombad says that the best model is for the Constitution to entrench the process of judicial appointments, and both Botswana and Nigeria borrow that model. The Botswana Constitution and the Nigerian Constitution spell out details of how judges are to be appointed in both countries, and in both countries, they have independent bodies. Botswana has a Judicial Service Commission, Nigeria has a National Judicial Council and Judicial Service Commissions that deal with the process of appointment, and in our paper you would see how they deal with the issues of appointments. I'll go straight to the next point, which deals with the issues surrounding judicial appointments in Botswana and Nigeria. Why I love our comparative analysis is quite aside from the fact that it represents the countries that we both come from, they also represent the two major government systems that we see in Africa and the rest of the world. Botswana has a unitary government system, Nigeria has a federal government system. And so they both draw the contrast between how judicial appointment works in a unitary system and in the federal system. Botswana unitary systems are normally simpler models of government, and we see that even in the process of appointment in Botswana. Federal governments appear to be a bit complex, and we also see that play out in the judicial appointment structure in Nigeria. And even when it comes to the problems affecting judicial appointments in both countries, the complexities also present themselves in Nigeria, with Botswana not having as much issues as Nigeria does as regards judicial appointments. We've identified 4 issues that affect judicial appointments in Botswana and Nigeria. Of that 4 issues, 2 affect both countries and 2 are very peculiar to Nigeria. The first issue that we have that affects judicial appointments is the composition of the appointing bodies themselves. We find that the composition of these bodies make them prone to executive interference, which is a second issue that we discussed. And Nigeria has I don't like the composition of the Judicial Council in Nigeria because of the 24 members of the National Judicial Council, we have 7 that are supposed to be independent, but these independent people are appointed by the Chief Justice, who is also a presidential appointee. So essentially what we have in Nigeria is a National Judicial Council that is an executive body that is filled with people that have been appointed by the president. And that affects the interference within the Judicial Council. In 2023, the Chief Justice of Nigeria presided over a meeting of the National Judicial Council where his son was appointed as a judge of a federal high court. And this happens with judicial appointments in Nigeria. Judges appoint their children, their siblings, and we have a lot of nepotism. So that's a major issue that we have in Nigeria. We haven't gone that far in Botswana, but there are issues with the composition of the Judicial Service Commission. We also have political interference in the process of appointment and discipline of judges, particularly in Nigeria. Botswana, we only have rumors, we don't have anything on record. It's been said that there is political interference, but we don't know for a fact. But in Nigeria, it's very interesting because you have the president suspending the Chief Justice without recourse to the National Judicial Council. You have a governor of a state taking out the Chief Judge of the state because he does not like the Chief Judge of the state. And you have these issues and you wonder where does judicial independence really have, what place does it have in judicial appointments in Nigeria? The third issue that we have the lack of transparency in the process of appointment. Both in Nigeria and Botswana, we don't know what goes into choosing judges. We know that these bodies exist. There's no idea how their processes are conducted because most of it are done in camera, unlike South Africa where there is publication and there are interviews and you see the caliber of the judges that will be appointed. We don't know what happens and what goes behind the scenes. So that's another issue that Botswana and Nigeria has. And then the last issue, which is very peculiar to Nigeria, is that there's a merit versus federal character principle issue that we have. So in Nigerian Constitution, Section 14 says that in any process of appointment in any government office, the person appointed must take into account the federal character, meaning must take into account the diversity of Nigeria in making appointments. So what has happened is that most people now use federal character to trump merit. So where you are supposed to appoint a person that has merit, you discard them because you are relying on federal character. So that is one of the major issues that we have in judicial appointments in Nigeria. Now, with all of this said, I do have to commend the Nigerian National Judicial Council because unlike Botswana, what the National Judicial Council in Nigeria has done is to discipline judges. There have been instances where judges have taken bribes. There have been instances where judges have issued orders without foundation. The National Judicial Council has made recommendations for the removal of those judges, and in certain cases, they've also made recommendations that those judges should not be promoted for a certain number of times. So I like that. I like that the National Judicial Council, despite its failings, is taking steps to ensure that judges are actually staying on track. And I think that Botswana can take a lead from this because we've had instances in Botswana where the Court of Appeal has made statements and concerns about the quality of judgments, about the conduct of judges, and all of that is said, nothing is done by the Judicial Service Commission. So I think that Botswana could borrow a lead from the National Judicial Council in Nigeria to be proactive in ensuring that the quality of judges, even after appointment, is maintained because that is also key to the independence of the judiciary after judicial appointments. So that's where I'll end my presentation and I'll hand over to my colleague. Thank you very much for this.
Good morning, everyone, and thank you. I'm very honored to be here this morning. I know probably the introductions are going to eat into a lot of my time, but they have to be made. Professor Fombad taught me back in 1997, so while she might be the youngest, I'm definitely probably the oldest of his of his former students here. He taught me delict in my second year at in the law program at the University of Botswana. So I'm very honored to be here and present this paper to celebrate his scholarship. I also want to thank you for having this event here at this very lovely place, because as I was driving here, I came across all those cows. It reminded me of home in Gaborone, because we pass cows all the time in that city. So thanks a lot for that. One of the great things about doing this paper is that it has opened my eyes up to new thinking and new ways of doing things, especially in the comparison between Nigeria and Botswana. Now, Botswana is Africa's oldest democracy, with 58 years of continuous democratic rule. So you may think that there's nothing that Botswana could learn from a country like Nigeria, which has gone through military coups and military dictatorship. But it was very eye-opening doing this paper with God's glory, because it showed that there is something that can be learned from other countries on the continent. And one of the things that we picked up in terms of the reforms that need to be made is that, particularly with respect to Botswana, is that the JSC in Botswana certainly needs to be reviewed. The last time that any reform happened with the JSC was almost 30 years ago, in 1996, 1997, when the JSC was expanded from it being a 3-member committee or council to a 6-member committee or council. But what is clear from our paper and what we point to is that that still needs to be reformed, because the influence of the executive is still quite strong in Botswana's JSC. In terms of the 6 appointed members of the JSC, 5 of them have an influence either directly or indirectly from the executive, with only 1 member being appointed as a nominee from the Law Society of Botswana, which I head at the moment. The other thing that we could learn from Nigeria is the issue of the federal character principle that my friend has and colleague has raised. Now, in the Nigerian context, it has been criticized, as my colleague has pointed out, because it has lended itself to the application of the federal character over merit principle. But in Botswana, we have looked at it and thought that the character issue is more of a societal character issue, in the sense that there needs to be more representation from other sectors of the society. So in the instance of the Judicial Service Commission in Botswana, what you find is, as I mentioned, the 5 members of the JSC are made up either directly or indirectly of presidential appointees. You have the Chief Justice, the President of the Court of Appeal, and the Attorney General. Now, all of those are politically appointed. Then you have, they're politically appointed to their substantive positions by the President. The other 2 are the chairperson or the head of the Public Service Commission, who is also appointed by the President. And then finally, you have a person of integrity who is a member of the public, who is also appointed by the president. And as I mentioned, you only have one member who is a nominee of the Law Society of Botswana. Clearly, there is a need to expand the JSC to include more voices so that you create a balance in terms of the representation that is there on the commission. The other issue, I believe, is a never-ending question about who guards the guardians. Whenever we talk about appointments to the JSC or the work of the JSC, it is fundamentally a question of who is guarding the guardians at the end of the day. And for us, we believe that in Botswana and in Nigeria as well, that there has to be an opening up of the process so that the process is less secretive, more open to public scrutiny, as is the case in South Africa. And we have seen developments in Zimbabwe and in Kenya, where that has become the norm. The Botswana process is very secretive, and particularly in the case of the appointment of Court of Appeal judges, where the process is not as open as the process that leads to the appointment of High Court judges. And finally, in conclusion, what we speak about is the fact that in terms of African constitutionalism, the truth of the matter is that it is always in flux and that nothing is cast in stone. And we point to the progress that South Africa, Zimbabwe, and Kenya have made in opening up the process to public scrutiny as a marker, to the point that there must always be pressure. There must always be a progressive move for reform. And we call upon non-governmental organizations, bar associations, to continue to put the pressure on the authorities, on whoever needs to be pressured in Parliament included, in order to bring about these reforms and make sure that they take hold. With that, I hope I haven't taken too much of my time at all. And I thank you for your listenership. Thank you.
Thank you so much. And then we have a few minutes, as I've indicated earlier, the last speaker scheduled on this panel was not able to make it. So we have a few minutes to take questions. I'll take a few, and then I believe then we'll have to break for tea. Isn't it, Prof? No? Tea is at 11. We will have another session. Oh, yes. Any questions? Yes, someone help with the mic.
Good morning. My name is Nathan Bushoma from West Midlands. I just want to ask Dr. Manani a question. My question is, do you think our judicial system is captured? And if so, what can be done to capture? And also, do you think, if you say it's captured, do you think if you say it's captured, rather, do you think taking away the president's powers to appoint the judiciary will help in that regard?
Is there any other question? Okay, looks like there's none. I have a question for the kids. You mentioned the introduction of merit review. And then I was wondering whether there's any connection between that and determinism. Is there any between the merit review and the issue of determinism? So, okay.
Did you really have to ask me about capturing and my honest opinion? I think so. I think it is captured, and the executive has a lot of power, and I'm not so sure whether there is any lessons we can get from elsewhere on how they do things. But right now, I think it would be most, it would help to create some form of integrity and to move away from perceived or real bias or some influence over the judiciary if that control was removed from maybe some form of committee like the JSC, that the way the candidates are interviewed, some more democratic process, I think would provide the level of objectivity that will bring back public trust. But at the moment, my trust is not fully in the executive. And also, I think if we look at the appointment of Zondi and the new Moyo right now, and we look at the timing, certain decisions were made which can clearly show how the judiciary could have been influenced by the executive. I hope that helps.
Thank you. I would say there is no connection between merit review and determinacy, because when we speak of merit review, we're inviting the court to sit in an appellate position over the decisions of an inferior body. It could be a lower court or an administrative body. And within the realm of constitutional review of the decisions of coordinate arms, our argument has always been the court cannot sit in a merit review kind of position. When we speak of determinacy, we basically say we have a constitutional provision that is vague, and an invitation is extended to the court to further develop that provision. So what we then say is that it's not for the court to develop that provision. The court should throw the ball back to the relevant political branch. It could be the executive, it could be the assembly, to supply determinacy, to supply meaning. And once that meaning is, of course, applied, the court cannot shy away from its role of ensuring the meaning aligns with constitutional provisions. And that alignment must be evident through a plain reading of the text itself.
We have a few minutes, and I want to ask the president of the Law Society on what they have done in relation to the appointment of judges, which they are raising interest in. And then lastly, also on the recent review processes, what has come out with respect to the judiciary, and whether there have been in Nigeria such processes to try and advertise the appointment processes of judges, both at federal and some other county levels. Thank you, Prof.
Thank you, Prof, for that question. And I think it's a very important question to ask, because particularly for the Botswana context, Botswana's civil society structures are quite, do not really have a culture of civil society activism. So what we have found is that it has fallen upon other organizations to develop and to put pressure on the structures for us to see progressive reform. One of those organizations has been the Law Society of Botswana, which is basically the bar association. And for the Law Society, it's been a very tough process. Because when the Law Society of Botswana is relatively young, it was only constituted in 1997. So if you look at it in comparison to other bar associations around the region or the continent, it's a relatively young body. And when it was promulgated with the sense that it would just be a regulatory body for the legal profession. So for the first, shall I say, maybe 10 years of its existence, it basically concentrated only with regulatory issues. But in early 2000s, there was a case in Botswana about the access to water for the Maasai, who are often known as the San or Bushmen. And there was a lot of pressure put on the Law Society at that stage for it to say something about the fact that the government of Botswana was relocating the San away from their traditional homes and basically relocating them to more modern, what they said, more modern areas, more modern amenities, so that they were closer to access to water. And I don't know if you know about this, it became a huge international issue with Survival International moving forward, etc., etc. There was huge pressure on the Law Society at that stage to say something about that, to move away from its base as just a regulatory body, and to say something about what was going on in the country in terms of human rights issues. And the Law Society refused to do that because it felt that it was just there to regulate the profession. And so the sea change happened in around 2006, when a new council of the Law Society was elected, and a whole culture change happened with the chairperson then and the council taking on these human rights issues. And from that point onwards, up to today, the Law Society has really been a champion for reform. So you asked me what the Law Society has done. Specifically, the Law Society has continued to push these issues. For instance, you will see in our paper we talk about the difference between the JSE has for some reason that has never been explained, a different approach to the appointment of High Court judges from those of Court of Appeal judges. High Court judges are positions are advertised, the vacancies are advertised. At least that process is open and known. Court of Appeal judges, we have no idea up to this day how they are appointed, other than to assume that it is the old tap on the shoulder process. But the question has always been, why the difference? And that has never been explained. So the Law Society has been pushing for that. I can confirm that the new president of the Court of Appeal has shown an interest in reforming that process, partly because of the pressure that the Law Society has brought. Another issue that we also touch on in the paper is that up until 2016, imagine from 1966 up until around 2016, Botswana did not have a female Court of Appeal judge. No woman, no female had sat on the Court of Appeal bench. And in 2015, at the opening of the legal year, the chairperson of the Law Society then brought this issue up, that our Court of Appeal bench is not representative of the society that we live in, racially and gender-based. And he was viciously attacked for raising such an obvious issue, and was accused of race baiting, of bringing racial issues up, and gender issues. But lo and behold, within 2 years, we had a female, our very first female Court of Appeal judge, and now we have 3. And now the president of the Court of Appeal is a woman. So these are the things that the Law Society, the list is endless, but these are the things that the Law Society as an organization has really What we don't have in Botswana, we don't have the likes of CASAC, we don't have those types of organizations in Botswana, freedom under law. And so it has fallen on the law society to bring these issues up. And it has actually caused quite an issue because there's always this fight between whether the law society should just be a regulated body or should, take up some of these societal issues. Sorry for taking such a long time.
Thank you so much. I think we have done well in terms of time. We have 5 minutes to spare, so I can just give each panelist a minute to share their views or their last words, and then we can close the session.
Thank you so much for having us. The idea of separation of powers continues to excite a lot of debate left, right, and center. But we still hold the view that the judiciary can still hold political branches to account in a way that is less intrusive, in a way that ensures there is institutional committee. And with the 3 recommendations we have made, we are hoping judiciaries in Kenya, the judiciary in South Africa will be able to have a meaningful engagement with political branches. One that does not allow them to shy away from their guardianship role or the Constitution, but at the same time, one that allows them to respect the constitutional design that allows political branches the leeway and discretion in key areas.
Okay, just to add that South Africa and Zimbabwe, obviously different situations, but similar at the same time. If Zimbabwe's processes can become more transparent, maybe learn something also from this South African example. Although I feel like we have different standards. With Zuma, things were very strict in bringing him to account as the executive. Now we do have the para issue, and the same treatment is not extended. So with those words, I'd like to say thank you very much for having me all the way from Limpopo, and it's really nice to be here. Thank you.
Yes, I think to answer the last question that you asked, I think we haven't had a situation in Nigeria yet. And I'm hoping that because we've had instances where those circumstances have arisen, where a governor refuses to endorse the recommendation of the NGC. And I thought that that would have presented the opportunity for the NGC to do what it's already been Tunisia and take the refusal of the House of Assembly and the governor to court, but they didn't. So I hope, and I'm hoping that in Nigeria there can be a political will to actually follow the constitutional processes for judicial appointment. I think that having lived in Botswana for as long as I have, I consider myself a Botswana, and I think that Botswana still does well, though there's still a lot of development or advancements that can be taken on board. But I think that Botswana is doing okay, and Nigeria and the rest of the world can also benchmark from Botswana. Thank you for this opportunity. Thank you for choosing our paper. It's really, really nice being here. Thank you.
All right. And ladies and gentlemen, my president, that brings us to the end of this panel. Thank you so much to the panelists for the interesting papers. I hope they will be developed, not given up. The job is done, obviously, and I hope that we'll be able to get it done eventually. And with that, thank you, ladies and gentlemen, for your attention and for having us.
Good morning, ladies and gentlemen. Welcome to the second session for today, and in totality, session number 5. And I'm Pacharo Kaira, I'm the moderator for this session. We're going to look at the broader perspectives on comparative constitutionalism, and we have one physical presenter today with us, and the rest online, 3 presenters online. And he was just asking that he should be the first to go. In terms of a summary of our presenters today, we have Professor Dr. Rainer Groth, who is online from the Max Planck Institute for Comparative Public Law and International Law. And then we have Professor Michael, who is with us today. And then we'll be joined by Mr. Dogmo Christophe from the Cameroon Center for Democracy and Human Rights. And then lastly, but not least, we have Dr. Kerry Catherine Lina from the Africa Center for Strategic Studies, National Defense University, Washington, D.C. So the previous group did very well on time, and we should follow the good example. 10 minutes each, and can you please start the session? Thank you.
Thanks, Mr. Moderator. I think I have a PPT, so can you help me to send a PPT previously? Okay. So, good morning, ladies and gentlemen, my dear colleagues, dear Professor Fombat. Today, I would like to share you my analysis of the value target implementation mechanism of African constitutions. Actually, this study is based on my previous several years of study of the African constitutions, its constitutional design, and its purpose, and the challenge faced by African constitutions, especially from my Chinese perspective point of view, how to maintain the political stability. Take it, you see full picture. Okay. Especially how to promote the development and maintain the political stability in Africa with the help of the rule of law. So I know you might be curious, me as a Chinese, as an outsider African continent, how could I do research on African issues? I tell you my secret. I just take the most stupid way. I read the constitutions of all African countries, all 54 constitutions. Actually, at the beginning, I thought it was not so much work, but it took me 2 years to finish all the meetings, one by one. Actually, when I first met Professor Fombat in 2014, I started. It took me more than 2 years to finish the reading. And I found actually, I don't know how you feel about reading African constitution. For me as a Chinese, I found it was really a very interesting, I would have to say, very enlightening process to read all these foreign constitutions, because I think it is really a good indicator of the aspiration of the framers of the African constitution, what they really want to achieve through this document with name is constitution. So as an outsider, and I showed Professor Fombat my book when we in China during my visit to my family. It's a very thick book, so I cannot express all the points. So I would like to focus on 4 questions. First, the values of African constitutions. Second, the democracy of African constitutions. with all respect, I would like to say democracy in the informality. And third, measures to enhance political stability and enforce how to ensure binding force of the constitution in reality. When reading African constitutions, I was always, and still, always impressed by the values of African constitutions. The first impression I got is the universal recognition of the binding force of the international document. So according to my study, 44 African constitutions refer to the binding force of international documents. Why this point is so important to me? Because there's no mentioning of the international documents in Chinese constitution. And almost no international law in Chinese constitution. So a sharp comparison, the African constitution, there are always some referring to the international, especially human rights documents. The most cited document is Universal Declaration of Human Rights. The second is African Charter of Human and the People's Rights. The third is the Charter of the United Nations. And I think the constitution of African countries actually they tend to define themselves as a foundation of a social consensus. According to my understanding on the classic liberalist constitutionalism, I studied the constitution for more than 2 decades. My understanding is for the classic liberalist constitution, there tend to be a very strict separation between the society and the state. And the constitution should not intervene into the social lives because the constitution should be a guarantee on the freedom of the social life. But I found no strict separation of the state and the society in the African constitution. Actually, 21 African constitutions explicitly declare the binding force even into the society. And the 14th African constitution, there is a detailed list on the duties, not just the rights, but duties of the citizens. It's quite interesting. So in my view, actually, the frameworks of the African constitution, they want to design a guidance book for the development of the country, not just like some protection of the civil or political rights. For example, 28 African constitutions, they include very clearly defined national development goals, and not to say detailed social, economic, and also cultural rights of the citizens. And then you might know now in Western society, Western countries, affirmative actions are quite controversial. During this presidential campaign of the United States now going, affirmative actions are very controversial. There is no controversy in the African constitutions. And at least the 20 African constitutions provide explicit mandate to the state to carry out affirmative action. So constitution, please use constitution to transform society, transformative constitutionalism. That is why originated from South Africa. So maybe in goals on the constitution, they are quite ambitious, but for the classic goal of the constitutionalism, democracy, with all due respect, according to my reading, I think democracy in African constitutions basically stays only in formality. The first evidence, according to my view, is the deep distrust in the local political culture. For example, 39 African constitutions define the formal colonial language to be official language. I know this is quite a controversial point, but my understanding is language is a very important symbol for a culture and the culture behind. So if there is a deep distrust in a certain language, actually there is deep distrust in the political culture behind this language. If always use the foreign language as not a local language as an official language, maybe there's some distrust. And there are even some restrictions based on the educational wealth background. And so far, I think that at least 22 African constitutions consist of the restriction of the right to vote based on the wealth and the educational background. I think this also might be another evidence of distrust of the freedom of the constitution. And the third, I think in a classical democratic constitution, the local autonomy should be seriously protected, guaranteed. But according to my reading of the African constitution, this aspect is seriously neglected by framers of African constitutions. So far, only 14 African constitutions explicitly handle the issue of allocation of legislative powers between the central and local government. And in these 14 African constitutions, only and the 3 constitutions allocate all residue power to the central and not to the local government. It seems to quite not quite friendly. So in comparison to these ambitious goals for the national development and the democracy, informality, I think the African constitution paid very much attention to the political stability. I assure you know this theory, this so-called self-defense democracy theory, which originated from Germany. And so far, at least 38 African constitutions contain provisions of this self-defense mechanism, such as prohibition of certain constitutional amendments and the ban on constitutional political parties and the resistance rights of the citizens. In addition to that, I think the presidential system is apparently favored by African constitutions. So far, 45 African countries are governed by president. And these presidents are constitutionally political strong men. They are strong men, they are not strong women. They are strong men. What is a strong man? They are very strong guys. Maybe a lot of children. And third, in addition to these strong men, constitutionally speaking, they are also very strong central government. I have already mentioned the neglect of the local autonomy, protection of local autonomy. In addition to that, 30 African constitutions authorize the central government the power to take over the control of local government when necessary. Why this is special to me? Because Chinese constitution, the central government is very powerful. But even in Chinese constitution, we don't mention the central government have the authority to intervene in local issues. There's no such mention. So for me, it's very interesting to find that third part. So the fourth, yes, this is me. I think 10 years ago, I first in South Africa. Much more here. It's not my younger brother, it was me. So facing this purpose in the constitutional design, the deep discussing qualities and now the political culture, the political stability. I think frameworks of the African Constitution paid much attention to its real binding force in the realities of African. So a very wide reach of the constitutional rule system has been established, and so far only 2 African countries, that is Libya and Rwanda, have developed constitutional rule system. And for these constitutional rule organs, their power are also very wide reached and allows of oversighting bodies on constitutional implementation, 24 African Constitution special oversight bodies on the constitutional implementation and education, such as human rights in South Africa. And on the moderators is very anxious. They are drawn quickly to that. Okay, my quick conclusion. I don't know why it is so sensitive. Why to jump to my conclusion? I'm not sensitive. I read it out. Yeah. The first one, I think, the African constitutions, in terms of formality, they are quite open-minded and internationally oriented, much better than the Chinese constitution. But for the truth behind this formally well enacted constitution, there is still very deep distrust in the qualities of the local political culture, and political practices. So facing the serious lack of the conducive supportive background conditions, or even the supportive support from the local population, I was a bit surprised that yesterday when I heard the Mr. Commissioner of the Human Rights Commission said, this Chapter 9 institution should be unpopular. So from my understanding, this means a lack of conducive cultural background. So the fulfillment of constitutionalist African continent might still have a very long way to go. Thank you so much for your time. Looking forward to responding.
Thank you so much for that rich walk through the many African constitutions. Our next speaker is online. Are you there, Professor Dr. Reina? Can you hear us?
Yes, can you hear me?
Okay, can you please start your presentation, and you have 10 minutes.
Thank you very much. Good morning to all of you. In their seminal article on transformative constitutionalism and constitutional rights education in Africa, Charles Fombart and Eric Kibet have argued that transformative constitutionalism is an ideal model to address past failures of constitutionalism and human rights abuses in post-colonial Africa, firmly anchor constitutionalism and respect for human rights in the region. In their rendering, while adhering to the central tenets of constitutionalism in the liberal sense, transformative constitutionalism moves beyond them to address prevailing social and political realities. In the South African case, this has meant the abolition of an oppressive legal, political, and economic regime known as apartheid, and its replacement by a democratic regime founded on freedom, multiculturalism, equality, equity, respect for human dignity, and human rights. Transformative constitutionalism also makes new and unprecedented demands on the courts. Combat and Kibet emphasize that judicialism is at the core of transformative constitutionalism, since the concept places faith in the law as an instrument of social and political change. And it is the court's mandate to say authoritatively what the law is. In order to be faithful to this mandate under a transformative constitution, the courts necessarily have to rethink and redefine their role so as to be able to give full effect to the transformative aspirations and goals of the Constitution. The traditional judicial approach to the interpretation and application of the law, such as legal formalism or legal positivism, will often be inadequate to meet the requirements of substantive justice at the heart of transformative constitutionalism. The realization of substantive justice requires a broader view of justice beyond the narrow negative rights conception traditionally associated with liberal constitutionalism. It implies the recognition of positive duties of the state to intervene actively in order to promote and secure the effective enjoyment of constitutional rights, as well as the horizontal applicability of the Constitution. As Fombart and Kibet also note, transformative constitutionalism has not escaped criticism. One major criticism is that transformative constitutionalism, while it is touted as post-liberal, actually sits quite comfortably within liberal constitutional discourses. In particular, it fails to place socio-economic justice, in the South African case, the elimination of the disastrous legacy of economic apartheid, at the center of constitutional discourses. If anything, this criticism has grown louder since the time Fombart and Kibet published their article in 2017. It is also a criticism which is of particular relevance to the theory and practice of transformative constitutionalism, not only in Africa, but in other countries of the global South as well. Now, I will try to give some responses to this criticism by taking into account comparative considerations. The first criticism is that transformative constitutionalism has not moved decisively beyond classic liberal constitutionalism. It is said by these critics that in contrast to its claims postulating structural change and reimagined egalitarian social and economic relations, transformative constitutionalism in practice has done little to take us beyond what might be termed enlightened liberal legalism. This criticism, in my view, is not really convincing. From the start, the South African Constitutional Court, under the 1996 Constitution, has looked for a broad post-liberal rights paradigm and found it in the concept of constitutional rights as objective order of values, a concept first developed in post-World War II German constitutional jurisprudence. In its decision in Karmikele, the South African court held, and I quote, "Our constitution is not merely a formal document regulating public power. It also embodies, like the German constitution, an objective normative value system. as was stated by the German Federal Constitutional Court, the jurisprudence of the Federal Constitutional Court is consistently to the effect that the basic right norms contain not only defensive subjective rights of the individual, but embody at the same time an objective value system which, as a fundamental constitutional value for all areas of the law, acts as a guiding principle and stimulus for the legislature, executive, and judiciary. And for the South African court to conclude, the same is true of our constitution. Now, this understanding of fundamental rights moves a decisive step beyond the classical liberal rights paradigm. Far from being mere defensive rights of the individual against the state, as they have traditionally been seen, constitutional rights and freedoms in transformative constitutionalism also have an important objective, institutional, and social dimension. In their multidimensional aspects, fundamental rights permeate all areas of the legal order, including those parts which deal with the relations between private parties. The impact or radiating effect of the constitutional rights may be felt more directly and intensely in legal relationships which directly involve public authorities, but no legal relationship or area of the law is per se free from the influence of the constitutionally protected fundamental rights and liberties. This dramatic reconceptualization of fundamental rights has allowed the German Constitutional Court to develop a highly expansive interpretation of fundamental rights on the basis of a constitutional Bill of Rights, which is quite conventional, conceived in the liberal tradition, protecting merely civil and political rights. There is only one exception, and the one decisive difference in the German case is that the whole human rights, fundamental rights jurisprudence of the German court is based on Article 1 of the Constitution, which proclaims the inviolability of human dignity. And it is this supreme value and overarching principle of the German Constitution, which all state authority has not only to respect, but to actively protect, which has allowed the German court to develop its interpretation and application of fundamental rights, which count among the most expensive and strongest in the world. At this point, an important clarification is in order. While transformative constitutionalism moves substantially beyond liberal constitutionalism, both concepts are not antagonistic, but complementary. Liberal constitutionalism is a vital component of transformative constitutionalism. Without a robust rule of law, that is a genuine respect for the independence of the courts and the autonomy of the law by the political branches, transformative constitutionalism will not flourish, but will quickly morph into something which we may call aspirational constitutionalism or symbolical constitutionalism. It is a system where the transformative concepts and mandates in the Constitution remain largely on paper, but fail to produce any significant change in the actual operation and application of the law. Where the liberal basis of constitutionalism, of which the rule of law is a key component, is weakened, this will also undermine the capacity of the law to act as an instrument of far-reaching social and political change. The second criticism of transformative constitutionalism, especially relevant in the South African context, is that it does not enough to put socio-economic justice at the center of constitutional discourses. This criticism also seems ill-conceived. As Gautam Bhatia has reminded us with regard to the Indian constitution, the transformative vision of the constitution has several components and distributes the responsibility for the implementation of these components among the various branches and institutions of government. This observation also applies to the South African constitution. With regard to the socio-economic transformation of the country as essential part of the transformative vision of the constitution, the main responsibility for putting this vision into practice must rest with the political branches. Only they dispose of the necessary financial resources and the legislative and regulatory powers to bring about large-scale socio-economic change. In a constitutional democracy based on the separation of powers, the role of the courts is necessarily much more limited. The South African Constitutional Court has acted in accordance with these principles in its case law concerning socio-economic rights, to the disappointed of many of the critics of transformative constitutionalism. The South African Court has defined its role with regard to the enforcement of these rights essentially as twofold: to urge the political branches to adopt the measures required to implement the rights protected by the Constitution, if they have not already done so, and once they have taken action, to check whether the measures adopted meet constitutional requirements, especially the standard of reasonableness. In applying the reasonableness standard, it has followed the idea that judicial review of government action to implement socio-economic rights should focus less on the substance of the decisions taken and more on the procedure in which they are reached, an approach which has been known as meaningful engagement doctrine. Under this standard, policies and measures to implement socio-economic rights have been found wanting if and to the extent that they failed to engage meaningfully with their intended beneficiaries. This restrained approach differs significantly from the more vigorous approach on the implementation of social and economic rights taken by the Indian Supreme Court in its more recent jurisprudence, notably through its public interest or social action litigation. This jurisprudence has been criticized, though, as disregarding the constitutional distinction in the Indian Constitution between fundamental rights and liberties in Part 3 of the Indian Constitution, which are enforced by the courts on the one hand, and the directive principles of state policy in Part 4 of the Constitution, which formulate the guiding principles of the profound socio-economic transformation envisaged by the framers of the Indian Constitution on the other hand. These directive principles include the equitable distribution of resources, the special attention to the vulnerable sectors of society, strong labor protections, and other socio-economic rights. However, the directive principles are framed as exhortations to the legislature, not as standards of judicial review. The Constitution saying explicitly that they shall not be enforceable by the courts. By disregarding this fundamental distinction, the Indian Supreme Court, in the eyes of its critics, has not implemented but upended the multi-layered transformative design of the Indian Constitution, involving in the process the courts in an active role in governance and taking both quasi-legislative and quasi-executive action. While the result may be called as a truly transformative jurisprudence on socio-economic matters, it is one which ignores the Indian Constitution's text, structure, drafting history, and underlying philosophy. The same criticism cannot be validly made with regard to the South African Constitutional Court's jurisprudence. Thank you very much for your attention.
So please stay online so that we can engage with you in terms of questions and comments. Our next speaker also online is Mr. Domo Christoph, and he's going to speak to us on national sovereign conferences and the concept of transformative constitutionalism in Francophone African countries. Can you hear me, Mr. Domo? Hello, Mr. Domo. Can you hear me?
Yes, good morning.
Good morning. Please proceed.
Yes, I can hear you. Good morning.
Yes, proceed, and you have 10 minutes. Thank you.
Okay.
Hello, you can proceed.
Yeah, thank you. Thank you. My topic, as you just mentioned, is on, we're going to discuss about sovereign national conferences and the onset of constitutionalism and party pluralism in French-speaking African countries. First of all, the problem statement. Throughout French-speaking African countries, they have been led by authoritarian regimes from the independence years through the early 90s. Also, the demise of the Soviet Union led to an upset of the liberal democracy in several African, Francophone African countries. And also major Western nations subordinated their economic aid to market economies and liberal democratic principles. As a result, Francophone African countries transformed constitutional and political reform through the organization of national sovereign conferences during those years. The purpose of my paper is to demonstrate that sovereign national conferences constituted a decisive turning point in Francophone Africans' constitutional democratic processes. And also the paper brings to the fore the interconnection between human rights, free and fair election, and liberal democracies. 3 research questions form the backbone of my paper. The first research question: did sovereign national conferences evolve as a new framework for regularizing democratic crisis in the African nation state? Second research questions: have national conferences contributed to the promotion of constitutionalism, democracy, and good governance? And the last questions: 3 decades down the road, what have been the challenges that prevented Francophone African countries from achieving a right-based constitutionalism and transformative political leadership? The methodology is mainly a descriptive analysis based on an extensive research in the form of interviews, press articles, autobiographies, reference documents, political party writing, constitutional court ruling. And 4 African countries were randomly selected for case study and analysis. These are Benin, Niger, Mali, and Zaire, now the Democratic Republic of the Congo. My lead argument: at least in theory, sovereign national conferences represent an African model to multi-party and constitutionalism and democratic theory. The comparative advantage of sovereign national conferences resides in the fact that they contributed to marking clear choices in favor of pluralist democracy. And finally, despite the accumulated gains and comparative advantages of sovereign national conferences, we can conclude that constitutionalism and the rule of law are not yet complete in French-speaking African countries. I'm going to structure I will first of all offer a literature review, then a comparative analysis of 4 selected countries, and I will end with some concluding thought and policy. As far as literature review is concerned, some authors discuss the sovereign national conference from the prism of the evolution of political reform movement. Some discuss the reconstruction of the neo-colonial state as a stepping stone to a successful transition to constitutionalism, democracy, accountability, and governance across sub-Saharan Africa. This is the case of John Mukum Baku. Africa's contribution to constitutional and democratization theories. The institutionalization of sovereign national conferences as a twofold transitional constitutional democracy model. Some scholars argue that sovereign national conferences were relevant indicators of political liberalization and open constitutional engineering dialogue. And so they were no more than an exportation and importation of political model to Africa. However, we notice that scholarship has covered core topics on the evolution and origin of political movement reform in Africa. However, there are still some gaps in that literature in the sense that they have not taken the prevalence of human rights abuses, electoral fraud, electoral violence, and the modification of the constitution by the executive branch of the state to remove presidential terms limit, military dictatorship across Francophone Africa. Then it's the purpose of this essay to fill that this gap by intertwining recent development in selected African countries with constitutional law standard setting. Then the second part, going to analyze 4 case studies of sovereign national conferences across Francophone Africa in the early 90s. The first case was Benin, where the conference lasted from February 19 to February 28. The event brought about political and constitutional gain. It repealed the constitution, established a democratic transition, convened a new constitutional parliament. There was the separation of power, freedom of the press, multi-party system, and other fundamental human rights guarantees. The Sovereign National Conference in Benin led to a power change in favor of a new head of state, and the previous one was overthrown. In the second country, in Niger, the conference lasted from July 29 through November 3rd, 1991. The delegate at the conference proclaimed its sovereignty, meaning that all decisions were binding, all decisions taken during the conference were binding against all stakeholders. The conference left the ruling head of state with mere honorary functions as a president. It suspended the constitution and the parliament. It organized presidential elections. In 1993, a new president, a new head of prime minister was elected. Overall, the National Conference in Niger defined the broad outline of the constitutional third republic, the electoral code, and the charter of political parties. In Mali, this is the third case study. The conference lasted from July 29 through August 12, 1992. A new transitional committee for the salvation of the state was set up to serve as the new parliament. The conference had the power to draft a new constitution, a new electoral code, and a new political party charters. Still in Mali, the country witnessed the return to military role with Lieutenant Colonel Amadou Toumani Touré, who was appointed to head the National Reconciliation Committee. The National Conference also laid the foundation of the democratic system through a party charter, electoral law, new constitutional engineering, and the overall of the institutional architecture of the state. The fourth and the last case study, that was in the Zaire, Democratic Republic of the Congo, where the conference lasted from January 14, 1990 through December 1992. It discussed all questions of national interest. It developed a draft constitution to be submitted for popular referendum. It determined the content of the electoral law, and the conference also crafted the electoral calendar. Still in the Democratic Republic of the Congo, the National Conference led new social political foundation and submitted 2 reports to Parliament, one on illegal enrichment and the second on political assassination. The conference marked the transition of DRC, the Republic, following the abolition of sin in the previous April. The sole article of the Fundamental Act that proclaimed the sovereignty of the National Conference on May provide that the National Conference is all decisions are binding in conclusion. The first point I would raise is that national in Francophone Africa mark a break with the past. The constitution that emerged therefrom led to new institutions, introduced multipartism, and guarantee new funding. Can be summarized as follows. The consecration of a constitutional democracy, the progressive constitutional election, and the putting aside of the new Francophone, to some extent, Western liberal democracy. The return of pluralism accompanied by the proclamation of rights and freedoms, the recognition of opposition, and the progressive construction of the rule of law across Africa. Thank you very much for your attention.
Thank you very much. Of course, in your conclusion, you were a bit stripping, so we didn't get that part of the presentation there. Our last presenter for this session is Dr. Kelly Catherine Lena. Can you hear me?
Yes, I can hear you loud and clear.
Thank you so much. You have 10 minutes.
Okay, thank you so much. And it's a pleasure to be part of this conference. I personally have never met Professor Fombat in person, but we've corresponded quite a bit over the years, especially since I became Professor of Justice and Rule of Law here at the Africa Center in Washington, D.C. So very appreciative of the body of work we've come together and the person we've come together to appreciate today. My presentation is about legislative oversight of the defense and security sector in Africa, and I'm looking in this paper at advances and limitations in the separation of powers in this domain. This area, the power of African legislatures to hold members of the executive branch accountable to citizens, remains an issue in scholarship and in the practitioner world that sparks a great deal of empirical debate and to generate new insights. Generally, there's a tendency in literature to depict many different African countries' parliaments as institutions that rubber stamp legislation, policies, or budgets that are then controlled by extremely powerful presidents in many cases. But there's a whole other part of the literature that, especially over the last several years, has made a mounting case that African parliaments are undergoing a significant awakening, and that their development of bureaucratic structure, of more technical capacity, can in fact generate long-term enhancements of how they contribute to democratic and civilian oversight of the executive branch. And that literature finds that this can be the case even when these initial institutional developments occur under authoritarianism or a hybrid regime, if not democracy. So ultimately, in terms of this part of the literature, as Charles Fombat has noted in some of his recent research, the ability of Parliament to hold government accountable is one of the most important means of preventing arbitrary government. And yet there is still a question, he says, as to, quote, whether the accountability mechanisms in the constitutions that African states revised or adopted in the 1990s and thereafter are sufficiently effective for checking the continent's unruly executives. So these observations have motivated quite a rich literature on executive-legislative relations in Africa and on the separation of powers in African constitutionalism in general. But less consistent attention has been paid to analyzing how those dynamics play out specifically through parliamentary oversight of the defense and security sector. And this, of course, is a particularly sensitive area of oversight as well. And so my paper, written with my co-author, Caroline Cosby, who's also from the Africa Center, describes some of the recent contours of legislative oversight of the defense and security sector in different African countries. And we've tried to look at a mix of countries with a different set of constitutional and political histories. Obviously, there's a lot of variation and uniquenesses there, country to country. And we've looked across countries with common law and civil law traditions because that affects the constitutional framework and the standing orders that the parliaments are operating under. Our analysis also follows the 3A's framework. This is not our framework. This is the framework of Adedeji Ibo and Boubacar Ndiaye, two scholars of security sector governance who have come up with it. But we like this framework a lot for analysis. It holds that the quality of parliamentary oversight of the defense and security sector is a function of 3A's. The first one being authority. So that's whether legislators have the legal mandate and sufficient standing orders to conduct oversight. The second A is ability, whether legislators have the financial, human, and technical resources to conduct oversight. And the third A is attitude. That's whether legislators have the political incentives as well as the wherewithal and motivation to conduct oversight. So we draw evidence from quite a few different literatures, comparative legal studies, of course, comparative politics, security studies, and the security sector governance practice area in the practitioner literature, which is quite prolific on this issue. We also draw from public-facing conclusions from some of the executive level seminars that my own institution, the Africa Center for Strategic Studies, has convened with senior leaders from 28 different African countries who come from their country's parliamentary defense committees or from their country's security sectors or civil society. So what do we find? In terms of the first A, the authority of legislators to conduct defense and security oversight, a couple of things. The legislators assigned to the defense and security related committees in their parliaments have the potential to play several really important roles. They're overseeing security budgets and spending. They are working on enhancing the security services, transparency and accountability. And they have the opportunity in a more vertical accountability fashion to conduct constituent outreach that would inform people-centered security policies. They'd be leveraging civil society expertise in this process. So as Charles Fombet has noted, legislatures are sort of a key institution to study because of them sitting at the nexus between horizontal and vertical accountability structures as well. We looked in terms of authorities, we did comparative analysis of publicly available constitutions and standing orders, and we started with just the ECOWAS member states. We plan to expand the analysis as we further flesh out the paper. But we wanted to pick a discrete set of countries with variations among them to explore the bounds of the generalizability of that analysis. We then also examined a few other countries from outside of ECOWAS to start with. So we looked at Botswana, DRC, Kenya, Namibia, Somalia, Tanzania, and South Africa. And one of our findings is that the authority of African legislatures to do this defense and security oversight derives from a mix of explicit and implicit prerogatives. And that applies even within the Anglophone or the Francophone and Lusophone legal traditions that certain countries share. So there's no single pattern within those language groups or countries with similar legal traditions either. Every ECOWAS member state parliament has the power to declare war. That's elaborated explicitly in each respective constitution. Similarly, every parliament has the power to approve the budget, with the Gambia, Ghana, Liberia, and Sierra Leone granted the additional power of approving foreign loans. And every current ECOWAS member state but Cote d'Ivoire has provisions in their constitution to approve appointments. Every parliament also has the power to call on members of the government to give testimony. This power extends to calling ministers in every country. And in some countries, this power extends all the way to the president. And then it depends on which country you're looking at, but the types of questions and the procedures for asking them also vary quite a bit. Despite all constitutions establishing the parliamentary power to declare war, only Liberia's constitution within the current ECOWAS states explicitly mentions the parliament's authority to oversee the defense and security sectors. In every other constitution, oversight of the defense and security sector is more implicitly included in the generalized powers of investigation and powers of the purse that Parliament is assigned. Another country outside of our ECOWAS sample that's very explicit about Parliament's power to legislate on the armed forces and the police is the DRC. So we see similar variation outside of ECOWAS and in other parts of Africa. In terms of the other two A's, ability and attitude, challenges to oversight often arise from the ways that ability and attitude interact with authority. So one common challenge to legislative oversight is that the parliamentarians on defense and security committees rarely have the specialized expertise that they need to effectively examine the defense and security budget and assess key aspects of the country's defense and security policies. Under such conditions of not having a great deal of working knowledge about the security sector structure or how it works, the standard legally mandated oversight techniques, things like holding open or closed hearings, pursuing commissions of inquiry, or even just posing oral and written questions to the ministerial authorities for defense and security can be challenging. As a result, there can be a tendency for parliaments to shy away from exercising their constitutionally mandated oversight roles. But we've seen some responses to this. There's been an increase in the amount of time that legislators serve on the committee. In Malawi, for example, that's been changed from them serving for a year, and that's been extended to 2.5 so that there's more time to deal with the learning curve. So that's one way that's been dealt with. Other ways that this has been dealt with in terms of knowledge transfer in Niger, in South Africa, in some other countries, the defense and security related committees write legacy reports so that new members of the committee that they're passing the baton on to have some sort of technical knowledge coming in that helps them get a leg up from the beginning. There's been more turning to civil society for further capacity building, not just with members of parliament, but also with staff who are a significant source of institutional memory and technical know-how in many African legislatures, because their tenure often is longer than that of the members of parliament themselves who are on the committee. So that's one challenge where the 3 A's come together. Another one that we highlight in the paper is the culture of secrecy around defense and security in many African countries. And this can hinder information sharing between defense and security services and the parliamentarians who are charged with passing and monitoring the implementation of the defense and security budget. There can be, as is the case in many parts of the world, a tendency to overclassify relevant information, a tendency for the defense and security services to refrain from providing information that's unclassified that is nevertheless considered politically sensitive. And these factors are also compounded by the political reticence that legislators may have within a historical context of defense secrecy to exercise what are their explicit authorities. So if you look at Senegal, for example, one of the continent's more resilient democracies, they never had a legislative debate on the budget for the Ministry of the Armed Forces until very recently, until 2022. Again, a couple of things that you've seen African leaders considering in this challenging context. The Chwane principles on national security and the right to information are obviously a set of standards that help foster these kinds of conversations in particular contexts. You have seen different countries taking a look or re-looking at how their official secrets acts sit or don't sit well in relation to right to information laws that 28 different African countries have now passed to smooth some of this information sharing when it's relevant and constitutional. Setting up closed sessions when sensitive information needs to be transmitted to specific committees or actors in the parliament. And the security sectors in many countries have started giving regular briefings to defense committees about key issues to enhance understanding and to play a role in breaking down barriers in the culture of secrecy. There have also been discussions in different countries about establishing tiered categories for the kinds of budget disaggregation that might be needed in order to convey certain kinds of information, but to restrict access to other forms of disaggregated budgetary information that could be classified or sensitive. So I'm running out of time. Where are the tractable ways forward with these challenges? My co-author and I provide 2 suggestions about this. One way forward is enhancing executive legislative engagement to foster a shared culture of professionalism in security sector governance. This could involve professional military education institutions and parliamentary training institutes, as well as individuals in military and civilian professions to be invested in this. PME, professional military education institutions in Africa, have not traditionally included modules explicitly about security sector governance in their curricula, but this is beginning to change. We know the Malawi Defense College is set to include a security sector governance and rule of law course in its offerings. Nigeria's National Defense College has a module in its Department of Governance and Public Policy that looks at military expenditure and the practice of regulating that. And in Congo, DRC, the Collège des Hautes Études de Stratégie et de Défense has offered training slots to civilians, including parliamentarians on the Defense Committee in their special session that mixes military and civilian officials. Parliamentary training institutes and defense think tanks in Africa can have catalytic roles to play as well. One defense think tank example comes from Senegal, where their Centre des Hautes Études de Défense et de Sécurité holds programs that are dedicated to deputies in the National Assembly, training modules, opportunities for civ-mil dialogue, and site visits have been facilitated through programs like that. Another way forward with the challenges that go with legislative oversight of defense and security.
Wrap up.
Yes, absolutely. Is improving information sharing and communication between defense and security sector leaders and oversight actors. I think we talk about how South Africa has made some contributions in that arena, as well as the Gambia in its transition after 2017. But to conclude, as the moderator has asked, parliamentary oversight is a core tool for holding defense and security officials accountable to the people on the scope and the limits of their mandate. Legislatures are at the nexus of horizontal and vertical accountability, as Charles Fombad has pointed out. And so they play a really critical role as a societal interlocutor in realizing the social contract. Frequently, however, neither the parliamentarians on their country's defense committees nor the defense and security officials who are supposed to engage with the legislature are quite as networked or as extensively informed about each other's roles and responsibilities as they could be. There are points of natural tension, but there are also areas of complementarity in their work. And so this is a really rich area to continue both research and practice. Thank you very much for listening.
Very much. There we have it. We have had our 4 presentations. Now it's time for us to ask questions and make our comments. We have about between 5 and 10 minutes of that purpose. Do we have any questions or comments? Okay, we have one here, one. Only one for a start. Are you hearing us? Thank you. 1, 2. So we start here and then finish over there. Now let's try. This doesn't appear to me. Just use this.
Thanks. My name is Tony Booker. I have 2 questions for Prof. The first one is about the judgment from the European Court of Justice in this month, which became EU Moroccan trade deal invalid because it violated the rights of self-determination of the people of Western Sahara. So I wanted to ask you what you think the impact of that judgment will be on the adjudication of rights in Europe. And then the second question related to your response to the criticism that transformative constitutionalism is doing enough to put socio-economic justice at the center of constitutional discourse. Yes, and constitutionalism isn't all of government responsibility, but there are ways in which the judiciary puts legal impediments to moving the needle on addressing past injustices. I think specifically of the land reform issue, and there are about 4 or 5 specific decision-making biases that we've already observed within the judiciary in South Africa that actually has precluded us moving forward dynamically. So I do think that we do need to look at whether the judiciary is doing enough and not just look at the executive or the legislature and what they're doing and the lack of resources or whatever their challenges might be. Thanks.
My question goes to Dr. Lina. I would be curious to hear in your research, did you observe or can you observe any differences when it comes to historical legacies? Because many of these countries that you look at have a military past, and some of these constitutions are also a legacy to some extent of the military past. And I found it quite interesting when you mentioned Liberia, because Liberia has a military past, but its constitution is actually before that time, from the 80s. And if I remember correctly, you said it's quite progressive to some extent, or at least more positively evaluated than others. So that would be quite interesting to hear to what extent is that an impact until today. What you observe, especially in the ECOWAS region, but maybe also in countries that don't have that military past, like Senegal, or I think you also mentioned Botswana. Thank you.
We have any more questions? Okay, we'll start with Dr. Reina for the first 2 questions, and then Dr. Lina.
I'm sorry, but I did not understand the question well. I don't even have a clear idea whether it was to which part of my presentation it was directed.
To ask the question again, maybe so that hear it properly.
Okay. I was trying to make my question short, and I think I might have made it unclear in doing that. When you were talking about the criticism that constitutional transformative constitutionalism doesn't do enough to put social economic justice at the center of constitutional discourse, the first part of your response to that dealt with the fact that constitutionalism is an all of government responsibility. But I feel that it's not enough to say that other parts of government need to do more. I have a practical example, for example, in terms of our course jurisprudence on land reform, where there are about 4 different decisions or approaches that they've taken that have actually constrained our ability to deal with land reform. So, for example, adopting a narrow definition of the word community, or penal restoration as an entry point to debate and feasibility and debate on restitution, using market value as a starting point of the assessment of compensation, finding that most people that have been possessed were in fact labor tenants, which just agents and claiming fully fledged ownership rights, and then adopting an approach to land which is common law centric. All of those represent legal impediments that have been put up by the judiciary. This is not the responsibility of the executive, and that doesn't mean that other parts of government don't need responsibility, but I think the judiciary also needs to take more responsibility in terms of what they can do to move the needle of socioeconomic justice. Thanks.
Professor, you got the question?
It doesn't work very well acoustically, so I have not a clear idea what the question is about. If I got some elements correctly, it's about the role of transformative constitutionalism and especially the courts with regard to economic justice. Is that correct?
Yes, yeah, go ahead, that's correct.
And I think there are different models, and the important thing to bear in mind is that a transformative constitution needs a strong judiciary in order to implement the transformative mandates of the constitution, because the defining characteristic, or the most important defining characteristic of transformative constitutionalism is that it places a lot of faith, a lot of trust in the transformative role of the law. That is the capability of the law to bring about far-reaching social and political change. However, this does not mean that the role of the judge, and in particular the role of the constitutional judge, has no limits. So there are different parts, elements, components of the transformative agenda. And while the courts certainly have to play a major role, or even a central role, in upholding or in enforcing those elements which deal with the legacy of political apartheid, that is to say, allowing for the full exercise of political and civil rights by all South Africans. Its role is more limited with regard to the socio-economic part of the transformative agenda of the South African Constitution. Simply because the courts, by their institutional structure and by the powers they've given by the Constitution, do not have the possibility to bring about the broad-based socio-economic change which is needed to root out the legacy of economic apartheid. So they can guide, they can frame this process, but the main task has to be achieved by the political branches. And the courts have only very limited powers if the political branches prove to be unwilling or unable to live up to that very important and cumbersome mandate of bringing about socio-economic transformation. Then they have very limited means to force them to do that. I can put it more succinctly. Transformative constitutionalism and transformative constitutional jurisprudence cannot be a substitute for dysfunctional democratic politics. No, there can be no government of the judges which makes up for all the failures of the political branches. So that will not work. If you point or you refer to the Indian experience, where the Indian Supreme Court has taken on a very broad role with regard to the enforcement of the socio-economic transformative agenda in the Indian Constitution, then I think the Indian critics of that jurisprudence of the Indian Supreme Court are right, that it has done so in contravention or in violation of the Constitution, which provides for a different separation of tasks. The courts being the guardian, the enforcers of the civil and political fundamental rights, which in the Indian case are as important a step to overcome the legacy of colonialism as is the socio-economic transformative agenda, because under British colonial rules, the Indians had only a small part of the Indian population had very limited political and civil rights. And the Indian Constitution has been transformative in the political sphere as well. It has given the right to vote to millions, to hundreds of millions of Indians, people which previously never had that right, and which in addition were often very poor and often could not read or and write. So it was an exceptionally bold step by the Indian Constitution in 1950 to give the right to vote to these people. There is no equally bold political reform or revolution in the constitutional history of any other country of the world. So that was an important part of the transformative agenda as well. And it is, of course, the primary role of the courts to see to it that these political and civil rights are fully enforced. However, with regard to socio-economic transformation, the Indian Constitution is equally clear that this is primarily the task of the government and the legislature, which has to adopt the laws and regulations needed to bring about large-scale socio-economic change. And by undermining or by blurring this distinction, the Indian Supreme Court has arrogated to its powers, which, according to the intentions of the framers of the Indian Constitution, it should not have, which makes the whole thing much more unstable. I mean, the Indian Supreme Court has been able to exercise these powers in public interest litigation to a large degree and extent during the time when following the end of the emergency and the loss of the absolute majority of the Congress Party and the first time election of an opposition government, the Bharatiya Janata Party, which came to power for the first time in the 1977 elections, when the governments were comparatively weak and were prepared to accept such a powerful role of the Indian Supreme Court in the social and economic policies of the government. However, when Narendra Modi came to power with the BJP, a much more energetic government and much less willing to tolerate a powerful role of the Indian Supreme Court, the Indian Supreme Court has been much more subdued, has been narrowed, and I think this is not, and this great instability in the way the Indian Supreme Court conceives its transformative role is not good for transformative constitutionalism. For transformative constitutionalism, the role of the courts should be a long-term one, that is ensuring that the central mandates and parameters of the Constitution are upheld and honored continuously, whereas the role of the political branches is much more short-term. It must react to political crisis, it must react to the lack of resources, it must react to economic recessions and so on, which may limit the resources available for spending on social purposes. And I think that, yes, in the long term, the Indian Supreme Court, by arrogating to it these large powers in the field of socio-economic reform, has perhaps rather undermined transformative constitutionalism than really helped to secure it firmly in Indian constitutional law.
Thank you very much. Dr. Kelly, you can take up the question.
Sure. Thank you for the question. It's a really thoughtful one to which I don't have an immediate answer, but it sounds like a good paper to write. And I think there are a couple of things that I think would be interesting to look at in relation to what you're pointing out about Liberia and the specificity of the Constitution and the standing orders there and Liberia's own political history. It's interesting that another place where you see really specific language that's more explicit is the DRC in relation to the comment that you're making. So that's an interesting set of observations. I don't know if a correlation that's more systematic than that bears out in the data, but I would want to look at what we looked at was a combination of how explicit the Constitution was and how explicit the standing orders for the Parliament were. So I don't know in the Liberian case off the top of my head how much of that comes from the constitutional mandate and how much of that comes from the standing orders. But it's a very interesting question as to whether there are specific systematic patterns in terms of amount of explicit power that's granted based on a country's history. I think the other question is, you know, in Charles Fombad's own work, he talks in different parts of it about, you know, is how much explicit power versus implicit is necessary in order to engage in the kind of governance that we want for ourselves as citizens and in different dispensations. And I think another really interesting part of, I guess, that paper that could be written would be, do you get better quality oversight as a result of having more explicit powers, or is it more about politically the ability to exercise and interpret what isn't said explicitly in a way that's workable in your context? And to that, I think that there is definitely from different case studies you see in the security sector governance literature, from our own you know, academic research on this across those different areas, issue areas where it comes up, whether it's legal constitutional work or political science work on this, you see that it's an art and not just a science in many cases. So really thoughtful question. I wish I had a more systematic answer, but that just shows there's more research to be done in this rich area. Thank you.
Thank you so much. A round of applause for our. That's the end of session 5. I think after 2 sessions in the morning, we have ended our tea. So what time should we be back? 15 minutes. If we could be back by 11:30, please. Thank you.
But yeah, I just want to hear you. But you said I've gone to, when did you go to Angola?
Yes. I wanted to take a photograph of you and my kids, but you disappeared. I didn't disappear. But you left. I mean, come take the photograph. You just stand here. Yes. Where? This other one here, you two can go there. Show me. No, let us put them two of them. But I told it so. But if you take it here now, why do you? Oh, you want this here? Okay, let's take here. Then you take there also. Give me one. When no first finish. Oh, I want to take you first, then I will join. No, we are waiting first. See you. But it's wonderful what you no, unfortunately. I think. Okay, I see if I can get it on my. Yeah, I see. Wait. Come closer. Are you sure? My system. You took it?
Yeah, I also need another one.
Let's take one here. We'll stand here. He was capturing
okay, one
no, it's PowerPoint.
Yes, well, wow.
Send me the picture.
Okay.
Can you send me later the picture?
Yes, I will send you the pictures. He wants you. When you remove your spectacles, you change your face. Yeah, I know you with your spectacles. Yeah.
Is that my glasses advice? Yes.
Something happening there. Are you quite honest? Thank you. Are you done? Oh, you will.
It's gone already. We'll restart again. Okay. He came from far from Zimbabwe. Yes, please.
This one is so nice to know. If I knew you were coming here, I would have said, can you bring me wine? One or two in the phone. Now we are going to give you that.
How is it? No. I want to grant.
Wonderful.
Send me the email.
Yes. Okay, on this one, change my.
Yeah.
I'll do that. Yes, I
You
can.
Where did you pick it? No, when you were speaking, I came down here. I was even standing here and I was like, I didn't notice. I came here. I was standing here every time. So I was so focused. Really? Really? No. I was close, man. I was close. You see, I started far. This was, I think, where I was sitting. You see? And then I came down. You see? You see how close I was? You see how close I was? I was just behind there. It's a woman. Okay, that's great. Take some fruit. You take some fruit. Keep reading. You did? Yeah, just give it for some. Thank you. Okay. Oh, you sent to me. The picture. I was about to say. I didn't notice you. Really? And I cannot think. That's great. Yesterday I sent it to you. No, that's the Wi-Fi. Atlas. But you use me to connect. I put your finger like this for 5 seconds. And then where's your
Thank you. Good. So, change developments for the change. I don't understand. Yeah.
Yes, I already set up my, yeah, the second one.
How do you pronounce your last name?
Soccer. I'm a teacher.
Oh, that's good.
Yeah, I know. I'm
They're hiding at the corner.
Yeah, I'm the sitting performance office in the corner of the first floor.
Okay. And then who's this?
This is another form of postdoc performer.
Okay.
But I'm gonna say a little bit about it. Everyone is sharing personal stories.
Okay. Who's speaking first?
It's only me. Only me speaking. This is only one man.
So he's not presenting?
Not presenting, but you call them.
Okay, so you mentioned him.
Yeah.
So,
So about me, you can only say if you want to introduce me, say I'm a postdoc.
I wanted to say
Yeah. No, I moved to Nigeria 4 years ago.
when did you? No, my only favorite is Anglophone citizen Africa. Number one Cape Cairo, two Accra, 3 Abuja. And then Frankfurt, number one to these 5 cities. If I were to South Africa, these are 5 cities.
Are you listening to Victoria?
I'm from Rasta.
I know, I've heard of this, so I know it's a bit of a
Yeah.
Really? I mean, Abuja, I also like came home after 3 years. I mean, I can see then. True. I also think it's interesting because it's very it's like kind of organized.
It's clean, relatively, in comparison to Lagos.
Exactly. For everyday life, I like it.
I could definitely.
I mean, it's not the most exciting.
Yes, but what do you do?
I mean, I worked with you for some time, but initially I just
Okay.
That's how I started to
And your wife is still in Abuja?
and
Okay.
so that's me also by the internet because I'm okay, I'm trying to be with the streets and
I was actually good enough. I think it's
yeah, I mean,
time.
Nigerians of that relations.
It's very awkward.
There's a story about it.
Very awkward. And every year is a lot of time.
I don't know what the one behind you are.
I introduced myself.
Oh, you did, yeah.
Yeah, curious. Yeah, said because it's quite small.
Yeah. I may just go here to do that. If there are no questions. I don't know, because I'm curious. I mean, I see what so it's curious. Yeah. You know what, I actually want to
I just have where is the senior?
Morning, everyone. Good morning, everyone. My name is Bonolo Makale, and I am the Program Manager of Democracy and Civic Engagement Unit of the Center for Human Rights. So this session, we will look at constitutionalism in the context of coup, conflict, and fragility. So we have about 5 speakers here with us, and I'm going to give each of them about 10 minutes, and then I'll open up the space to ask questions. But I do want to say that in this conversation about coups, conflicts, and fragility in Africa, Africa has actually in recent times topped the coup chart globally, trailed by Latin America. I was looking at the report by APRM, the third governance report by APRM that was released in July 2023, which specifically focused on unconstitutional change of government, and it documents about 18 incidents of unconstitutional change of government between 2003 and 2022. Of course, there have been some developments in West Africa after this report was published. And of course, on the issue of conflict and fragility in Africa, I think we can all agree that conflict has experienced, Africa has experienced and continues to experience several deadly conflicts. And again, the nature of conflicts as we see them on the continent, there seems to be a shift, from traditional conflicts like conflicts and interstate and interstate conflicts to very complex security challenges like, violent extremism, electoral violence, terrorism. And so in recent times, we're really seeing a very concerning state of peace and security in Africa. So we have experts here with us that are going to look at these different themes. We've got Dr. Johannes Sohan, who is a postdoc fellow at ICLA. He's going to look at constitutional courts and military rule in Francophone Africa. And then we've got Ms. Barbara Nyasha Sambo from the Department of Jurisprudence at the University of Pretoria. She's going to look at unconstitutional changes of government in Africa. And then we've got Shorai, I pronounced your name correctly, right? From Zimbabwe's Lekki University. He's going to look at lessons from the 2017 Zimbabwe constitutional crisis. Then we're going to have Dr. Ibrahim from the University of the Western Cape, who's going to look at constitutionalism in fragile countries, reflecting on Somalia. And last but not least, we've got Dr. Cristiano, the friend of the center from the University of Johannesburg, who's going to look at the tendency of undermining democracy in Africa through constitutional change. So I'm actually going to start, if you'll allow me. I want to start with Barbara. Is that okay, Barbara? Yes, you go for it.
Good morning, colleagues. Like I said, my name is Barbara Sambo, and I am affiliated with the Department of Jurisprudence at the University of Victoria, also an alumni of the Center for Human Rights. I am honored to be here. Thank you so much, Professor Forward, for paving the way for especially us young scholars and emerging scholars. The first time I actually communicated Prof. Forward is I was begging him for assistance with my dissertation in my fourth year, where I was looking at constitutionalism in Zimbabwe. And he responded and was talking about that the constitution in Zimbabwe is also recognized as one of the best, but cannot actually have the full implementation cannot come into place unless Mugabe is also in power. And here we are, 2024.
My title is Unconstitutional Changes of Government in Africa, Challenges to the Sovereignty Power of the African Union. So I'll just really go into what I will be looking at and just a synopsis of my research. So according to Prof. Fakwe, the African Union is an organization that is charged with the responsibility of taking Africa to its promised land. And this statement is understood to mean that the African Union is viewed to be an organization that has the mandate and the responsibility of ensuring the achievement of democracy, development, and also where Africa is free from repression and authoritarianism. So unconstitutional changes of government in Africa are seen as an impediment to the achievement of this democracy, good governance, peace, and security in Africa. The African Union has also implemented a zero-tolerance policy towards unconstitutional changes in government and makes use of sanctions as a tool. Despite its expansive AU normative frameworks and intervention approaches, African member states continue to experience coups and conflict. So this paper unpacks the responsibility that the AU has been given to take Africa to its promised land. The power of the AU will be examined as to why its approaches to conflict in the continent is not yielding much peace, security, and unity, as the organization has been seen to have challenges to its sovereign power and supranational powers, resulting in African leaders not giving the organization much respect as being the vehicle of taking Africa to its promised land. So the AU has principles that are in place to overcome this social and political unrest and conflicts, as well as underdevelopment in Africa. And this paper just examines the concept of UCGs, a critical analysis of the AU and the response of the AU to the UCGs, challenges the sovereignty of the AU, and also will give recommendations in this sense as well. I will not really get deep into the concept of unconstitutional changes in government, but I will put out that forward that one of the consistent features of politics in Africa since the collapse of the colonial system is the rarity of constitutional change of governments. And we see different frameworks as well with the AU, the Constitution Act of the African Union. We see the Rome Declaration was adopted in which they condemned this coup d'etat and UCGs, and the African Charter of Democracy, Election and Governance is another primary instrument or framework that is adopted to actually address these UCGs as it promotes the holding of free and fair elections to institutionalize legitimate authority of representative government as well as democratic change. As we see, the UCGs take the form of these military coups against a democratically elected government, the intervention of mercenaries, the replacement of democratically elected governments by rebel movements as well. And we see that in the removal of an incumbent government to relinquish power to the winning political party after the free and fair elections. And so we really see that they involve the use of military force to gain or retain power unconstitutionally. So I will just mention just a few of these, how they form. This is also according to Prof. Fomba's article with Abebe, in terms of just a listing of it. And we see from this map as well the unconstitutional changes of government that have occurred even just between 2022 and 2023. And these take the form of an unconstitutional removal of a democratically elected government. And this takes the shape of coups, rebel takeovers, and intervention of mercenaries, like I say. And Prof. Fomba provides two determinants that show whether an unconstitutional government removal has occurred, and this is whether the coup or rebel mercenary takeover has occurred, and whether the government was removed as it was a democratically elected government. And then we also look at unconstitutional retention of power. And Prof. Fomba states that this takes the form of an incumbent government refusing to relinquish its power after losing in a free and fair and regular elections. And secondly, where there is a continuation of governmental power through the adoption of constitutional changes that constitute an infringement on the principles of democracy and democratic change of government. And we saw that even in Zimbabwe in 2008 as well, and this is just a case that I will also be looking at in terms of that as well. It brings up the challenge of the AU in not ensuring that the AU electoral observers are actually designed with the full intention of the UCGs in mind. And so it also brings up the capacity and also a challenge of credibility in that sense. And it was seen in Mugabe actually still continually retaining power. And just really to move, it may seem that I'm not catching my breath, but I have 10 minutes, so I have to move forward. Really to just also look at the African Union and its response to the unconstitutional changes in government. The formation of the OAU, later AU, came as a form of creating an organization that prioritizes African unity, and also came as a result of the quest to create a collective anti-colonial struggle in Africa. This led to the formation of the OAU in 1963, where the African leaders resolved that they need to take action in terms of this as well. Performed asserts that the OAU was founded on the colonial experience in which Africans were denied control of their social, political, and economic destinies, and the OAU has objective to free African states from the bondage of colonialism. Mulamu has asserted that the prevalence of conflicts in Africa ought to be understood against the background of Africa's colonial past, and says in this regard that any understanding of how Africa has become so fragile needs to be considered to consider the role played by colonialism. Africa has never recovered from colonialism, let alone shaken off its shackles. Rather, the continent inherited political governance systems in their holistic perspective. And Ibrahim also states that the transformation of the OAU that was considered a toothless bulldog that lacks the capacity to catapult the continent to greatness to form the more capable African Union, fashioned in line with the European Union, was expected to institutionalize systemic reforms that will enable giant strides to be achieved. Yet the outcome leaves much to be desired, and this paper looks at that which is left much to be desired in terms of that. And really this paper causes us to examine whether the AU's quest for a peaceful and secure Africa is a pipe dream following the extension of silencing of guns in Africa from 2020 to actually 2030. And some of the challenges also seen in the consistency. And it's really said that AU's criticized in terms of just having inconsistency in terms of just how it has been soft and pragmatic in its approach to UCGs in certain states. And this is seen in the case of Zimbabwe, where the AU categorized the situation in Zimbabwe in 2017 as a political development and not a coup. And the Ninevi states that the tacit avoidance probably represented a Mugabe fatigue and a forward-looking approach where a smooth transition could reverse crippling international sanctions on the country. And it's also seen in the soft approach that it is used in other countries as well. And then it has inconsistency in terms of how soft and in the others it's actually not as soft in terms of that. And so Forward brings up the issue of consistency and says once sanctions have been imposed, the authority to follow up whether a return to constitutional order has occurred appears to belong to the chairperson of the AU Commission. In contrast, under acting, the power to determine whether the situation that led to suspension and sanctions belongs to the PSC. And Performance suggests that in order to ensure consistency, the issues of whether UCG has occurred, the return to order and decisions concerning suspension and sanctions should all be streamlined. And we also see the issue of accountability. Ebroka brings an argument forward that a framework will not be effective if it does not challenge the legitimacy of incumbent leaders and does not question their ascension to power, and instead condones their stay to power. In this power, this defeats the purpose of democratic governments in terms of that. So there's a strong call for the AU to challenge the leaders that have come into power, especially before the framework and also through unconstitutional means, and that the AU is actually not strongly challenging these leaders and has been viewed to actually be rewarding this incumbent leaders. A challenge is also seen with the PSC and its architecture, and here the PSC has a mandate of imposing sanctions on perpetrators of UCGs, including sanctions where incumbents are the perpetrators. The challenges have been noted in situations where leaders that hold onto power unconstitutionally are made judge over their own cases. And the objectivity of the PSC in imposing sanctions is questionable probably explaining why some rebel movements ignore its decisions in terms of that. So we really need to also question the use of sanctions. Is there a transformation in the sanction system or the sanction architecture that's being used by the AU in terms of that? Because sanctions are colonial in nature, and when you're imposing them, are you actually using follow-up mechanisms to actually show that the populace is not affected, but the sanctions are doing what it needs to do by removing these leaders out of power? So I really won't get into much about the challenges because I'm almost out of time, but just really looking at the challenges of monitoring and enforcement mechanism, institutional challenges also actually affect the sovereignty power of the AU and just unity among the Africans and the African leaders as well. Impedes the success of this principle of African solutions to African problems. And so here the lack of firmness and consistency as well has undermined the AU's legitimacy in that sense as well. And when I look at the institutional challenges, I also just look at how it faces the challenge of institutional capacity, looking at the elements of supranationalism within the AU, that they actually seem and argue to be non-existent in terms of that as well. And while the AU is not given much respect and listened to by the African leaders in terms of that, and just really looking at external influence and intervention as well as political will from the leaders. Just in closing, recommendations. So just really looking at, so can the African Union take its people to the promised land, and what does this promised land look like? Is the AU actually enforcing the mechanisms to actually take Africa to its promised land with its peace and security? And really there is just a strengthening of AU mechanisms for early warning signs and prevention, and not just really being reactive, but to actually see the early warning signs. Promote good governance and democratic institutions, strengthen regional collaborations, especially with the REX as well. Just really looking at the promotion of transitional justice mechanisms and reforming the AU peace and security mechanisms in terms of that as well, to just really ensure that there is peace and security. So in conclusion, unconstitutional changes of government erode the foundational principles and credibility of the AU, posing a direct threat to its sovereignty and its ability to act as a unifying force for peace and security and development in Africa. So really the AU has enacted also impressive normative frameworks, but it just really comes to the implementation of this and even the supranational power of the AU in terms of just really navigating what it needs to do in the continent. Thank you.
I hope you can hear me well. Good morning, everyone. It's an honor and privilege to talk to you today on this occasion, to be part of this panel. As I've already been introduced, I'm a postdoc at ICLA, collaborating with Prof. Fombat on different projects. Our main project, as some of you know, is on political parties, but today I will talk about, obviously, something completely different. Or maybe not so much if you look at the history, and you will see why I say this later on during the presentation. So this is a collaboration between another former postdoc, Dr. Samson Tabire, who is in Burkina Faso, back in Burkina Faso, and he's, I think, also online with us. At least he wanted to join, so maybe he can also respond during the Q&A after our presentation. So I'm going to talk about, on our behalf, about our project for this paper on constitutional courts and military rule in Francophone Africa, focusing on the cases of Burkina Faso, Guinea, and Mali. So the idea for this project actually is connected to my previous engagement before coming to ICLA. I was a consultant for the German government and giving advice and constitutional assistance. One of the projects was of the Max Planck Foundation supporting the Constitutional Court of Mali. during or up until 2022. Whereas Samson, at the same time, wrote a blog post later on, but already then started to work on the role of the Constitutional Court in Burkina Faso. And later on, a coup happened there as well. So we got to know each other at ICLA, and eventually this is what came out. And the key question basically is, what is the role of constitutional courts during military regimes? Because unlike the legislature or the executive is often not replaced by military institutions, but it continues to operate. Not always, but often. So in our case here, in Guinea, it was suspended, and the mandate of constitutional review was taken over by the Supreme Court. Whereas in Mali and in Burkina Faso, it continues to operate. So this is like the key question. How has it affected the courts themselves, but also what is the role and how have they been complicit in a way to the military regime while the military is ruling these countries? So basically the paper is going to consist of these three main parts, basically giving an overview of the role of constitutional courts before military coups in these countries, so according to the constitution. Then also looking at their role right before the coup happened. Then how did they maybe contribute in legitimizing military rule afterwards? Then what is their role during this so-called transitional periods? And as a conclusion, or basically a legacy question, what is the lasting impact, or what will be the lasting impact of these military regimes on the constitutional order more broadly, but here, of course, particularly also with a focus on the constitutional courts. So how has their mandate maybe already been changed or will be changed in the future? So, yeah, as many of you will know, in most Francophone African countries have separate constitutional courts with dedicated mandates for constitutional review, but also regularly to oversee elections. And in all these three countries, after the military took over, transitional charters have been enacted, sometimes to replace the constitution completely, or to change it substantially, but not suspending it entirely. And that had also an effect on the constitutional courts themselves. So in the case of Mali, the constitutional court is kept in place, and it even received an additional mandate, at least in theory, to interpret any conflict that might arise between the transitional charter and the constitution. In Guinea, as I said already, the constitutional court has been suspended completely, but the mandate of constitutional review has been shifted to the Supreme Court. In Burkina Faso, the Constitutional Council was initially briefly suspended after the first coup in the beginning of 2021, but then rehabilitated together with the constitution. And that happened for a second time in a very similar way in the second coup at the end of 2021. So you see already some differences, but also some similarities. So what happened right before? Basically, the question is here, to what extent did they contribute maybe also to constitutional instability? So in Mali, the court approved the constitutionality of the 2020 elections, which was quite controversial in the way they did it. The legal interpretation was a bit unclear, because what happened was parliamentary elections, and 20 seats were assigned to then President Keita or his party, basically securing him a majority in parliament. And that contributed at least to the ensuing constitutional crisis. And as a solution, President Keita on, I think the advice of ECOWAS actually, dissolved the court de facto, which meant all judges were replaced, but the court was still operating, but with completely new judges. And then shortly thereafter, the coup happened. In Guinea, the Constitutional Court found a referendum enabling a third term for President Condé to be constitutional and confirmed the adoption of the new constitution. In Burkina Faso, we didn't find a similar instance where you could say it somehow played a role in what later led to the coup. But what is maybe more important here now is what happened right afterwards. And in both Burkina Faso and in Mali, the courts legitimated military rule by declaring the new heads of states as presidents of their countries. Thereby, I mean, there's other aspects of these decisions that are problematic, but the main reason and most clear cut is both constitutions of Burkina Faso and Mali have prohibitions of military coups, and these provisions were simply ignored. And in Burkina Faso, you could say the council went even further and declared the so-called Fundamental Act to have constitutional value complementing the constitution. So this was a military decree, or is a military decree, that declared the new military leader as head of state, and the council basically then said, this Fundamental Act has constitutional value, and thereby what is written in the decree makes him now also the constitutional head of state. So, in the second main part, the question is what is the role of the constitutional courts during this transitional period? You can distinguish between two forms of engagement. One is decisions on functioning of state institutions. So when the military decided to change institutions, appointment procedures of the judiciary, for example, or in the case of Burkina Faso, the media oversight body, there have been cases in front of the courts. And the most interesting case is maybe the exception, namely in Mali, where just recently the Constitutional Court initially found a new law to be unconstitutional. So this is the only case we found so far that a Constitutional Court actually found something problematic and unconstitutional that the military did. But then after the military changed the law that was about providing the salaries for the military council, which is essentially the new parliament in Mali now, to be constitutional after these changes were made. But at least there were some attempts of kind of regaining legitimacy also for the court themselves after having played this controversial decision earlier that I mentioned before. And then the other form of engagement is in this process of returning back to civil government. And in all three countries, constitutional amendment or entirely new constitution making processes are underway or even completed. In the case of Mali, there's a new constitution in effect since last year. In Burkina Faso, there have been substantive amendments also last year. And in Guinea, right at this moment, there's a new draft out there that is being discussed. And in both Burkina Faso and Mali, again, the court has been actively supporting, you could say, this process and found it to be unproblematic, to be constitutional. So far this has been quite descriptive, and it's just interesting as such, I think, to see that constitutional courts, at least in most cases, continue to operate during military regimes. But what to do with that now? How do you assess that? As I mentioned briefly, from a purely legal point of view, some of these decisions are just technically problematic. They have weaknesses, they overlook provisions, they just look away from some other parts quite often. Especially the court in Mali was asked to decide on the referendum, for example, last year, just shied away from it and arguing on procedural grounds, basically saying it's not their role to decide on that. So they find ways of kind of not to decide on controversial issues, with the only exception of these salaries law I mentioned earlier. But then, of course, there's also another option, and asking yourself, so what is the alternative? Maybe you can also see some kind of understanding of what are they trying to do? What can they do in this position? What's the alternative for them? And then it's, of course, you're on more shaky ground, but at least to some extent, that's, I think, what we can see, at least for Burkina Faso. The court is, to some extent, effective in politically managing these cases, but of course, in the end, it's complicit to the regime, and that's problematic as such. Thank you. And then the legacy question, yeah, of course, that's another quite different aspect, because even if eventually in all these countries we return back to civil constitutional order, what will be the lasting impact? One obvious example is, of course, the constitutions that are amended right now. But even the courts themselves are affected by it. So in Burkina Faso, half of all judges were appointed by the military. So you could say they are undemocratically elected because they were appointed by the military head of state. So on a personal level, judges, and the process itself can even be constitutional because their terms expire and the new judges have to be appointed. Yeah, but also the institutions are changed on a permanent basis. So the constitutional, for example, the appointment process in the Constitutional Court of Mali for the judges has been changed in the 2023 elections. And if you look at it, how the new procedure looks like, it's less independent than it used to be before. And for the case of Burkina Faso, just as a last point, it's also interesting to see they are still, I mean, constitutional amendments have happened last year, but they're already speaking of new amendments to happen this year, and it's quite unclear what's actually the overarching goal of this amendment processes. They introduced some interesting innovations that you could even say they are positive, but then the overall agenda is unclear, and of course the whole process of amending is undemocratic. Thanks a lot. I'm looking forward to your responses and questions.
Thank you, Dr. Ivanis. I'm going to invite Christiana. Hopefully after our presenters have made their presentations, we can engage with the body of their work. I think as I said, keep it to 10 minutes. Because we are right.
Can you hear me without microphone? Okay. Sorry. So yeah, it's going to share on his side the outline that I sent. So I can start anyway. Okay, thank you. Thank you so much for having me here, and thank you very much to Professor Fombat that I haven't seen for long, although we communicated by email. Yes, I'm talking a bit, I'm continuing a bit what the first presenter started, about also the role of a bit of the role of the African Union. African contemporary constitution legalize often opposition parties, impose term limits on presidential tenure, grant independent court constitutional review authority, and guarantee important civil and political liberties. In the history of post-colonial Africa, these liberal concessions are unique, and albeit they are quite young, they've already survived previous attempts at political liberalization. Notably, the presidential term limits introduced in the recent reforms successfully ended the tenure of a growing number of African presidents, thus helping to establish a new tradition of systematic political succession. Presidential term limits are constitutional provisions to restrict the number of terms that the president may serve. They are meant to put a constraint on presidential rule, and in so doing, prevent the appearance of power abuses and personal rules. Although, of course, there are still attempts to push this presidential term limits. There was a recent attempt made in Kenya by a senator of the president, that was the same party of President Ruto, but to try to extend the presidential limit, the term limits, but at the moment it seems that it didn't go anywhere as an attempt. In spite of such progress, however, the general constitutional scenario in Africa is not always so conducive. Incidentally, I noticed that one of the main themes of constitutional analysis in Africa is on the diverse form of changes to the constitution, several being legal and several others being illegal. Over the years, the African Union and the African Regional Economic Communities, particularly after the 1990s, have thrown at a constitutional change of government very often when they result from coups. The governmental attitude has often triggered protests, like, for example, what we also witnessing these days in Mozambique, but sometimes have been received in silence. A typical example of illegal change of constitution in Africa consists, as I mentioned before, in the removal of the term limits for a president in a manner that was not contemplated by the same constitution. Several times these term limits, they don't even exist. In fact, in Africa, we have cases of presidents who are in charge for many decades. I think that the long-standing president in Africa is still President of Young in Equatorial Guinea, who is in power since 1979, followed by President Biya in Cameroon, who is in power since 1984. And later this year, there will be still the election. And probably you read that it's not really clear the situation of President Biya was 91, I guess, because apparently it's not living in Cameroon anymore, it's living in Switzerland, where he's a resident for a long time. As such, on one side, in my work, I'm wondering how often this has happened and what has been the impact of this situation on African constitutionalism. Against this backdrop, while the African Union and the regional economic communities shout when there is a military coup on the continent, for example, the African Union suspended Gabon one day after the coup of the 30th August 2023, and this was the first response, regional response to the 8th coup in West and Central Africa since 2020. The institution often remains silent when an incumbent president changes the constitution in an illegal manner to retain power. So one of the causes of my work is not to reflect on the issue of repeal of term limits or other changes per se, but also would like to rather reflect on the legal manner in which these situations are carried out and the failure of both the African Union and the regional economic communities to condemn them, leading African democracy often to liberalism. On the other side, my work tried also to analyze the recent development of the protest movement. As I mentioned before, we see what's happening in Mozambique these days. That occur often, but not exclusively as an outcome of a contested election, or because of some constitutional change operated by national governments. This protest today seems to represent one of the arms to persuade incumbents not to take advantage from the presidential role, in fact. One of the main documents is part of the soft law, but it's still it's quite new and remains a very important term of reference, as it was also mentioned before, is the AU Declaration on Constitutional Changes of Government in Africa that was adopted in April 2022 in Accra, in Ghana. And this was adopted by the representative of the AU member states, member of the Peace and Security Council of the AU, AU organs and institutions, and regional economic communities, and also the representative of African civil society organization. What it was decided, I think that some of what was decided was put in this declaration is very important to understand what is the idea that the institution in Africa, in fact. All the participants at the meeting in Accra, first of all, continue to strongly condemn all forms of unconstitutional change of government in the continent, coup perpetrators and manipulation of democratic processes to effect constitutional amendments or revision for entrenching power of the incumbent in violation of the national democratic principles, and stipulated rules and procedures for constitutional amendment. Also, they pledge to comprehensively address factors which lead to a constitutional change of government, including the manipulation of democratic processes to tamper with constitution and effective amendments to electoral laws within a short span before the election and without the consent of the majority of political actors. We have witnessed several attempts attempts in several countries. I remember there was one that was tried to be attempted in Senegal several years back. And of course, in violation of the stipulated national democratic principle, rule and procedure for constitutional amendments. Of course, another important feature is to call for the decriminalization of opposition party legitimate activities and enhance closer collaboration for the common national and continental shareholders, while respecting human and people rights and upholding separation of power and the independence of the judiciary. Is not strictly to do with unconstitutional change of governments, but just in these days, the president of Zambia sacked 3 judges of the Constitutional Court because they ruled in favor of his predecessor, and this, of course, lead several political observers to start saying that also Zambia now it can be on the edge of some form of illiberalism. In the declaration, it was rejected any form of internal and external interference on peace and security matters in Africa, and warned those who finance coups, foreign fighters, and mercenary member states that the action would not be tolerated. And this, of course, was targeting organizations like the Wagner organization that has been accused to be behind, the Russian Wagner organization has been accused to be behind several coups in West Africa. The declaration also encouraged member states to address peace and security challenges to mutual support within the continent, as well as advancing the concept of African solutions to African problems, and appeal also member states to respect their respective constitution, especially adherence to presidential term limits, and to recognize free, fair, transparent, and credible elections, in line with national laws and international norms, as well as respecting the outcomes of the elections. There was also, in this case, there was this recent controversy because President Kagame in Rwanda has been elected in August again with more than 99% of favorable positive votes. Of course, in this regard, there was also mentioned before, we have in Africa this hard law document that is the 2007 African Charter on Democracy, Election, and Governance. There are, of course, several articles that deal with unconstitutional change of government. I will just quote Article 2.4 that talks about the objective of the Charter. I'm quoting, the objective of this Charter are, paragraph 4, prohibit, reject, and condemn unconstitutional change of government in any member state as a serious threat to stability, peace, security, and development. In the end, and I hope to be in the 10 minutes, currently the African Union capacity and also the capacity of the regional economic community to enforce the prohibition of unconstitutional change of government in Africa seems quite limited. It is tempered by the political realities and other local factors in the state in which an unconstitutional change of government has taken place. For example, the fact that the African Union mostly calls for a restoration of the constitutional order when coups occur. This is a generic and actually forward-looking solution, rather than insist on the immediate return of the deposed leader. Has been seen as a testament to this reality that the African Union is forced to accommodate. In fact, the ability of the organization to enforce the prohibition of constitutional change of government is tied to its own moral authority and credibility, the strength of which, in fact, are determined by the depth of its member democratic culture. Of course, if there is no culture of democracy in several countries, it will be very difficult for the African Union to let this country understand that what is happening there is anti-democratic. Of course, I'm available to respond to possible questions afterwards. Thank you very much.
Thank you. I'm going to move to two specific case studies, just to help us recap this previous also setting up. One of the things that have come out of the three conversations is also this idea that, we often, when we think about unconstitutional change of government, we think about the military takeover, but the terrain is shifting and there are nuances that are emerging. You see things like unconstitutional retention of power, but also extension of term limits, presidential term limits. But there was also something that Barbara said, which I think is very important, is this idea of consistency in how the African Union responds to these issues. There seems to be lenient to other cases and harsher to others. So we need to also think about how the AU responds to these type of instabilities and unconstitutional changes to make sure that there's consistency there. And of course, even this idea around the legal frameworks, a few weeks ago, someone was talking about, the Rome declarations and so on, that, the idea here is not that the frameworks are not very good frameworks, and Barbara alluded to that earlier, that there seems to be an implementation gap. And there seems to be a lack of commitment and political will in implementing those. And I'm also very interested in the case of of Mali, Burkina Faso, and Francophone countries. So maybe later we can reflect on that also in terms of the role of you know, international bodies, even France, for example, that had colonial power, and how that has impacted some of the developments in Francophone countries that have experienced unconstitutional government. But now I'm going to hand over to Dr. Ibrahim, who will reflect on Somalia.
Good afternoon. Good afternoon, all. I am happy to be here, and I'm happy to join you in celebrating the scholarship of Professor Charles Holmes. I have widely used Professor Holmes' work, he has guided me, and I think I will join you guys to pray for him, for his long life, for his long and healthy life. And I hope we'll continue working together. Thank you so much. Now join me. I think you have heard a lot about African countries. You have heard about EU, you have heard about Cameroon, you have heard about Ghana. Now it's about time we go to Somalia. And I will protect you guys from Al-Shabaab. Somalia history, I'll be sharing with you guys on how constitutionalism is gradually taking shape in Somalia. It's not yet there, but it's gradually taking shape. Somalian colonial history was shaped by both British and Italian rule, which influenced its early governance structure. The top part of Somalia, present-day Somaliland, was colonized by British, and they inherited British Commonwealth system. The southern part was inherited by Italia, was colonized by Italia, and they inherited a colonial Italian civil law system. Both countries gained independence from their respective colony. After that, they came together and they said, you know, we are one people, we are all Somalis, let us remove this colonial boundary, let us become one country. So the birth of Somalia was born, and it was named the Somali Republic. Somalia adopted one of the African first colonial constitutions, laying the groundwork for democratic governance. In the early years, Somalia emerged as one of the first democratic countries, with this constitution providing for key aspects of constitutionalism, such as separation of power, rule of law, and democratic election. Somalia held its first election in 1964, which actually demonstrated commitment to constitutionalism in the early 60s. The peaceful transfer of power followed. Somali leaders then respected the constitutional term. And after 1967 presidential election, President Aden Abdullahi Usman stepped down peacefully, marking a key milestone in African democratic history. He held the monopoly of power, he had the military, but he chose, when he lost the election, he chose to step down. And this is high story in Africa, and that is in 1960. Okay, despite the early success, Somali democracy began to face challenges, as corruption, nepotism, and increasingly clear clan-based political divisions undermined the governance. Political stability became evident after 1967 election, when the tension within the political elites and dissatisfaction among the various clans began to grow. The widespread corruption in the public sector weakened the confidence in the government, while economic difficulties added to the political satisfaction. In 1969, the military overthrew the civilian government in a bloodless coup, marking the end of Somali's brief democratic experience. 1960 constitution was suspended by the military. All the democratic institutions established under the 1960 constitution, including the parliaments, were dissolved. Political parties were banned, but the Barre regime ruled by decree. He drafted a 1979 constitution, which was based on socialist principles, influenced by Soviet Union. The regime introduced of the training system and barely cultivated a cult of personality, portraying himself as the father of the nation. When Seth Barker was overthrown by the group of clans in 1991, Somalia fallen into a civil war, and 1979 constitutional legal framework collapsed alongside the regime. In 2004, after several years of failure, transitional federal government was established under traditional federal charter, making a new attempt to rebuild Somalia's governance structure. Apart from the TFG mandate, efforts were made to draft a new constitution that will lay down the groundwork for a federal system of government. The 2012 provisional constitution was adopted by National Constituent Assembly in August 2012. The constitution was designed to accommodate Somalia's diverse clan-based society and provide for autonomous regional states with a unified national framework. In 1960, since 1960, Somalia therefore has had a number of three constitutions, 1961, 1971, and 1990, two transitional charter and provisional constitution. The endorsement of 2012 provisional constitution marked a significant milestone in Somalia's post-conflict recovery and state-building processes. It represented a groundbreaking achievement for a country that has entered a decade of instability and political fragmentation. The provisional constitution provides a legal framework necessary to get Somalia's effort to rebuild the nation in alignment with the principles of rule of law, good governance, and human rights. Central to the constitutional framework is the principle of federal system, which states that Somalia is a federal, Somalia is a sovereign and democratic republic founded on the inclusive representation of the people, a multi-party system, and social justice. This declaration reflects commitment to creating a political system that not only respects the sovereignty and democratic values, but also promote inclusive representation and social justice. The provisional constitution seeks to address the need of Somalia's diverse population while fostering political stability and development. The core principles of constitutionalism is provided in the provisional constitution. There's a separation of power, both vertical and horizontal. A number of fundamental human rights provided from the constitution. The rule of law and judiciaries are elaborated, and also the constitution provides for independent commission under chapter 10. Article 48 of the provision constitution envision two levels of government, consisting of federal government and federal member state. The founding principle, as articulated in Article 3, explicitly states that Somalia is a federal republic. The Federal Republic of Somalia is founded upon principles of power sharing in a federal system. This framework is designed to ensure that political power is shared between national and regional governments, promoting a centralized form of governance that can address unique needs and characteristics of Somali regions. Further, Article 1.2 reinforces the principle of mutual respect between different levels of government. It mandates that every government shall respect and protect the limits of its power and power of other governments. This provision seeks to prevent conflict over jurisdiction boundaries and promote cooperative federalism, ensuring that both federal government and federal member states work within their constitutional mandates while respecting the authority of each other. So there are federal government and federal member states, each with its, there are, I think it's very clear here. The federal government, there is executive authority shared between the prime minister and the president. There is legislative authority. Somalia has two houses of parliament, House of People, and the upper house. Upper house represents federal member states. And also there is judicial authority. They are in the process of establishing judiciaries across the country. But then the Constitution stipulates that there should be a constitutional court, and then there's a federal government level court and federal member state level court. And the federal member state, the regional government, executive authority is shared between the president of the region and this cabinet. There's a judiciary within the federal member state, and they also have their legislature. The institution of shared rule, and the institution of shared rule, the upper house represents the federal member states. There is an informal representational national leadership forum where the president of all the regions, together with the president and prime minister, sit down and deliberate the issue of the country. And then, of course, there is a Council of Interstate Cooperations. On the federal member state level, so far there are 5 main federal member states. The number may grow as the alignment continues. Constitution stipulates that every level of government shall respect and protect the limits of its power and power of other government, implying that a constituent unit in Somalia will be granted autonomy without interference from the federal government. Apart from that, the Constitution will also provide for fundamental human rights. Among these rights are right to life, freedom from torture, right to privacy, freedom of expressions, and so on and so forth. Together, these provisions aim to safeguard individual rights while promoting social justice and equality within the framework of a federal system. Judiciary in Somalia plays a crucial role in upholding the rule of law, safeguarding the constitutional right, and ensuring fair administration of justice. However, the independence of the judiciary has often been challenged by political interference, corruption, and countries' unstable governance structure. These are other critical challenges because of time. I want to be able to dwell on it. So the critical challenge, apart from the fight of the division of power and resources, the Constitution has not explicitly stated how resources are shared within the country. It says that the policies have to be created on that is going to give a direction on how the resources are going to be shared. Up to now, that has not been put in place, and this has caused a lot of rift between the level of government. The clan-based system, the individual system or clan system, continues to undermine national unity and constitutionalism. You know, apart from what is written in the Constitution, the Somalis have only had indirect election. They cannot have direct election because of a number of things, including the state capture by the elites. The elites, they don't want to let the power go. So they can influence on how the indirect election can take place. Indirect election usually take from the grassroots to the presidential level. At the grassroots, initially, the elders are selected from every Somali clans. And then these elders, they select members of parliament. And the members of parliament in turn select the presidents. Every level, for you to be selected as a councillor or as an elder, you have to have money, you have to influence the process, you have to pay for it. And for the member of parliament to be elected as a member of parliament, the qualification is you have to be rich, you have to be wealthy, and then you'll be elected as a member of parliament. And for you to be the president, you have to be super rich. You have to be extremely, extremely wealthy for you to be able to purchase the parliamentarians. So the parliamentarians, they have to pay their money back, the money that they've invested in the elders. So the process continues. So this is how the indirect election goes. And the power is shared according to the 4.5 power sharing formula, where the biggest clan share 1 of each, and the minority clans are given 0.5. And this is, has been a problem where, especially the minority clans have been complaining about it. Apart from the clan system, Al-Shabaab and security continue to pose a significant threat to constitutional governance. Al-Shabaab still control better part of southern Somalia, along with the regular attack. They keep on attacking the government and political environment. Somalia still have weak institutions. Judiciary and security forces are still underdeveloped. The corruption is widespread, and effective governance is yet to take place. concluding remark. The journey towards constitutionalism in Somalia is approached with complex challenges, deeply influenced by insecurity, political rivalry, struggle for power between government and federal member states, the ongoing violence and instability in the enforcement of rule of law, impaired protection of human rights, weakened the authority of key institutions necessary for constitutional governance. Additionally, insecurity excavate tension between federal government and regional entities, complicating Somali federal structure and delaying exceptional democratic processes. Despite these challenges, Somalia's commitment to establishing peace and inclusive constitutional framework remain critical to achieving long-term peace, justice, and accountability. For a meaningful progress to take place, Somalis have to address pervasive insecurity. They have to foster cooperation between the different layers of government, and judiciary should be established. Thank you so much. Thanks for listening to me.
Okay, thank you so much. I'm blessed to be here and celebrating the scholarship of Professor Moment, and I'm also pleased to be coming from Zimbabwe to present about the coup to power, but this is Southern Africa gained from Zimbabwe's post-2017 constitutional But as you all know, in 2017, Zimbabwe experienced one of the most silent and still controversial coups, because it wasn't a coup from the political outlook because of the smoothness of how things happened, but constitutionally it was the move of the government that has been in power through a legitimate means, which was an election. So the way the coup in Zimbabwe happened was a bit silent and did not shake the regional institutions, and even SADC was a bit silent about it. But now the problem is that I'm advancing the argument that whilst most scholars have been contextualizing the Zimbabwean coup as primarily Zimbabwean, and they've been trying to look at the Zimbabwean coup, looking at how it has affected the human rights from within the country. They've been trying to look at how it has affected the constitution within the Zimbabwean context, and little regard has been given towards understanding the regional impact of the coup in Zimbabwe. Because my argument was that the Zimbabwean coup cannot be contextualized within the Zimbabwean territory, but rather it should also be understood in the context of the SADC community, because SADC has got the responsibility to look into the issues of the unconstitutional changes of power. And I also made it clear that if left unchecked, this trend of having unconstitutional power, change of power in SADC is most likely to continue. And that would be a direct overthrowing of the legitimate constitutional provisions that bound us as democratic states within the SADC region. Now, I think some of the things I'm just going to go to pass. Section 208 of the Zimbabwean 2018 Constitution Amendment number 20 prohibits the involvement of the military services or any other state arm in matters to do with politics. And it is very clear that the military should be apolitical. It should serve the public interest instead of the partisan interests of a particular party. And remember, when the coup in Zimbabwe happened, Chiwenga couldn't come into power directly because it was going to be a very, very clearly non-coup. So what he did was he handed over the power to his friend who was not part of the military. Then the idea was that after serving for quite a time, then hand over the power to Chilunga, but then he would have left his position as the commander of the military. So the problem now that we have in SADC is that not only SADC but in Africa is that since 2017, we have seen a wave of constitutional changes of government. And from the statistical information that I got, I think there are 17 coups that have occurred since 2017 globally. And of the 17, 16 are from Africa, and Zimbabwe included, and one is from Asia. I think it's the Myanmar one, 1 February 2021, I think. Now, it is becoming a norm for African countries to disregard the provisions of constitutions, especially the election of leaders into power through democracy. And if this trend continues, we're most likely to see a total disregarding of the constitutions by African states and the entrenchment of dictatorial forms of government, which will further marginalize the liberties and freedoms of the people. Now, I also made use of the contingent theory, which was propounded by Lee and Thompson in 1975, which talks about the issues to do with coups and how they can possibly affect governance across nations. And one of the tendencies that coups are transmissible. A coup in one country has got a modeling effect which can possibly be taken by other countries, and possibly that can lead to a triggering of various coups within the region. Now we have seen this happening with the Mali coup and the Burkina Faso coups. And today the three countries have formed an alliance which is made up of coup leaders by themselves. And what it basically means is that we are slowly accepting coups as something that is normal within the African context. And then I'm narrowing down to SADC and saying, if SADC does not look further into the prospects of what coups will bring to the region, there is a possibility that they will continue to be entrenched as a systematic form of government of unconstitutional change of power, and possibly lead to more chaos than we are currently realizing. Then in the collection of my data, I used a qualitative approach, which was based on interpretivism as a philosophical worldview, and the subjective approach. I also got into touch with a lot of participants who are into politics and political analysts, and some who are into issues to do with politics and governance. So from the information that I got, I did a systematic analysis of the data, and then I also did a systematic analysis of the presentation of my findings. So I realized that currently SADC is an enabler of unconstitutional changes of power, because when the coup in Zimbabwe happened in 2017, SADC was very silent. And I think someone also talked about the African Union, how it has been just saying we need to get legitimate changes of power, but they are not bringing that into action. And by continuing to preach lip service, we are most likely to see more of those coups happening. So we are saying this is an enabler of something that should be stopped as soon as we can as African states. And I would also like to bring the idea of how South Africa is one of the SADC member states has been enabling this. Now, when the power was seized in 2017, South Africa is one of the countries that has been forward in terms of human rights, but they've been failing to do the same over the Limpopo River, which is less than 2,000 kilometers from here. They've been failing to possibly trying to make sure that the whole region is also immersed in democratic governance. So even in 2018, President Mnangagwa came into power through a controversial election, which was filled with bloodshed, the death of 6 civilians, and President Ramaphosa was the first person to congratulate him, whilst the Western countries were busy trying to denounce the violation of human rights and the clamping down of people's liberties. And the next thing was China and Russia came and congratulated Zimbabwe. Why did these countries start doing this? You realize that when you go to the Eastern countries like Russia, and China, they do not regard what you call human rights. They do not regard democracy. So they just want a country, a leadership that comes into power and allows them to siphon the resources. So we are now losing the benchmark of democracy by aligning ourselves with the Eastern countries just to advance our political agendas at the expense of our constitutions, which are largely premised on the Western principles of governance. So we are saying, in as much as we may continue, we may talk about this issue. SADC is enabling the dictatorship, and even the African Union itself has been very silent on this issue in Africa. Okay, so unfortunately the time is gone. So we're also having a problem of political ideologies divisions within the SADC region due to the unconstitutional change of power. And I think in the past few years, you've realized that since 2017 to the present day, Zimbabwe has been stirring controversy within the region, from insulting President Akainde as a security threat and throwing all forms of tantrums to all the other countries, and even going far to Russia and reporting that Zambia is a security threat to our region. Zambia is one of the models of democracy within our region, but Zimbabwe, because of the nature in which the government is coming to power, it is now seeing democracy and the constitutions as hindrances to its political agenda. And because of that, due to the time constraints, I'm saying we need to have a grassroots approach to rejecting these constitutional changes of power. And I think Abebe and FOMBA 2021, they also wrote about the African Union, and they also recommended that it should also take a proactive role in making sure that it rejects all these forms of unconstitutional changes of power. And you know, one of the painful things is that SADC has devised ways of joining hands with Zimbabwe to bring out a day to be in consolidation against sanctions, but Zimbabwe is a member state of the broader community. These sanctions should be enforced, and all these countries should join hands with other countries in denouncing unconstitutional change of power. And I'm saying, if this is left unchecked, we are most likely to see the most controversial, dictatorial type of leadership flourishing across the SADC region and Africa as well. So thank you so much.
Right. To all our presenters, we have about 10 minutes. Is there anyone in the room who has a question? We've got a question there, number 1, 2, 3, 4, 5. So please keep it very brief. Can someone help with the mics? You have a question? Okay. Are you helping? Oh. So let's start at the back.
This one. I mind if I take that?
Yeah. Starts here.
Thank you. I'm Yankan Peter. I'm a student from Kenya. So when we're speaking about unconstitutional changes in government, the problem that happens is we do focus a lot on military coups and popular uprisings, and we end up forgetting about unconstitutional changes of government through constitutional amendments. So I'm trying to think about these countries, Uganda, Equatorial Guinea, Cameroon, and Djibouti, where the presidential term limit was extended with via parliamentary approval without involving the people. And I remember reading one of the submissions of Professor Charles Fombard in a case in Kenya, the BBI case, in the Court of Appeal. And I was just thinking, and I would like to get your thoughts, how can we use, because this doctrine that I think can help solve this. So the basic structure doctrine. So the Court of Appeal will tell you that the Constitution of Kenya has a structure. Then their understanding of the basic structure is there are provisions of the Constitution that you're not supposed to change unless you're going by a referendum. So I'm just trying to think of countries, the 4 countries that I've mentioned amongst other countries that don't have a constitution that has a structure. if it's possible to adopt the basic structure doctrine through judicial craft so that we make it tough for people and leaders who want to extend their presidential term limit without involving popular sovereignty. Thank you.
Number 2 at the back. To your left.
Thank you so much, Kennedy. I think my question goes to the last presenter, that is Christopher. Christopher, from a democratic point of view, the election monitoring bodies play a key role in elections. And as you see, of recent, after this year, Zimbabwe has just concluded an election. Now, when you look at the reports that is coming from the national election monitoring bodies, including the one of SADC itself, it plays a role and actually criticizes the human rights violation that was happening in Zimbabwe at the times of election. And considering the fact that this happened in Zimbabwe, which is part of the SADC, and your research work tries to pick up lessons that other South African regions can learn from Zimbabwe in the post-2017 periods. Have you, in your line of thought, considered in your work that you do from a democratic point of view, what other South African countries can pick from Zimbabwe in how they conducted the elections and how they have made it impossible for the election monitoring bodies to exercise their roles in on assessing the quality of elections in Zimbabwe? Thank you.
Number 3 here, the gentleman.
Greetings. My name is Khalid Mohammed, BA Law student. So mine is to the last speaker, Brother Christopher. He said something in regards to say that Eastern countries are known for being anti-human rights and Western countries are pro-human rights. Don't you think you are being controversial yourself? Because of Western countries are known for endorsing or for committing genocides and massacres. So by saying Eastern countries are anti-human rights and Western countries are pro-human rights, don't you think you are being controversial? Thank you.
Just to be clear, it's Sharai, not Christian. Oh, okay. Can we have this gentleman here with the staff, please?
Good afternoon. My name is some charged on the issue of the chain in my question is going to show can currently what might be the cost of the chain.
Thank you. Do we have someone this side? If we don't, I'll take the last question.
Greetings, everyone. My name is Commander Shonwe. I'd like to firstly make a comment that to a fragile and a conflict-driven Africa, we also need to acknowledge the contribution of the West in the collapse of Africa as a whole. A gentleman made the point that for you to be a president of the country, you must be super rich. And an example close home with a president who is well decorated after Nelson Mandela called Cyril Ramaphosa, who is very rich, whom in us they gave us an impression that he's very proud in his leadership qualities and business-minded type of person. But ever since he got into office, there's nothing but disaster. You need to look at it from unemployment perspective, to collapse of state-owned enterprises. So my question to anyone who is comfortable to answer, it's not specific to anyone. How does constitutionalism prevent and address the coup, is it coup or what? A coup in African countries? Because there's an article that states that since August 2020, there's been 7 coups in Africa, which includes Niger, Sudan, Guinea, Burkina Faso, Mali, and just to mention a few. Then my second question is to say, what is the relationship between constitutionalism and peace-building efforts in a fragile African states? Because the West flourish if Africa is fragile. The West doesn't want to see an Africa that is united, an Africa that is one. So I think those are just my 2 questions for now. Thank you very much.
Oh, okay. I don't think the one which was there was a question about constitutions and
There was a question about the way elections are managed in Zimbabwe.
Okay, it's a compliment that you can find it's very true. I also yeah, the elections failed to meet the local and global standards. Okay, that is very true. And the reason why is because the institutions of are already captured. The person who is in charge of the commission and all the people are pro-SANU-PF. They are known as members of the SANU-PF party. And the system has been changed not only in the same body, but also in other state apparatus like the police and everything. So there is no way a leader government is going to be power through a soft approach, which is an election. Obviously, they are going to wait for another leader.
There was a question about the inconsistencies of responding
the decision. Oh, okay. Yes. So in terms I didn't really touch completely as I was presenting, but there is disunity. And this is a challenge to the sovereign power of the AU. And this disunity is actually seen in terms of just the division that Africa is divided into Francophone, into Anglophone, into Lusophone states. And that also brings about the difference in ideologies already between the African member states in terms of that. And also just the disunity between in having stabilization and also just really consistency in how the AU is supposed to actually do what it needs to do in Africa in terms of just, it needs to be enhanced collaboration with the race, of which that is something that is also just seen as a challenge and also just showing that much of disunity in terms of that as well. And just really in terms of some African states seek their own solutions as well. So in the AU, they struggles in terms of that as well, in terms of just that of the rates as well. I think that in an article I was reading in terms of just really ECOWAS wanting to have some exclusive control in their own parts as well, and then just that affecting the strengthening of just really the regional collaboration to actually ensure that there is consistency in ensuring peace and stability.
Thank you.
No.
Yeah, because also I mentioned this inconsistency. It's true that, in my opinion, it's not only my opinion, it's a question of check and balances also within the African Union. I made the example of President Kagame in Rwanda, that he was elected for the umpteenth time in August with 99% of votes. That in some other contexts can be considered a sort of illegitimate election and stuff like that. But we are talking about the same president that, for example, is helping a lot the African Union in hosting refugees. And the same question that it can be posed for President Museveni in Uganda. And also he is contested because he pushed the limits, the term limit, but Uganda is hosting 2 million refugees. So you have to consider the big picture. You can't focus only on one picture about the change of constitution. So in any case, if they help the African Union, if they help Africa in some other way, the African Union is keen to close an eye or 2 eyes. Because in any case, they are not doing God's bad. I mean, they are also doing something good for the rest of the country. And I have also a question. There's a good question to be Ibrahim. Actually, I wanted to know, it's very interesting what you said. I'm Italian, by the way. But how this constitution fits with the fact that Somaliland, since 2001, they won the reivindicated independence, and it doesn't care about the federal constitution from Somalia.
Thank you so much. I think I should respond to one question constitutionalism, settlement peace. Peace building. For constitutionalism to prevail, is a need for peace. Without peace, it will be difficult to establish constitutionalism. Now, if you look at Somalia, one of the biggest challenge is insecurity. And that has seen that the establishment of constitutionalism. Many times, the constitutional friends, they organize a conference where they bring together different people. They talk about the issues that environment, it is the issue of resources, it is the issue of power, it is the issue of representation. This is addressed. It is addressed in the conference. And then they put it in a draft document. Eventually, trying to set in the constitution. I think that the issue of peace will be addressed. Everyone will be happy. Will be addressed through that kind of challenge. That's that. And the issue of Somaliland, Somaliland is formerly colonized by the British, the southern part is colonized by Italy. Somaliland has been so peaceful. It's more peaceful than many African countries today. They have rule of law, legal constitution, they have their own currency, they have their own security system. Actually, it's more functional than even South Sudan. It's more functional than even Ethiopia. But then again, because of the nature of the politics, because of the nature of the new politics, they have not been they want to free themselves from Somalia. And there's so many reasons why they want to free themselves from Somalia. Although initially they came together from one related Somalia. But then after the civil war, Somaliland, there's already established their own peaceful area. They don't want to interact with the southern part, and it's always a war. And now it's becoming so difficult for them to develop. Somalia, they don't want to let it go. They want Somaliland to continue to be part of the Somalia. And AU is adamant that they don't want to change the boundary. It was established. So there are a lot of diplomacy taking place. Maybe in the future we will see independent Somaliland. Thank you.
just two quick points. So one actually, continuation of what you just said, there's a certain irony in our cases that one of the main reasons why the coups happened, at least that's what the general agreement is that insecurity, like the terrorism in the region, and both in Mali and in Burkina Faso, there have been attempts to challenge the constitutional amendment process or the constitution making process in the case of Mali because of that, because both constitutions have provisions that say you can't amend or change the constitution if territorial integrity is threatened. But the courts then said it's no problem, it's just part of the country, so we go ahead. The other point is in response to what you said about international involvement or responsibility in these cases. And I said at the outset of my presentation that my first contact with this topic was an assessment of a constitutional assistance project by the Max Planck Foundation. So they supported the Constitutional Court of Mali before, during, and after the coup in Mali. Not seeing any problem. And one of my main conclusions in my report was maybe there should be a red line, or at least think about it. What does it mean? You support the court, it's not by default a positive thing. They are also complicit to some extent with that regime. And when I came across now in our research on the two other cases, I saw that in the case of Guinea, where the Constitutional Court has been suspended, there's an EU-funded project that supports the Supreme Court of Guinea now to increase the capacities of that court to be able to oversee the upcoming elections and to be able to do constitutional review. So I don't know, but it looks like there's no sense of, it seems there's no awareness that this might also be problematic. It's good.
Thank you so much. This has been a really good conversation. Just to build on something that you said, for West Africa in particular, so there seems to be also anti-trade sentiment. I think another interesting thing to look at is how the investment and influence of Russia and the US at the same time is also impacting some of the constitutional challenges in West Africa. But I think what we can agree on is that this idea of building or adhering to provisions of constitutions is like it's almost the citizens are demanding a new social contract, right? And there seems to be an agreement, and even throughout this conference, we've been talking about this idea that we need to critically look at the type of democracy that we have. There seems to be a challenge around how citizens see democracy. And again, in some parts of West Africa, we've seen young people going to the streets to celebrate coups and stuff like that. So I like that this conversation was able to center the African Union, center the Reds, but also center how we can apply legal frameworks and so on and so forth. So thank you so much. Please give a round of applause to our for lunch. Can we be back at 4:02? What time is it now? 4:02 is fine, right? Yes, so enjoy your lunch. Yes, let's be back here at 4:02, please.
I love my phone here.
I've been wondering this for minutes.
That is supposed to be present. Is he online? That is supposed to be present. Is he online?
can't hear you, Mr. Mutabi. You're not audible to us on the platform.
Friends, colleagues, let's call the meeting to order and get on with our business. It's a pity that we have to start on a slightly limping basis, but I'm sure we'll have both our legs in no time at all. I always get the graveyard shift. And Prof. Wombat saw that happen to me in Bloemfontein 2 months ago, 3 months ago. And I think it may have something to do with my dean, the dean of my faculty, Professor Kamga, who thinks my job is to rouse us. So let me try. First of all, I admit to being the person named on the program. I am indeed Kanya Mutsabi. That much I only admit. The other proposition I do more than admit. I'm proudly of the UFS Law faculty. I'd like to start perhaps on a more personal note, which may be appropriate given the fact that our colleagues are joining us. By the time I applied to join here, I had known Prof. Wombat for no more than 5 days. Just navigate this. Prof. Wombat, I was struck. But as the rest of us can imagine, in a very soft kind of way, soft, powerful, impactful. In his calm, gentle, mild manner, Professor Wombat made a strong, lasting, and sustained impression. This made me, as Mr. Obama likes to say, want to be a better person overall. Prof. Wombat is one of those who tends to have that kind of effect on me. So I simply had to be here. This week, my wish to become better is growing. So potent is the power of the scholar and his orbit. Mine has been a great, brief journey with him, a great opportunity, a massive privilege, an incalculable honor, and a wonderful delight. Thank you, sir. And for this, I'm especially grateful, of course, to so many, especially the honorant himself, and his quite charming, warm, and accomplished family. I also owe Dean Kamga from the University of the Free State for making it possible for me to be here. Dean Kamga, who comes up a lot in my speech, is my self-assigned mentor, who happens to be a present and or past protege of Prof. Wombat. So the question arises, what Prof. Wombat are you in relation to me? And I'm going to try and answer that question. I'm afraid, sir, that it makes you a role model, perhaps a mentor, a role that you began in Cape Town, not Cape Town, in the Free State, when we saw each other in July and spent those wonderful, rich 5 days together. So I want to thank the organizers, I want to thank the organizers for the opportunity to be part of these proceedings and to moderate this session. This afternoon, we have 6 papers. It appears that 2 of the presenters are in the room, the rest are online, and I don't propose to dwell very much on the background information which is on the program. So I want to proceed, if I may, directly to the speeches. Now, I wanted to check in with my panel, but I was here and you were elsewhere. The first speaker, couple of speakers, are Professor Abatas Abbo and Ms. Borisani Matala. Are you in the room, colleagues? If not, then we go straight to the Free State, to my colleague, Dr. Mhlanga. Are you ready, sir?
I am ready. I am.
Please proceed. The time is 14:29. We shall be watching you hawkishly. Good luck.
Okay, I think I can share my screen.
Please do.
That's feasible. Can I get a confirmation if the screen is up?
Yes, fantastic. Thank you. Please do proceed.
Oh, thank you. Thank you very much, Kanya. And allow me to greet everyone there in the auditorium and everyone on the platform and say to our honorary luminary person in the room, Charles Fombert, that it's an honor to be here and it's an honor to contribute to today's discussions. So my title for today's presentation is Beyond the Ballot, Socioeconomic Inequality and the Future of South African Democracy. And really what I'm trying to delve into is the subject about how economic inequality is not only a social issue, but one that strikes at the very heart of democratic participation. And perhaps to start off with a disclaimer, the distortion of democracy or the distortion of democracies by economic influences is not unique to South Africa. But I argue that it's emblematic of many neoliberal economies where global capital exerts a strong influence over domestic political outcomes. In South Africa's case, the entrenched racial and economic inequalities inherited from apartheid have only deepened under neoliberalism and any other economic influences that one might see manifesting. Right? And let me just straight into the introduction. When we think of democracy, we tend to think of it in simple terms: one person, one vote, and the ideal that everyone has an equal say in how their country is governed. But in reality, democracy operates within a far more complex framework. In South Africa, where economic inequality is rife, or it's among one of the highest in the world, the principle of equality severely compromises democratic outcomes. So while every citizen may have an equal vote on paper, their access to political power and influence is vastly unequal, with the wealthy often exerting disproportionate control. And my theoretical framework is one of economic disparity vis-a-vis political equality, which I'm sure has come out with the introduction. And I argue that this leads us to the core issue we're discussing today, the relationship between constitutionalism, democracy, and economic inequality. And on that slide there, I have a stat there for you guys to see and ponder on. And I'll have these stats throughout my presentations that I want you to just keep referring to and perhaps think deeply about as we go on. The transition to democracy in South Africa in 1994 was a turning point in South Africa's history. Political equality was finally secured with the right to vote extended to all. However, this shift did not come with the economic overhaul that many had hoped for. The economic structures that supported apartheid and those that entrenched racial and class divisions remained largely intact. Decades after the first democratic elections, the reality is that many Black South Africans, though politically liberated, remain economically marginalized. After 1994, there was a brief period where the ANC embraced distributive economic policies. But as we know, by 96, the shift towards neoliberalism had begun. The GEAR program, for instance, emphasized attracting foreign investment and promoting economic growth, but it did so at the expense of addressing the structural inequalities inherited by apartheid. So what does this have to do with what we're discussing today? The core issue here is that the outsized influence of elites on politics and wealthy individuals and corporations that donate large sums of monies to political parties, often ensuring that policies favoring their interests take priority, are we need to reckon with. Beyond financial contributions, there's a concept of discursive majorities where the ideologies of a small, wealthy minority dominate the political landscape. Or if you want to look at it differently, as Isaac Gillard points out, there's also the aspect of financialization, which is this growing entanglement of households and governments in financial markets, which further compromises political agency. And how he explains this entanglement is it's a dependence on credit cards, mortgages, pension funds, which really ties households to the current system, making it difficult to push for the economic recalibration needed to dismantle apartheid-era economic dominance. And the case in point that informs the study is the recent elections. By July, the rand had recovered. After the elections, the rand had recovered and bond markets had regained confidence. Investors welcomed the new administration's commitment to fiscal discipline and market-oriented reform. However, this stabilization, I argue, only reinforced the notion that political legitimacy in South Africa is increasingly tied to satisfying the demands of financial markets rather than addressing the democratic will of the people. This dynamic creates a perversive incentive structure where political leaders are compelled to pursue policies that cater to investors rather than focusing on the broader population needs, particularly those of the economically marginalized. But one would argue, so how do we reclaim our democracy? South Africa's democracy is still young, but faces significant challenges. As long as economic inequality remains unaddressed, the system will continue to favor the few over the many. However, there is hope. Reforms such as land redistribution, progressive taxation, and greater investment in marginalized communities can make democracy more than just a vote. It can become a system that works for everyone. That said, achieving these reforms through political channels is unlikely due to the fact that the overwhelming influence of markets, for instance, rears its ugly head constantly. For instance, public hearings on the amendment of Section 25 showed overwhelming support for land expropriation without compensation, yet this issue is no longer even on the table. So we must remember that democracy is not just about political rights, it's about ensuring that all citizens have economic power to make their voices truly heard. And as I wrap up, I would like to open or leave you with this question. Is there a peaceful path forward for Africa's most celebrated constitutional democracy? And what does that path look like in a constitution or in an environment that creates this sort of loop-sided, and if you want to put it higher, it's a trap, it's an entrapment. So my question to you that I want to leave you with is there a peaceful path forward other than the violence that I envisage there on the picture there on the screen? And how do we go forward? And with that, I'd like to perhaps close. I know we're at 10 minutes. I hope I'm still under 10 minutes. Mr.
You're over.
Musabi.
You're over, sir. And I thought your ending was perfect, both as to time and also as to that wonderful intellectual challenge you left us with. But would you like to say one more thing real quick in a minute or something? Slightly less than that?
No, that's it from my side. Thank you very much, colleagues, for giving me an ear.
Thanks again for challenging us on model performance on both counts, as I suggested earlier. Thank you for that contribution, which allows us to move forward with our program, to call, and I hope these colleagues are here. This colleague is here, Ms. Wadawala Zubaida Musa. I believe you may be online, is that correct?
I'm here. Thank you so much for that.
Thank you.
I hope you can hear me.
Do you need to share something or anything of the sort?
Yes, I'm going to share my slides. Am I audible enough?
Yes, you are. Thank you. Please, over you may begin speaking. Over to you, ma'am.
I'm attempting to share my slides.
Are you fine? Is there any way we can help the student? There may be a way to get you some help.
I'm so sorry about this. I don't know why I'm unable to share. Let me try one last time. Let's minimize the screen.
Maybe a good shape.
So while the speaker does that, Kanya, I see there's a message online from one of the other speakers. She's online, but she wants to be granted permission to be a panelist.
Thank you. Thank you very much. I'll pass it on. Thank you, Lila. Appreciate it. Just as a matter of caution, are the other online speakers wanting to share their presentations when their turns come up? Just checking. If that changes, please let us know so we can prepare. Thank you. I suggest that we take another presentation instead and then swing back to you if you don't mind, please. Colleagues, we're going to use this crisis as an opportunity to move on to the next speaker. Happily, she's here, ready. She has nothing to share except a piece of paper. So I want to welcome Ms. Clelia Mwache. I don't know whether your co-presenter is here or whether you're presenting on your own. Ms. Mwache is an independent. That's all she's saying, and that's the story. She's sticking to it. Over to you.
Thank you. Thank you. I'd just like to start off by saying that my co-presenter, Notando Shoma, and I are very honored to have this opportunity we are really babies when it comes to the academic game. So to hear that we are one of 120 people who are chosen to be part of this is really wild and really exciting for us. That being said, our papers on the Constitution as a source of accountability, the role of constitutionalism in South Africa. This paper describes the South African Constitution as a transformative document that embodies the nation's aspirations for democratic values, social justice, and fundamental human rights. It frames constitutionalism in this context as playing a significant role in creating structures that uphold the rule of law, meaning that everyone and various structures of government are subject to the rule of law, right? Specifically, Section 2 of the Constitution provides that the Constitution is the supreme law of the Republic, that law or conduct that is inconsistent with it is invalid, and that obligations imposed upon it must be fulfilled, and how that is a pretext for how accountability is supposed to function, guiding all conduct, procedures, and expressions. As such, the supremacy of the Constitution forms the basis of the legal systems within which the judiciary, the state, and citizenry operate. And the purpose of this paper is to examine the role of constitutionalism in fostering accountability within South Africa's democratic framework, which is done through exploring the challenges of realizing constitutional accountability in practice, focusing particularly on the State Liability Act and its impact on constitutional accountability as it regards the state and its actors, looking at the disjuncture between resource constraints, the exercise of power, and the guidelines established by the Constitution. We look at the role of the Constitutional Court in interpreting and assisting in developing legislation and those limitations, evaluating legal mechanisms in place for ensuring state accountability in situations where claims sounding in money are claimed from the state, assessing their accessibility and effectiveness of procedures provided for in legislation. We also look at the accountability as it regards civic engagements and how that can aid the discourse. We argue that accountability at its core is a critical component of governance because it fosters transparency and encourages ethical conduct. We further argue that accountability is important in the context of South Africa because of its historical significance given apartheid and the nationalist regime that eroded transparency and accountability through past racial laws, which effectively oppressed and marginalized the majority of South Africans without limitation or sound justification, which resulted in political distrust and inequalities which persist today. As such, the principles of accountability should be seen as a cornerstone of democratic governance and good governance because it allows for institutions to explain their decisions, failures, or wrongdoings to stakeholders alike. In this way, accountability is intricately linked to the concept of constitutionalism and ensures that there are appropriate checks and balances on the exercise of power. Furthermore, examples of corruptions or rather anti-corruption mechanisms and commissions such as the Commission into State Capture and the Zondo Commission are products of constitutional mechanisms used to enforce transparency and accountability in governance. These are used as a means of showing how public execution and the eventual judicial review of corruption can be used to enforce accountability. This is achieved through a combination of independent bodies and judicial oversight. In this way, constitutionalism can be seen as the principle that a government should be bound by a constitution, ensuring that authority is exercised according to established laws, ensuring that equal application of laws to all citizens alike. Then we go into the analysis of the State of Liability Act. The essential premise being that the executive arm of government should be accountable to citizens, the judiciary, and ultimately the Constitution itself. So here I want to start off by saying that the State Liability Act 20 of 1957 provided for state immunity for all contracts entered into by the state or wrongs committed by the state or its people acting in an official capacity. And Section 3 of the Act did not allow for any judgment, debt, sounding, and money to be actioned against the state. However, in 2008, the landmark judgment of Nyati versus the MEC of the Department of Health, Gauteng, made it clear that Section 3 of the State Liability Act was unconstitutional. Because it differentiates unjustifiably between judgment creditors who obtain judgments against the state and those who obtain judgments against private litigants. The State Liability Act was amended in 2011 in accordance with the Constitutional Court judgment, specifically because it deals with enforcing monetary judgments against the state, and was amended to provide a procedure for judgment debts against the state to be accounted for. The key features of the Act are now that the removal on the prohibition of the attachment of state property, the inclusion of structured notification process to register claims against the state for claim sounding and money, and a 30-day time frame for the state to satisfy court orders. Although now the Act provides for a procedure for judgment, debt, sounding, and money to be made against the state, it remains challenging for a number of reasons. We argue the following: that the procedure set out in the Act inherently leads to procedural hurdles and time delays because it can limit an individual's ability to enforce judgments against the state, potentially discouraging citizens from seeking legal recourse, which undermines a constitutional right because it also raises questions about equality before the law as a result of extended timeframes, because it takes plus minus 80 days to initiate an action, right? That the timeframes create a situation whereby the state is placed in an ideal position for non-compliance, thus weakening the role of the judiciary as a check on state power, because the state cites things like resource constraints as a means of running away from its responsibility to pay out claims. That the timelines provided for in the Act do not provide a remedy for applicants who seek relief on an urgent basis, causing a conflict between court orders that are granted in matters brought on an urgent basis, and the procedures set forth in the Act then conflict with that.
1 minute.
We therefore argue that the State Liability Act remains unconstitutional and leaves the state actors unaccountable. Nkabinde J once said that the effectiveness of court orders or decisions are substantially determined by the assurance that they will be enforced. We then state that the state also cannot rely on the fact that it has limited resources and means of running away from responsibility unless it can provide proof of such constraints. There's an imbalance of power, which means that the courts need to be relied on heavily under these circumstances. The Constitutional Court, as an apex court, plays a pivotal role in interpreting, protecting, and enforcing the Constitution, but may not prescribe an outcome in how Parliament should exercise a particular power or impose substantive content to a particular provision under dispute. The ultimate power to reform the legislation lays with the relevant branch of government, and that separation of powers exists to protect constitutionalism. Nevertheless, the socioeconomic landscape in South Africa and the challenges faced by the ordinary citizen basically means that access to the courts dictates a need for robust civic engagement and a need to engage public interest organizations. In conclusion, balancing access to the courts and a civil society which is often inundated with work requires using both formal tools such as court proceedings or public interest litigation, as well as informal tools such as advocacy campaigns, public meetings, social media activism, petitions, and the paper goes into citizens needing to co-create an accountable society through these mechanisms and how civic engagement aids constitutionalism and accountability. Thanks.
Okay. I'd like you in conclusion to leading up to it. Very, very well managed. Thank you very much. Especially all the time as well. Thank you. So with that, colleagues, I believe we are free, if our colleague is linked up, Ms. Musa, to move on to her presentation. She is not independent. She is from the School of Law at the University of Witwatersrand, and we'll be talking this afternoon about transformative impact of climate change on the South African Constitution. Mr. Musa, are you ready? First of all, I hope you're in the room again.
Hello.
Please give us some indication.
I'm struggling to hear you. I hope you can hear me now, and I hope you can see my slides.
I can hear you, and we can hear you well. Thank you.
Okay, I'm glad. Can you see my slides? I'm sorry?
No.
Are you able to see my slides?
No, apparently not. Are you able to speak with reference to your slides, but not
Yes,
showing?
I will have to do that. On my side, it says I'm sharing and it's showing me, but be that as it may, I'm going to speak. So by way of introduction, I do apologize for this glitch. I have no idea what's going on, but it is truly an honor for me to be part of this panel and in fact to present at my alma mater and of course to celebrate Prof. Vomberg. Many thanks to all and especially to my former lecturer, Professor Frans Viljoen. So with myself being very mindful of time and trying to stick to my 10 minutes, my topic for today is within the context of the Comparative Constitutionalism in South Africa conference on, oh dear, glitch number 2. Okay, I'm going to have to just, okay, there we go, I'm sorted. Talking about the transformative impact of climate change on the South African Constitution. And of course, climate change has been on everybody's lips, everybody's mind, everybody's been worried about it. What is climate change? Two little words, and one big concept. Time does not permit me to go into the harms of climate change, but for purposes of this presentation, I will be exploring the South African Constitution's response to climate change, particularly within Section 24 of the Constitution, environmental rights, and Section 33 of the Constitution, just administrative action. So within the climate context, and it is very necessary to understand this, the first thing of importance is that in order to combat the devastating impact of climate change, the United Nations established the United Nations Framework Convention on Climate Change in 1992 to enhance global responses to climate change. This led to many significant milestones. I will only talk about the first COP, which was held in 1995, the Kyoto Protocol, which was signed or drafted in 1997, and of course, the Paris Agreement of 2015. South Africa then ratified to the United Nations Framework Convention on Climate Change in 1997. It acceded to the Kyoto Protocol also in 1997 and joined the Paris Agreement in 2016. As a result of these, South Africa has international legal obligations to develop policies for mitigating and adapting to climate change. As a nation, we must report every 5 years on our emissions and progress in implementing our nationally determined contributions, or NDCs. Since the Paris Agreement in 2015, the world has seen a rise in global climate litigation. Climate litigation has surged across various jurisdictions, introducing innovative legal options. Notably, the 2019 Netherlands case of Agenda, which marked a significant human rights turn in the global north, with many jurisdictions following suit. By 2024, climate litigation has actually reached an international stage, with advisory opinions being issued by the European Court of Human Rights, the Inter-American Court of Human Rights, and the upcoming or forthcoming International Court of Justice, expected to deliver its advisory opinions in December 2024. Looking at current climate litigation in South Africa, we have 10 climate cases. These are, of course, within the ambit of what is climate litigation and are on the international databases as such. 7 of these decisions have been taken. 1 has been postponed indefinitely, and there are 2 climate cases pending. For purposes of this paper and this presentation, I'm going to look very briefly into 2 South African climate cases, the first being the Earthlife Johannesburg versus the Minister of Environmental Affairs case, and the second Sustaining the Wild Coast versus Minister of Mineral Resources and Energy case. Briefly, a look at the Earthlife case. This judgments were given firstly in 2017 and the final judgment in 2020. At issue was the environmental impacts of building a coal-powered fire station and the granting of an environmental authorization for this purpose. In 2017, the court ruled in favor of the applicant Earthlife that the authorization would have to be revisited, and one of the reasons for this was the contention on the issue of climate change impacts. In 2018, however, the minister upheld the environmental authorization, and in November 2020, the High Court ordered the environmental authorization to be reviewed and set aside. The key takeaways from this case: Section 24 of NEMA, which is the National Environmental Management Act, looked at stipulated environmental impacts of a listed activity, which was the case in this particular case, must be considered and investigated and assessed before granting an environmental authorization. Section 24O of NEMA when interpreted meant that this would mean a mandatory climate change impact assessment. This was further looked at within Section 24 of South Africa's Constitution and South Africa's international obligations, as I had just outlined. Eventually, this matter was ruled for reconsideration, and this was under review, Section 8 of PAJA. Lastly, South Africa's climate change and energy policies were also looked at, particularly coal-powered fire stations being the largest emitters of greenhouse gases in South Africa. South Africa at that stage had a white paper which called for the shift to low-carbon electricity generation options. Then we'll move briefly to the Wild Coast case. This was decided in 2022, September 2022, but is currently on appeal. Firstly, what had happened was Shell, the company, undertook exploration for fossil fuels by means of seismic surveys of South Africa's east coast, home for rural communities subsisting on fishing and other marine activities for its livelihood. The parties then brought an application for reviewing the decision, grant the exploration rights, which was granted in terms of PAJA. The court considered, amongst others, whether a fair procedure was considered and whether climate change impacts were considered. Back to the Earthlife case, in its prayers, the applicant's earthlight sought for the matter to be remitted to the Chief Director, relying firstly on Section 8(1)(c) of PAJA, and in reaching its judgment, the court considered the grounds of review which were raised by the applicant. The court then looked at South African government's climate change and energy policies and the decision of the Chief Director to grant the environmental authorization. Looking at the Wild Coast case, the important parts I'd like to highlight from the judgment is that there were no proper climate change impacts. The burning of discovered reserves of oil and gas would not be conducive to sustaining global temperatures and is required by South Africa's international obligations. And the decision to grant the exploration rights as well as renewals thereof fell under review in terms of Section 6(2) of PAJA. Ultimately, what we find from this is that, yes, indeed, the South African Constitution was transformative enough. It enabled the judiciary to rely on provisions of the Constitution with which to grapple with constantly emerging social, environmental, and climate injustices, and to thereby uphold the values of human dignity and the rule of law. Primarily, the Constitution stepped in where there was no Climate Change Act. As you might be aware, the Climate Change Act was signed into law by President Ramaphosa in July this year and is currently not yet in operation. The Constitution, in its Bill of Rights provisions, namely Section 24, the right to the environment, and Section 23, just administrative action, were what enabled it to be called a transformative constitution. In conclusion, then, in interpreting the values enshrined in our Constitution, the Constitution itself has proved to be a living document with the ability to adapt to the changing needs of the South African society. This can be seen in the BEE process from a few years ago, the recent climate change movement and the cases I had just outlined, and of course, the emerging just transition framework. With that, I do conclude my presentation, and thank you so much for your time. And I do apologize, but thank you for your patience in the glitches with regards to my slides. Thank you for that.
Very much. A round of applause for Ms. Thank you again for, as I did our other colleagues, for a crisp, concise presentation and for excellent time management, especially given the initial teething problems. So another big round of thanks to our colleague. This enables us to move forward with our program. The next speaker is here in the room with us. I'm taking it to Mr. Stroll. Mr. Tolle, welcome. You are, according to the document from the University of Victoria, and this afternoon, you're talking about rethinking transformative mandate of the Judicial Services Commission. Welcome. Over to you.
Thank you, distinguished guests, academics, practitioners, and students. The topic of my draft paper is Rethinking the Transformative Mandate of the Judicial Services Commission. And that's the subject matter of this talk. So in the course of this talk, I intend to address two topics. First is the social transformative objective of the Constitution. Then second, the transformative mandate of the Judicial Services Commission in its recommendation of candidates for judicial appointments. Now, addressing the first topic, which is the social transformative objective of the Constitution. My first point of reference is the 1996 Constitution, particularly the preamble, which sets out the objective of the Constitution. And I'd like to highlight three, which are particularly relevant to this talk. And the first, as mentioned in the preamble, is that the Constitution seeks to recognize the injustice of the past, to heal the division of the past, and to improve the quality of the life of all citizens and free the potential of each person. Now, as you have heard, reference is made to the past, meaning the past legal order, under which the state president and the cabinet and the senior judges of the courts were involved in the appointment of judges during the past legal order. So in the past legal order, what was followed then was what is called the tap in the shoulder system, under which the Minister of Justice recommended judges to judicial appointment. So it is by no surprise that the judges who were appointed were conservative judges who preserved the status quo ante, the perpetuation of discrimination, segregation, and the apartheid legal system. So then the bench mostly comprised of white male judges drawn from the ranks of the advocates profession. And by 1990, there was only one black judge, Ismail Mohammed. And in 1990, through the political transition, that's where we saw a little change, under which out of 165 judges, only out of 165 judges, 160 were white male judges. And the 3 were black men and 2 were white women. So during the past legal order, it is beyond any level of debate that the law, the judges, and the body responsible for the appointment of judges were complicit in the injustices of the past. Now, coming to the constitutional dispensation, the appointment of judges that was adopted in the past legal order was considered unacceptable because it lacked transparency. And so the JSC is the body tasked with the appointment of judges now under the current constitutional dispensation. And the composition of the JSC is found under section 178 of the Constitution. So the JSC, one of its tasks is to transform the judiciary. And the provision enjoined, which encourages the JSC to transform the judiciary, is found under section 174 sub 2, which says that in the appointment of judges, the bench must reflect the demographics of the country. So in my paper, I accept that significant strides have been achieved in making sure that the bench of the judiciary reflects the demographics of the country. So as of 2023, we have 253 judges and 113 are women, more or less 45%. And then 39% were black, and then 13% were white, and 32% were black females. So on this score, I accept unreservedly that indeed the judiciary now reflects the demographics of the country. So my concern, which I highlight in my paper, is that there's a gap between the judiciary, the transformation of the judiciary, and social transformation. The marginalized still remain marginalized. The injustices that were perpetrated during the apartheid remains unaddressed by the law. And to echo Adila Hassim sentiment that she expressed in the SWCM curriculum this year, that if you approach the law thinking that one case can change the world, then you must revise your thinking of the law, because the law is too conservative. So on that conservationalism of the law, to address that, I consider the role of the JSC. JSC has done enough, but not enough to effect social transformation. The courts now reflect the demographics of the country, but then the marginalized, their plight, remain unaddressed. So my proposal, coming from the draft article that I'm writing, is that the JSC in its appointment of judges should consider the impact that the likely candidate will have on the transformation of the society, and the impact the candidate will have on the judiciary as a whole. Simply put, it's not enough to just courts or the judiciary to reflect the demographics of the country. More needs or remains to be done to ensure that the people who sit in court, through their judicial decisions, effect social transformation. And there are cases in the early constitutional days where we see a shift to social transformation. And one of it we see in Port Elizabeth municipality versus various occupiers, where Albie Sachs wrote that we have to consider grace and compassion. We have to infuse the elements of grace and compassion to the formal structures of the law. So that provision is not set out in any law, but just Albie Sachs' judicial activism in making sure that the plight of the marginalized is addressed. We see it again in the Croat War case, where provision was made that people who seek temporary shelters must be catered for. It wasn't set out in any legislation, nor the common law, because I know the common law is mostly conservative, because it dates back to the Roman Dutch law system. But again, we see the value of Ubuntu, which was explained more adequately in State versus Makwanyane by Judge Yvonne, the late Judge Yvonne Mufara. That in interpreting the legislation, we must consider the principle of Ubuntu. And the later of the subsequent judgments of the Constitutional Court, Bedeika is one case under which Ubuntu was confirmed as the founding constitutional value. So every now and then we see glimpses of judicial activism. And the role that the JSC, and this is the point, my departing point, is that the JSC have to up its game in ensuring that the people they appoint are people who endorse the living constitutional and living constitution doctrine, which seeks to accommodate the ever-changing circumstances of the society, to make sure that there's no gap between what transpires in our society and the decisions being issued by the people who sit in court. Thank you for your attention.
Yeah, thank you very much, Mr. Stoddard. You can't take it. Belongs to me for now. Thank you very much, Mr. Stoddard, for again exemplary time management and a short, sharp, and sweet speech. So thank you very much, and another round of applause, please. This enables us, colleagues, to move forward further in our program. I take it that Ms. Chayroot Nicholas is here with us. I think we saw you earlier, but we want to make sure that what we saw was indeed you. Right. Mr. Chairut is an LLM, Nicholas, rather, is an LLM student in human rights and democratization in the Center for Human Rights of the University of Victoria, talking to us this afternoon about independence without accountability, the state and place of the impeachment of judges in South Africa. If you are ready, colleague, I'm ready to hand over to you. Are you ready? May I surrender the mic?
Yes, I'm ready. Thank you. Just to confirm that you can hear me and see my screen.
Very well. Thank you very much. Over to you.
All right. Thank you. Thank you so much, Kanya, and for this wonderful opportunity, and also for the organizers of the event for affording me this opportunity. I must say that it's an honor to make this presentation in celebration of the academic figure in Professor Charles Fombard, who also happens to be my lecturer in my LLM program. So as he said earlier, I'm talking about independence and accountability of the judiciary, and I'm looking at the impeachment of judges and in South Africa. And later on, if time allows, then I'll make reference to what's happening in Kenya. Topic of judicial independence has been discussed quite a bit in the previous sessions, and I wouldn't want to delve so much into that. Safe to say that one of the fundamental tenets of judicial independence is security of tenure of judges. And what this denotes is that judges cannot be arbitrarily removed out of office, and there must be a valid reason why they are removed from office, and due procedures have to be followed. But as some scholars have stated, this protection is enjoyed by judges during their good behavior moments, so that in the event that they violate the Constitution and breach the judicial code of conduct, then they are going to be removed from office and they cease to enjoy this protection. And this is, of course, provided under Section 177 of the South African Constitution, which requires that, among others, judges can be removed from office on grounds of incapacity, gross incompetence, and misconduct. When you look at history, you realize that impeachment of judges has not been has not been prominent, and I was able to find only 2 impeachments in the 19th century, with none in the 20th century. But under the 1996 Constitution, we have the recent impeachment of Dr. John Klope and Kola Mutata, who were impeached in February and March 2024. Just a brief basis, Dr. Klope, I'm sure we are aware of him. He was impeached for trying to, among others, trying to interfere with the Constitutional Court judges to rule in favor of former President Zuma. Mutata, on his hand, was impeached for trying to drunk driving and making racist statements. And all these conducts are conducts which are not becoming of a judge, and they were successfully impeached by Parliament following a recommendation of the JSC. That's in March 2024. So what this then does is to show and send a clear message to the public and judicial officers that the judiciary is not only independent, but it's also accountable to the Constitution and the public who are who pay who are the watchdogs of the judiciary. So this is something worth commendable on the part of South Africa, and it's a step in the right direction in ensuring that judges are held accountable. But while this is to be celebrated, there are some of a few underlying issues which I think they need to be addressed, if at all impeachment of judges is to serve its legitimate purpose. One of these issues is the long time taken to through the impeachment process, because when you look at these two cases, they took at least 16 years to be completed from the moment they were commenced by the JSC. And this, of course, serves an injustice. And as the saying goes, justice delayed is justice denied. So the long period upon which these matters took, an injustice was occasioned in that sense. That's on the public and on the Constitution. Something else is a financial burden, which went into the impeachment process, because in the case of John Klope alone, the amount of money that went into his impeachment are more than 10 million rands. And this is quite a huge amount of money, so that while this is the cumulative amount through the impeachment process, this amount is enough to finance the Judicial Service Commission for a whole financial year. Because when you look at the 2021-2022 financial year, you realize that the JSC was allocated 9.4 million rands, so which means that this amount is able to fund the JSC for a whole financial year, and even some amount will be left unspent. Something else is on court cases which were filed, and just one or two words on this. When you look at these cases, they were not really based on merit, but they were looking at the procedural issues, which of course interfered with the process. And what all these issues do is to portray the judiciary before the public as a body that's, excuse me, independent, but whose members are not accountable. And in effect, the judiciary will lose public trust and public confidence. And I bet that's not properly a good position for the judiciary to be in. Because as the former retired Justice Krigler said in S versus Mamabolo, without public trust, there is no guarantee for judiciary to perform properly. And where the judiciary cannot function properly, then the rule of law is eventually going to die. This is important because when you look at the recent statistics by Afrobarometer and Statistics SA, they show that over the between 15 and 25 years ago, up to from 15 to 25 years ago up to now, the public trust and confidence in the judiciary has been dropping. So these issues ought to be addressed to ensure that the public continues to have confidence in the judiciary, and to ensure that judges are operating in a constitutional and in an accountable manner. A brief look at what has happened in Kenya, especially in the recent past, and I looked at one of the recent cases. That's in 2023, which is the removal from office of former Justice A. Chitembwe. And without going into so much details, the whole process of removing him from office on grounds of misconduct took a period of 2 years, less than 2 years, because it was started in 2023 and it ended in 2021, sorry, and it ended in 2023. So this therefore shows that it can be done in the shortest time practicable, and this justice and accountability ought not to be delayed. And I think that's a lesson that South Africa can pick. And as I finish, because I can see my time is running out, something else that I think South Africa can learn from the Kenyan experience is on suspension of judges. Because for someone like John Klope, he was in office between 2008 and 2022. So that casts doubt on the cases that he was handling during that time, which taints the image of the judiciary. And lastly is on disciplining of judges, because in South Africa, and I think this is a lesson that Kenya and other jurisdictions can learn, is that South Africa, as per the recent amendments to the SC Act, allows for disciplining of judges whose misconduct is not as, who of course engage in misconduct, but the misconduct is not gross enough as to warrant impeachment. So this is something that Kenya and other jurisdictions can pick. And in conclusion, I would say that South Africa is headed in the right direction, but these underlying issues which interfere with the process ought to be addressed, if at all impeachment is to serve its constitutional purpose. So with that, I thank you, and I look forward to further engagement during the Q&A session. So over to you, Kanya.
Thank you so much, Mr. Nicholas. And I want to thank you also for keeping the tradition. I'm in good company this afternoon. Thank you very, very much. And let me just apologize for calling you Ms. I will improve the specs that I wear. So apologies for that, sincere apologies. Colleagues, it appears that we may have gained some time, though we'll remain late, only because Prof. Agbo and Ms. Matlala may very well not be with us. Oh, she is with us. There you are. Is it Rurisana? Mr.
Good afternoon, everyone. Yes.
I thought, yes. And is Prof. Agbo with you?
No, I will be, presenting on behalf of the both of us.
Fantastic. Well, we are delighted and thrilled, and I would like perhaps to give you a moment to set up. Do you have slides to project, to share?
No, I do not have any slides, so yeah,
Fantastic.
I'm ready. Thank you.
Well, Ms. Matlala is from the School of Law of the University of KwaZulu-Natal, where she's a law lecturer in Durban, South Africa. And she will be speaking to us on behalf of herself and her co-author, Prof. Agbo, on probing into the scourge of socioeconomic injustices in South Africa, how a corrupt political elite ushered the phrase, "we the people of South Africa," into obscurity and oblivion. And on that relatively dramatic and I think quite appetite-whetting note, let me hand over to you. 10 minutes, please.
Thank you very much, moderator, for that wonderful introduction. I must say this is an honor and a privilege to be joining this celebration of an academic giant, Professor Bombard. Now, without further ado, let's dive straight into the heart of the presentation. Now, I would like to, build on to the arguments of, a presenter that presented as he, alluded to the unfinished business of the apartheid regime. And he also alluded to, the importance of Ubuntu. And I would like to say that is where my argument, or that aligns with my argument. Now, without wasting time, my presentation starts with the phrase, "we the people." This phrase echoes across the political landscape of many nations, encapsulating the idea of popular sovereignty. Now, popular sovereignty is the idea of the government or the idea rather, that the government is established by the people and exists solely to serve the will of the people. These words originally made famous in the preamble of the Constitution of the United States. They later transcended time and the borders, becoming a foundational expression of democracy. But in South Africa, these words take a deeper resonance, carrying the weight of the nation's struggle for justice, equality, and human dignity. The phrase, "we the people of South Africa," opens the preamble of the 1996 Constitution, symbolizing the beginning of the South Africa's transition to constitutional democracy. The statement not only asserts the sovereignty of the people, but also embodies a commitment of a new governance model where the government is accountable to its citizens and derives its authority from them. However, given this position, we therefore must critically assess this promise that we must critically assess whether this promise has manifested in practice, if it has at all. Moreover, we need to consider whether the concept of popular sovereignty has genuinely impacted South Africa's socio-political landscape. Now, if the words of now I need to also shine light of the words of one of the speakers in yesterday's session. The speaker asserted firmly that it seems like as a nation, we have forgotten our preamble. And my argument is, aligns with these words. Now, with that being said, these pressing questions that I have highlighted demand our attention as we navigate the complexities of our democratic journey. Now, with that being said, I think everyone here, and considering the arguments that have been raised, we are all aware that the Constitution is not merely a legal document, but it represents a social contract. And the terms of the social contract are very clear. The public officials are mandated to serve the welfare of the people, ensuring justice and equity and the protection of human rights. Therefore, as a clause in this binding contract, the phrase "we the people" is not just only a symbolic statement, but it signifies that every exercise of public power must be rooted in the consent of the governed. This phrase also serves as an affirmation that the institutions, the laws, and the processes of the government, they must draw their legitimacy from the people, who are the true holders of political authority. Therefore, representatives, whether elected or appointed, are merely the people's agents, entrusted to act on behalf of the people of the nation and act in their benefit. Forgive me. Now, still focusing on the nation, or focusing on the nature of the Constitution, rather, this document embodies a collective will of the people, requiring that the government needs to protect the rights and the interest of citizens. Now, what makes the South African Constitution unique is its broad scope, as we have seen in today's deliberations. And the Constitution not only covers civil and political rights, but also covers social and economic rights. This reflects a deep commitment to social justice. However, this commitment raises critical questions about its implementation. Now, when it comes to implementation, we need to see that if the promise of "we the people of South Africa" has it been taken in consideration of by the political elite when exercising their powers. It has been nearly 3 decades of democracy, that is 30 years, and it also has been 28 years since our Constitution has been adopted. We need to ask ourselves questions like, has the authority and power that was given by the Constitution, has it been used to serve the interests of all citizens as it was originally intended? Or has the vision of "we the people of South Africa" been overshadowed by self-interest and neglect? And if the last question that I have put to you was answered in the affirmative, does that mean that the elected representatives have violated the terms of the social contract, as we say that the Constitution is like a social contract that has been reduced to writing? Does this mean that the current political representatives have failed to meet the contents or the clauses of this social contract? Now, in order to answer that, we need to look at the country's socio-economic landscape. Now, the situation reveals difficult truths. As we know, South Africa is known for its very high unemployment rate, estimated around 37%. Many people continue also to live in poverty, and inequality is deeply rooted, making South Africa one of the most unequal countries in the world. And race, despite the adoption of this constitutional principle, race still plays a major role in the socio-economic gaps. And many individuals still lack access to quality education, healthcare, basic services, which keeps them in this trapped cycle of disadvantage. Now, in the wake of these issues, there is a rising discontent with the government's performance and a surge in protests, particularly when it comes to issues of service delivery, indicating that citizens remain actively engaged and are demanding for accountability and transparency. People are seeking a government that genuinely meets their needs. Therefore, in addressing these challenges, our papers, provides that it is important to remember that South Africa's democratic ideals are not only Western imports, but they are deeply rooted in African values, particularly the philosophy of Ubuntu. Ubuntu often expresses as "I am because we are," emphasizing that as people of the nation, we are connected, and also emphasizing the notion of collective responsibility. In this view, the welfare of an individual is tied to the welfare of the community. And justice is not just only a matter of individual rights, but also a communal well-being. Ubuntu teaches us that the nation's resources belong to everyone, that the government's job is to make sure that these resources are shared fairly. This belief is crucial for understanding South Africa's dedication to social and economic justice, as this principle highlights the moral duty of political leaders to act in the best interest of the people. Therefore, we the people of South Africa is more than a constitutional phrase. As a matter of fact, it is a call of action, as it reminds us the legitimacy of the government. It basically reminds us that the legitimacy of the government rests on the consent and the active participation of the people. Now, in conclusion, concluding, I'd like to bring light to the views of Professor Charles Format, as he echoed that without effective implementation of constitutions, and this basically includes all the African constitutions, he said that without active implementation, these constitutions merely serve as a piece of printed futility, and he based this on the view that basically we can have perfect laws, but without honoring the true will of the people and highlighting the true popular sovereignty, basically this would render the context or the text of the Constitution invalid or useless. Because at the end of the day, whether our laws are perfect, it remains on the political will of those that are elected to implement those laws. Therefore, for South Africa to truly heal the divisions of the past and build a future that is based on social justice, we, the people, must again become a driving force behind political decisions, as it was when we fought for the freedom that we have today. And I have had, I was honored to, hear presentations where, we were glorifying the Constitution. I'd like to say, yes, although it is essential to glorify the Constitution for its achievements, but we also as scholars need to critique its shortcomings, because this balance will, determine the future of our nation. So if we continue glorifying for the Constitution and without finding fault in the Constitution, I believe that we will be trapped in the reality that we face today, where there is a lot of unfinished business. Thank you.
Matlala, thank you very much for ending like Dr. Mhlanga on a provocative note. I'm sure we'll pick up some of those themes during the course of discussion this afternoon. I also want to thank you for your equally exemplary time management. I was a bit concerned about this afternoon, but I feel less so now, and that is thanks to you and all the members of the panel, Dr. Mhlanga, who's still here. I'm checking. Ms. Musa, Ms. Mwake, Mr. Strolle is here, and Mr. Nicholas. I believe that we can take a little bit of time. We are 15 minutes behind time. We should be breaking for refreshments. And I'm sort of glancing suggestively at Prof. for you. May we go for what, 10 minutes? Something like that. Thank you. Or about there. So what I'd like to propose is that we move quite quickly through the process. We take 3 questions at a time and then come back and do another round of 3, try a third round if time allows, and then see where we get to from there. There is one hand at the back, and I have a mic here. Oh. Next hand is over here. Please proceed, sir.
No, oh, do you have constance to the question or comment to gentlemen sitting at the far right on the stage? I think you can see generally when the GX is thrusted into discussion. Judges and judicial committees tend to be very defensive. But I think it's very evident how much the movement into transformation to process to be a judge is not parallel or is not sync with the movement of where the country is in terms of liberalization of social rights and fighting corruption. So I think it was really deeper and definitely 100%.
Yes. Thank you very much. I direct my question to Mr. Stone. You spoke very concisely about the JSC, that when they pick or choose people, they need to look at someone who actually had an impact on the judicial or transformation. So I was wondering at the criteria that they're going to use. If you maybe perhaps in your paper thought of the scorecard that they are going to use or the criteria to see if indeed this person is going to bring transformation, what are you going to look at during the interview process or the shortlisting? Thank you.
Greetings once again. I would love to compliment the young Indian from, I think, as young people, especially in South Africa, we've detached ourselves from such topics. And it's very empowering to find such young scholars who are in academic institutions involving themselves in such conversations. But in what he was saying, what I picked up was accountability, transparency, and the success and the shortfalls of the JSC. Then my questions to him are, how does the JSC ensure transparency?
1 or 2 or 3 or 4 or 5?
What?
How many questions?
Let me give you 2.
No, let's keep it to 1.
Okay. How does the JSC ensure transparency and accountability in its processes? That is the way that, are there any concern about political interference, favoritism, and lack of objectivity in the JSC decision-making processes? I think, second round of questions.
No, I don't have a mic, so who wants to go first? Maybe the person they call a young man.
So, to answer the gentleman's question, the criteria, section 174, sub 1 of the Constitution mentions that any candidate who wants to be a judge must be a frequent and proper candidate. And unquestionably, people who apply to be judges are demonstrated and proper. But when it comes to transformation, that's where the lack of transparency comes in. But usually, I think that there are candidates are drawn from 2 poles. It's either you're an academic or an practitioner, mostly an attorney or an advocate. So for transformative purposes, and to assess whether one aligns with the transformative objective of the Constitution, because the Constitution is a transformative document, where those views can be ascertained is through one's paper trail, i.e. scholarship. So when one is written articles, books, you can see where it falls in terms of when it is conservative, or someone who seeks to effect transformation in the society. And when it comes to practitioners, the only way to find out whether one endorses the transformative mandate is through question. And we know that the JSC question is rigorous. But lately, we've seen that they detract from the mandate of ensuring that they find suitable candidates. Sometimes they ask relevant questions, whether one knows Africans. So I think their role as well has to be assessed in order to align with the transformative mandate of the Constitution. 2. So the second one for transparency. Section 1 of the Constitution 176 says the JSC is the master of its own procedure, so they set out their own procedures. And one of their procedures is that when they decide on one's candidate or suitability, they do it in deliberation, and the recordings of the deliberations are kept secret, so that it may not be available to the public. So that impedes the transparency of the procedure, because we don't know which assessment or which criteria was applied in qualifying one for judicial appointment. And as far as political interference is concerned, I think for me personally, it's a good balance of the academics and the elite and professional and politicians. But there is growing concern that there's too many politicians. But for me, since the politicians are representatives of the electorate, I think their role is best suited in the JSC so that they can safeguard the interests of the public.
Thank you very much. And I think the third question was addressed, which was a comment. Okay, that helps us. No response to the comment from anyone in the panel, either online or in the room. If not, then I think we should just check, are there any questions from the people online? Or is it only speakers online? If not, then we'll move back in-house. So sorry, I've forgotten the name. Please, go to
I have a question for Dr. Bundari in Florida. Can you hear me? Because we had an issue with online participants hearing questions the first time on. Dr. Bundari, are you still there?
It looks like yes. Is that towards me? Sorry.
Yes, I want to ask a question. Just want to make sure that you are there, you can hear us.
Okay, the voice is a bit faint on my side, but you can go ahead then.
Okay. I actually found your presentation to be quite triggering because you had the picture of the NHI, the article about the NHI on your presentation. And coming from a medical background, you know, I mean, there's so many stories that I can tell about the issues that we have with our public health sector at the moment. And how those disparities definitely are along race and class lines. And so if you look at the challenges to the NHI, like the solidarity case that was just decided recently, where you have a group of health professionals, private professionals, challenging it based on their investments and their practices being, what's the word? I don't know what the right word is, but I mean that they would kind of have those investments would fall away because of the certificate of need associated with the NHI. And, you know, knowing what I and my friends have gone through in the public sector, I think it is doctors in the public sector that have their rights actually most severely constrained. But now you see that these are not the doctors that can go to court and challenge things. So you made a statement about wealth and power, and you made very recommendations along very broad strokes. But I wanted to hear from you, what do you think in terms of, you know, specific ideas of how constitutionalism can address the exercise of power with those that have needs, and those that have wealth versus those that don't. Thanks.
We take another 2 questions. Yes, sir. And is there another one? I know you want to come back, but let's just see if we can't democratize it further. Maybe we'll get back to you. Please proceed, sir. Oh.
Thanks. So, to you again, Dr. Milani. So you made mention of, or just clarification what you said, you said financial market pressures governments to making policies favorable to market participants as a whole at the expense of the quality of all. So I'd just like to point out the importance of a free it's through a free market that countries vertical context have access of technology foreign direct investments. And foreign direct investments is what developing markets can use to sort of build, you know, roads, infrastructure, etc. And if foreign investors are of the opinion that the financial markets in an economy is not free and fair, or hesitant to channel those funds into those markets. I want you to consider that in your sort of
That takes us to our last session question.
Okay, mine is another question, just a compliment for Ms. Rorisang Matlala, to say that we need more writing that links all to all the social ills that we have. So well done on that.
Thank you very much. So are there responses, I suppose, by Colin or Kamthara? You're in the hot seat.
Kanya, thank you very much. But I would ask for a favor, Kanya. I couldn't get most of the questions. I don't know if the problem is on my side or, but from the first question, what I could gather was the colleague was worried about NHI, that to do with NHI?
Maybe what we'll do is we ask the questioners, the commentators, to just summarize their questions again. If you are able to manage it.
A bit closer to the mic, please, Kanye.
Okay, can you hear me?
Yes, I can.
All right,
Yeah.
I just want to speak to the comment that you made about financial market pressuring governments to making policies favorable to market participants at the expense of equality to all.
Okay.
Now, my comment is on the importance of a free financial market, because my angle is that it is through a free financial market that developing countries are able to access foreign direct investments. And foreign direct investors will only be willing to put their money in developing countries if they're able to access their money back or their returns back. And typically, that won't happen if there's a lot of government intervention. So I just wanted you to consider that in your sort of paper research.
Okay, okay.
Has to be 2 seconds. 2 seconds, sorry.
Hi, I'm Diane. I wasn't specifically talking about the NHI, I was just using it as an example to say that if we look at the core challenges against the NHI, what you see there is a small group of private practitioners or private sector actors throwing their weight in to kind of challenge the NHI, whereas the vast majority of South Africans do not have access to quality healthcare. And the health professionals working in the public sector who are working under very inhumane conditions do not get the same consideration because they cannot be going to court. So what I was saying is you make very broad recommendations, but can you maybe give us some specific ideas about how you can use constitutionalism or the law to address the excessive influence those with economic power have over policies in this country? Thanks.
So about 2 seconds, man.
All right, thank you for those questions. Perhaps to start off with the last one, I don't make suggestions because I believe that there's none. Right? If you follow my argument is simply that the Constitution, well, at least this one, the South African one, is a constitution that adopted like open-ended values, where the contestation between or what defines those open-ended values and what defines what impetus should be placed on poverty reduction is between unequal powers. So what then obtains at the end of the day is the people that have the money, they'll always dictate as to what must happen and whether we move with NHI or not, right? So in the sense of democracy, which is what I was arguing for, that cannot be a good thing, right? It makes a mockery of democracy, to put it mildly. And unfortunately, you get manifestations of it in the experiences that you've witnessed, where the private players will sort of have the power and the resources to go to court, but you don't. So what do you do with that? Right? So if you were to pick my brain, I would say there is no solution. Right? So that question at the end when I was asking, is there a way forward? Practically, I could have put it in a more harsher way and said, is there a way forward other than a violent way out of it? Right? And then on the second one, the foreign markets. The foreign markets issue is on a global scale. So my problem can be looked at a global scale and at a local scale. At a global scale, the pressure will always be there. It was there in 1994 or in the lead up to 1994 with the fall of the Soviet Union. So you got neoliberalism entrenched in most economies that were coming out of like your independence wars and stuff like that. That was the pressure of the global markets. And it continues to exert itself on African governments and everything. So if you take out loans, the structural adjustments, and you name it. I don't want to go into that. But the point here is, if I want NHI, like the lady that was speaking, and I vote for a party that says they want NHI, but in reality, that party can't implement NHI, because if it implements NHI, then you have people that don't want NHI and they have the resources, then they won't fund, then there's poverty, then there's all these other problems. Is that really democracy? That's my question at the end of the day. Like that's the nub of the question. Is that democracy? I don't know if that makes sense.
Thank you very much. Any other comments from the panel? I don't think we can take any more questions. But from the panel, no comments from the panel in the House, panel online. If not, then we're at a relatively good point after a struggle with time. But I would focus less mechanistically, I would focus on the content. I just want to thank all of our panelists for very helpful, very thought-provoking and a wide-ranging set of papers that really remind us of some of the central problematics of South African democracy and constitutionalism. The issue whether socioeconomic rights are really meaningful and to what extent they are, although of course there's much admired jurisprudence. The fundamental question of inequality at a macro level, which is stubborn in its many dimensions. The questions of agency about the Judicial Services Commission and so on, and the kind of difference that they could help the judiciary potentially make a difference, and so on and so on. And I'm not going to say blah, blah, blah. But the sanitary, I think, is that those of us who are self-satisfied about the achievements of this great democracy would probably do well to reflect further and more deeply, as we've learned this afternoon. Our democracy, our constitutionalism, the entire system is a work in progress, as is the case elsewhere in the world. And in our particular context, we may have quite a number of really particularly prickly pears that we need to peel very carefully with a sharp and long knife, fingers away from the thing. I want, with those few words, to express my sincere thanks to the organizers, to the leaders of the organizing committee, Prof. Yoon, the Dean of my faculty, Prof. Serge, about whom I gossiped a little earlier. I want to thank again the honorand and his distinguished professor, the one who sits next to him, I'm not going to say wife, for the opportunity to engage this afternoon in ideas that really matter from the point of view of futurism for our continent. And I'm just very grateful to be part of this occasion and that I was even allowed to say something. A great thanks also to all of you colleagues in the audience who've borne with us and been tolerant. The time is 7 minutes past 4, and I'm again looking across the room for some kind of guidance as to when we return.
We could say 10 minutes, but let's say half past. We really start.
Yes, half past it is. You've won. Passive resistance works, right? Thank you very much to everyone. A big round of applause to us all. Sure.
Can I get a photo with the people in the back?
No, you did a lot of you did the hard lifting. Yeah.
You don't want me in the picture? No,
Of course
please.
I want. You're part of the panel.
Oh, okay.
I
All
want to
right.
post something about this panel. It's my
Okay.
favorite panel of the day.
Oh, thank you. Thank you. Tell them it's a people panel.
You're not calling Mr. Stolle up there?
Oh, Mr. Stolle. Focus Stolle. Focus Stolle. I don't want to shout too much.
What's his name? Where's your phone? Can I join?
I don't have any. Oh, no, wait. Oh, how are you? Oh, no, that's not mine. Folks, just someone's book here.
Mr. Stolles.
Yeah, you don't lose things like this. That's called losing your life.
Stolle, you want your photo?
Oh, yeah, fine. Because don't you have a step? Thank you so much. Just saying you should read the African Human Rights when we have that's such a
Yes.
No, I'm taking my book so I can note. So yeah, I'm already able to.
Yes, he's outside. Yeah, there is. There is. You may want to take your tea.
You ready? Oh, I can make it more. It does not.
That's the nature of
Thank you so much. Yeah.
Yes, how are you? Very well. The name just goes.
It's so good. I love that. It's I don't know what I'm doing, but I'm looking at you.
Thank you so much, ma'am. He was really happy. Thank you.
Hey, busy. He's busy there.
It's all right.
See you.
Okay.
Anything. Anything.
I don't want to see. But you.
May ba wannan zuwa garin mu shi ne ba mu da ke tawo. This is what we know, but this is what we are now seeing. This is my favorite time we are going to do.
Hello, hello, good afternoon. Yeah, Polycarp on the line, what's happening? Is it possible for me to present now?
Afternoon, sir. So, still on a tea break at the moment, and they'll be back shortly.
Okay, so I went to present shortly?
Shortly, yes, sir, after the tea break.
Okay, okay. How long is the tea break?
It's supposed to be about 15 minutes.
Okay, okay. I hope to be the first to present after the coffee break, as I'm somewhere with very limited energy.
Very well, so we'll note that. Thank you.
Okay, thank you.
Yeah. I can see how much it is. Oh, what's this in here? What's wrong with this place? It's the pen. It's a banana.
Back. Yeah. How did they go? Yes, we came. My wife were having the tea. Yes. Yes, this session. Okay, there are too many. Yeah. They would have already been more, but they just don't say it. Yeah. 10 minutes.
I actually was very sad. You don't understand. So sad.
I can take it from here.
No, there should be a problem here.
So let's get your panel here.
Yes. This is the last one.
Yeah. Where's Arcticus?
I recover my seat. We're talking about you and say I recover my seat. You are appropriated. You are over there, that's where you belong.
They also haven't done very thing. They will each for you.
Oh, okay. Yes. You came and now, right?
Carol. I think
Nobody knows.
Carol is here.
Carol is here. Yes.
I hope so. She's here. She's here. Yes, and they are online, I know. Yes. And then just online. Yeah. No. They are 10 minutes. They know that. They know. Maybe just a little bit more. But there are 2, 5, 5. You know, like count. They're definitely not all of them will speak. 2 have been designated.
Yes.
But otherwise, you know, a little bit of flexibility. But and please let's use this one, not these ones, because they're not very. Is this working? You know, those ones pops up all the time. It's not a good show. Let's see those two.
Good afternoon. Welcome to the final session of this important conference. And this is such a fitting panel because we are going to be taking a deep dive into countries, Angola, Cameroon, yes. And we have our speakers here. The majority of our speakers are physically present. And each would have 10 minutes. So that we can have enough time to have a discussion around the topic. So, our first speaker, Dr. Comparative, the floor is yours. Thank you very much.
Good afternoon. I'm also honored to be here to celebrate the scholarship of Professor Fonda. He helped me in publishing my first peer-reviewed paper in 2016. After that, we've been working together under the Stellenbosch annual seminar on constitutionalism in Africa, and through that particular platform, he has also assisted me to publish 2 other papers through the University of Oxford Press. So I appreciate that very much. My paper is going to focus on constitutionalism and legal pluralism. It's a tongue twister, so forgive me. In environmental and natural resources management in Zimbabwe. So to start with, by way of definition, and as we all know, many of us here, legal pluralism is the presence in a social field of more than one legal order. And in the context of a state, it entails the existence of multiple sources of law within the same country. And the sources of law can be both state and non-state, and can operate side by side or simultaneously or concurrently. And legal pluralism exists both in countries with very well-developed legal systems, and even in countries with legal systems that are still developing or establishing. Because we know that even in countries that have got very well-developed legal systems, not all issues can actually be addressed, or disputes can be addressed through the formal legal structures or court systems that we have. There are also different types of legal pluralism. I will give maybe 3 examples of such. The first can entail the existence of legal orders that are parallel to the state system. They are not sanctioned by the state and are not recognized by the state. Then a second type is one where we have, which is formal legal pluralism. In this scenario, certain legal aspects, especially those about personal law, such as issues of marriage, property rights, burial or devolution, are governed by customary or religious laws, whilst other aspects are governed by formal state law. Then there's a third type, which entails the establishment of quasi-state legal orders or the incorporation of non-state legal orders. Examples of this include the incorporation of traditional authorities or local power holders as the lowest levels of state legal pluralism. I would say in the context of the paper, the draft paper that I currently have, in Zimbabwe, all the above forms of legal pluralism actually exist and are applied to different extents in the country depending on various factors. But my paper is focusing mainly on state legal pluralism and how the constitution and legislation have incorporated both formal law and customary law into the country's legal system. And looking at the constitution specifically, defines what law is or the sources of law in the country. And this includes the constitution, acts of parliament, statutory instruments, or unwritten law in force in Zimbabwe, including customary law. The constitution also recognizes international law as a source of law in the country. So to this extent, I would say the constitution actually clearly recognizes that we do have state or formal legal pluralism in the country. I would look at specific constitutional provisions that try to address this issue. Both the independence constitution of Zimbabwe, we had an independence constitution that was replaced by a new constitution in 2013. So both constitutions, the independence constitution and the 2013 or new constitution, I don't know if 2013 up to now can still call it new, but they both recognize formal law and customary law as sources of law together with other sources that I indicated earlier on. And one key issue is that the new constitution recognized traditional leadership as an institution. The 1980 constitution or the independence constitution only recognized chiefs as part of the customary leaders that the country could rely on. But the new constitution actually embraces a whole institutional framework to deal with the issue of traditional leadership. And this new framework includes chiefs, it includes head persons, it also includes village heads as the 3 tiers of traditional leadership in the country. And the constitution also specifically provides for the role of traditional leaders in natural resources management as well as environmental management. For example, if we look at section 282 1D, it says that traditional leaders are given the responsibility in accordance with an act of parliament to administer communal land and to protect the environment. Then section 282 1B states that traditional leaders also have the responsibility to preserve the culture, traditions, history, and heritage of their communities, including sacred shrines. In the context of environmental management and natural resources management, I think the issues of shrines is very important, because looking at the traditional way of life in Zimbabwe, the shrines that people depend on include areas such as wetlands, it includes areas such as forests, which are actually sacred and therefore are treated with reverence. And as a result, giving this responsibility to manage these spaces to traditional leaders means that at the end of the day, we are able to manage the environment using those powers that are conferred on our traditional leaders in the country. We also look, for example, at the issue of the protection of human rights when it comes to the role of traditional leaders as justice providers in the country, or when they're using or applying their judicial powers. And in this context, traditional leaders are also able to address issues of environmental crimes, if there are minor crimes within their communities, but also to manage the natural resources using the powers that they have as judicial officers within their communities. We have also seen the role of traditional leaders, for example, when it comes to mining. And in particular, when we are looking at the issue of the need to consult communities when a mining investment is coming into an area. And the issue of, for example, the undertaking of environmental impact assessments, where before a mining project can actually proceed, there is a requirement for environmental impact assessments to actually take place. That responsibility is given to the Director General of the Environmental Management Agency in the country, but in undertaking the environmental impact assessment, the Director General and any investor who is coming into the country is actually required to consult with communities and other authorities, including traditional leaders that live within those resources. So again, we see the role of traditional leaders coming to prominence in such instances as well. There are challenges with legal pluralism. I think as in any other situations where you have multiple sources of power actually participating in the governance of any resources, and we've seen that as well in the context of natural resources management in Zimbabwe. And one of the key challenges that we've faced is the issue of corruption, especially where traditional leaders actually connive with investors in order for them to give positive reviews when it comes to an investor who is coming into the country. But also, I think one of the other challenges that we've faced is the issue of traditional leaders participating in political partisanship. Yet the Constitution clearly provides that traditional leaders are not supposed to participate or take part in any partisan political activities. And as a result, when they do so, they actually lose the support or the respect that they're otherwise supposed to get from their communities. And when they attempt to enforce their roles in terms of environmental and natural resources management, they are unable to enforce those laws as they should because of the loss of respect that comes out of their participation in partisan political engagement. So I would say one of the key issues that would need to be addressed in order for the country to reap the benefits of legal pluralism is to ensure that traditional leaders are able to carry out their duties without being involved in partisan political activities, so that they can get the respect that they need in order for them to be able to enforce the rules. In conclusion, I would say it is important to fully integrate traditional leaders, communities, and customary laws and practices into environmental and natural resources governance. For example, the World Resources Institute reports that indigenous peoples, local communities, and Afro-descendant peoples customarily hold and use 50% of the world's land, and further that at least 36% of the global key biodiversity areas lie within indigenous peoples and local communities. And the protection of these key biodiversity areas is not by chance, but is an indication of the effectiveness of traditional and customary rules, laws, and practices in managing natural resources, the environment, and biodiversity. And therefore, if we look at it from this perspective, that traditional leaders and their communities can actually play a key role in managing our environment and managing our natural resources, I believe that legal pluralism can be a positive force in shaping environmental management in the country. This is because the country and communities can benefit from adopting the best of customary law and customary law as well as statutory systems to achieve environmental protection and derive positive benefits from the utilization of the country's natural resources. And there's therefore great potential to improve the interaction between legal systems for sustainable utilization, for sustainable resource use, and identifying potential models for harmonization of the legal principles and development of sustainable collaborative governance systems. And I think the fact that we have got strong personal provisions recognizing customary law and traditional leaders and their roles as well as a number of laws that we have in the country, such as the Environmental Management Law, the Environmental Management Act, the Customary Land Act, the Traditional Leaders Act, all coming together to recognize the role of traditional leaders together with other statutory institutions in managing the environment and natural resources. is a good, I think, source of legal provisions that the country can use to ensure that there's good stewardship of the environment. Thank you very much.
Thank you. The next speakers are online, Yvonne, Lulu, and others. Can you hear me?
Yes, we can. Can
Yes.
you get me clear?
Yes, we can hear you. So you also have 10 minutes to present on this very interesting topic on gender skills and political systems in Kenya. Thank you.
Can we have our slides projected, please? Good evening, everyone. My name is George Nyanaro. I am representing the group that is presenting a paper themed A Bullet for Democracy, how the Kenyan Generation Z have leveraged on the digital platforms to drive political change. The basis of our paper was the June and July 2024 protests that happened in Kenya, and whose genesis and organization was through the various social media platforms, which was as a result of the public outcry of what was plaguing the nation in terms of management. So the whole essence is that our paper is spec'd on digital activism, which we use Kenya as a control test to assess whether it is ripe or it has become time where digital activism plays a key role in Africa when it comes to pushing for democratic change. Our paper first tried as much as possible to bring a historical context of what activism entails. And for purposes of not leaving anything unturned, we defined activism to be a vigorous campaign that aims to drive for political change. The whole basis of driving for political change is to ensure that the citizens get to be served and get to enjoy their democracy that has always been defined in the famous Gettysburg Address as the rule of the people, by the people, and for the people. So Kenya as a country has had a historical past where activism has been its guiding light. And we went back to the colonial era where Kenya, the likes of Tom Mboya, the likes of Oginga Odinga, fought for self-rule before Kenya became an independent state gained independence in 1963, before becoming now a republic in 1964. But that was not the end of activism and the fight for change, because after that, there were still issues that Kenya was dealing post-colonial, which included political repression, authoritarian leadership, and all forms of what democracy detests: detention without trial, trumped-up charges, and all sorts, which are also well recounted in Miguna Miguna's book, Peeling Back the Mask, A Quest for Justice in Kenya. Now, the reason why we brought the whole historical context was to bring about how modern digital activism came to birth. And we went back to the year 2010, when Kenya, there was now the coming of affordable smartphones in the country, and also the liberalization of education under the leadership of the former president, Mwai Kibaki, where now the youth were able to access education and to also learn and to also critique literature and also read widely. So it more of brought a woke generation that was able to read and understand and also challenge the status quo where there was poor leadership. So through time, leadership has always been challenged in one of the ways. But now this year was the precursor or the tipping point due to many reasons. But the major reason for digital activism coming to birth, according to our paper, was the new finance bill that was coming, that was to become an act. And it contained clauses that were very punitive when it comes to tax administration. And the Kenyans were frustrated in the manner that their plights were not being heard.
So that is when the youth led the movement, leveraging on the various social media platforms, including but not limited to TikTok, Facebook, X, which was formerly Twitter, and all forms to mobilize people after mobilizing using hashtags, and to also conduct what we call citizen journalism, where they informed the youth of what the implication of the various laws that are being passed. Through this mobilization under a hashtag of a tribeless, partyless movement, the youth went to the streets to protest for what they termed to be very punitive laws, and which to a certain extent they felt had a hand of external players, such as IMF and the sorts. So through this, the youth fought so much to an extent that the government was made to listen and turn down, withdraw a punitive finance bill and other laws that had not gone through the rigorous, meaningful public participation to bring on board the views of the persons. So through that, we felt that to a certain extent, digital activism had attained its achievements. So the whole aspect was that digital activism was the leveraging of the various social media platforms to push for meaningful change, socioeconomically and politically. While there were tangible results in terms of the withdrawal of the finance bill, followed closely by dismissal of the various cabinet secretaries who were not performing, and also the government trying to involve the youth meaningfully, we can say to a particular extent there was success in that now the people became more aware of how they are the sovereign according to Article 1 of our Constitution, and also how they are able to mobilize without necessarily breaking the traditional political barriers, and they're able to amplify their voices to protect the Constitution, which has been deemed progressive since its promulgation in 2010. It also gave them the right to advocate for their human rights, their freedom of expression, their freedom of human dignity, and the right to be heard on matters governance. So to a certain extent, we felt that it attained a large level of success. However, we also believe that amidst the success, there are also some misses and missed opportunities of growth. Among the misses was that there was a recycling of political leaders whom we felt were not able to deliver. And also there were issues that were left unaddressed until today, while there are still issues to do with the economy that are yet unaddressed. And also the movement, by the virtue of not having no leader, being partyless and tribeless, it faced what befell the Arab Spring, in that the lack of a leader, it led to infiltration eventually. And so to some extent is still in its over effect. Also, there were casualties whose justice is yet to be brought to book. So there were people who were killed in cold blood, and other people whose human rights were violated, illegal abductions, arbitrary detention, and other forms of the illegal use of state machinery that we felt is not something we could have expected in the wake of a constitution that is very alive. But that is where we felt that there is opportunities for growth, because it was a demonstration that digital activism can work in Africa, and citizens can exercise journalism to create awareness and to advocate for meaningful political change. That is what we had from our side. Thank you.
Thank you. Next presentation by Dr. Prof. Campbell.
Thank you very much. To you, Chair, I would like to recognize Madame Lang, the first secretary at the Cameroon High Commission in South Africa. Welcome. Thank you very much for coming. We will be talking about a paper that we have put together with Dr. Tabon, who has been my student and now my mentee. He's been a student for many years when I was still at UNISA. In this paper, we are looking at constitutional democracy and electoral processes in Africa with the case of Cameroon. But I will not speak about the paper per se. I will just do something that Professor Fombat did in our last book chapter we published on corruption in one of the constitutional law series published by Oxford. I brought in the paper we discussed. I did the first draft when he took the paper, transformed it so much to another level. After my first draft, I did not recognize my paper. And then I said, wow, this is beautiful. And then I had put his name as the first author. He said, no. Serge, you need it more than me now. So today, I want to say, Atabon, come, you need it more than me.
Thank you very much, Prof. Sedges. Actually, Prof. Sedges, I remain his student forever. I guess if we can still work together, it's because we have good relationship. It's the same thing that happened when Prof touched this paper. The paper, I couldn't recognize it. And I'm glad because he gave me a phone call to guide me on how to write to a legal audience. However, this afternoon, I'm not going to speak like a legal practitioner because I won't be able to. It's just to say that that chain of relationship is very important for us that are emerging. And of course, it's today that Prof. Combat and myself had a handshake through Prof. Sedges. You always, for us who did not go through the Center for Human Rights, the easiest way to meet Prof. Combat is once you see Professor Sedges, you know Prof. Combat is around. And of course, we all have good things to talk about the scholarship of Professor Combat, including myself. Except if there is somebody here that has differences with me, which probably will be a wizard or a witch. Because his scholarship, for me, it's one of the work that when I read, I'm able to recall what I have read. Remember, there are times that you read publications and you ask yourself, have I read this? Whereas you have read it. So today we're looking at constitutional democracy and electoral processes in Africa. We're looking at the case of Cameroon. My comment on this paper is not for us at the end to roll our eyebrows to think Cameroon is out of touch, but however, it is for us to engage to see how we can, make Cameroon advance as well, because the challenges are the same challenges almost in every place. So in this paper, we are actually looking at asking 3 questions. And one of the restructuring that Prof. Sedges did on this paper was that for my own, point of orientation, I have listed things like findings, I've listed things like questions, and then you have to restructure it in such a way that those things don't appear, but they are within the contents of the paper. So what the first question that the paper tried to answer is, what are the challenges of electoral processes in Cameroon? The second is, how inclusive are electoral processes in Cameroon? The third is, why does the electoral institution of Cameroon lack capacity to implement the mandate? So these are the 3 questions that we are trying to ask. And the paper actually relies on depth study to get answers to these questions. It makes use of the electoral code. It looks at the independence of the electoral commissions, etc. Now, for me to put content into this, I just want to say that the wind of change that brought democracy to Africa in the 90s, in what Prof. Sedges described as the east wind of change that went through the Soviet Union and then to Africa, didn't go through Africa without stopping in Cameroon. This east wind of change brought in democracy, and the fact that it brought democracy, it emphasized on constitutionalism, which is the backbone for every successful democracy. Cameroon is not an exception because it has a constitution. The constitution takes advantage of a lot of international legal framework like the Constitutive Act of the African Union, the International Human Rights Charter, and others from other supranational organizations. So the Constitution itself is good, as you may see. However, one of the questions that one may interrogate in terms of the Constitution is regarding the view of Montesquieu in terms of how strict and abiding is the Constitution. One would say this question, a lot of Cameroonians who have similar opinions to say that the Constitution of Cameroon, for example, is not so much that it's really respected, in the sense that in 2008, there was actually a constitutional amendment. A constitutional amendment is not so much of a bad thing, but it all depends on what direction it is going. In the case of Cameroon, it didn't go in the direction of the people because it removed the term limit of the presidents, and also it increases the number of years from 5 years to 7 years per term, which of course is problematic in terms of the context we find ourselves today. So to answer these questions, as I said, is to say that when we look at the challenges of the electoral process in Cameroon, one of the challenges is that the electoral process of Cameroon is not so much digitized as you will find in other parts of the world. And whenever something is not completely digitized, it becomes a problem because manual entry are always manipulated. I was fascinated when I read in Yamjo's work that he talks about structural challenges like lack of electricity in terms of vote counting, where they use light from cell phones and touches. I'm sure it's something that happens in every African country, to be able to count the votes and so on and so forth. So in this particular case, you realize that the electoral process will be weak because these are all manual counting, are all possible ways in which vote rigging can happen with ease. And of course, like I mentioned about vote rigging, is another issue that is a challenge to the electoral process in Cameroon. Because when we talk about the electoral process, we are actually referring to all the different activities that takes place within an electoral cycle that begins probably from voters' education as far as vote counting and result proclamation. So we have this more that you find in the paper because of the issue of time. Let me go to the second question. How inclusive are electoral processes in Cameroon? One will argue that electoral processes in Cameroon are not so much inclusive for varied reasons. For example, the Cameroonian diaspora, a lot of whom are having dual nationalities, are not considered fully as Cameroonians. They are excluded in the process. The Anglophone Cameroonians as well, like the last election that took place in 2018, one may argue that because of the question of insecurity in that region, they were not able to vote. In other words, they were excluded because the government never created any structures to be able to accommodate them. In practice, when you look at literature, some scholars have already written, documented scenarios where some of the Anglophones were displaced because of the war into Francophone provinces, were not given the opportunity to vote, because in Cameroon, most likely wherever you register, the constituency that you register to vote, that is where you will go to vote. And of course, the ruling CPDM party, that in elections in Cameroon, it plays itself as a player and at the same time an umpire in the entire electoral processes, is using some of these lapses to be able to strengthen and make some political gains, which the gains are also questionable at the end of the day. And then in terms of why does the electoral institution of Cameroon lack the capacity to implement a mandate, it's obvious. The formation of the Electoral Commission itself, it's very problematic in the sense that when you look at the code of the formation of the Election Commission, It talks about the Election Commission being an independent institution. But in practice, it is the executive that appoints individuals in key positions in the Election Commission. Some of these individuals are actually former ministers. And then one scholar, of course, said, whoever appoints you, you owe that person their loyalty. I thank you.
Thank you. Still on the subject of Cameroon, is Polycarp before online? Yes, Mr.
Yes.
Yes.
Yes, I'm online.
Yes, please, the floor is yours. Thank you.
Thank you for giving me the floor. I feel privileged to be given this opportunity to present on presidential term limits and constitutionalism in Africa, the case of Cameroon. Presidential term limits are a cornerstone of democratic governance, facilitating the peaceful transfer of power and preventing the concentration of authority. In recent years, the debate around term limits has intensified in Africa as several countries have amended their constitutions to extend presidential tenures. This paper uses Cameroon as a case study to explore the impact of extending or abolishing term limits on constitutionalism and democracy in Africa. Presidential term limits have been a contentious and long-standing debate in many African countries, including Cameroon. The tension between the desire for political stability and the principles of constitutionalism and democratic alternation of power has often led to complex and diverse political dynamics. Cameroon has been ruled by President Paul Biya since 1982, making him one of the longest-serving leaders in Africa. Biya's prolonged tenure has been facilitated by the removal of presidential term limits from the Cameroon Constitution in 2008, as indicated by the last speaker. This is a move that was widely criticized by both domestic and international observers as a threat to democratic governance. The decision to abolish term limits was justified by the government as a necessary measure to ensure political stability and continuity in the face of various challenges, including the Boko Haram insurgency in the country's northern regions. However, critics have argued that this move was primarily motivated by the incumbent's desire to maintain power and consolidate its authoritarian grip on the country. Moreover, the absence of term limits has contributed to a culture of political dynasties and the entrenchment of elite networks, making it increasingly difficult for new political actors to emerge and challenge the status quo. This, in turn, has undermined the principles of political pluralism and the ability of citizens to hold their leaders accountable. The write-up examines the relationship between presidential term limits and constitutionalism in Africa, with Cameroon as a focal point. Cameroon's political trajectory is particularly relevant as it has been led by only two presidents since independence in 1960. That is Amadou Ahidjo, who ruled until 1982, and Paul Biya, who has remained in power since then. Although the 1996 Constitution initially set presidential term limits, these were abolished in 2008, allowing Biya to remain in office indefinitely. While legally permissible, these moves have sparked widespread criticism and political unrest, revealing the tension between constitutional amendments and democratic principles. The key issue at the heart of this story is the conflict between the removal of presidential term limits and the concept of constitutionalism in Africa. And in the write-up, we try to answer these questions. How does the removal of presidential term limits in Cameroon affect the principles of constitutionalism and the rule of law? Another question, what are the prospects for restoring term limits in Cameroon? And what role can regional and international bodies play in supporting the democratic process? In the write-up, we try to address the conceptual framework, that's constitutionalism and presidential term limits, where we discuss in detail the concept of constitutionalism, the role of law and separation of powers, constitutionalism and the protection of rights, constitutional amendments, and constitutionalism. When you go through the history of presidential term limits in Africa or in the world, you understand that presidential term limits are designed to curb the potential abuse of power by creating a legal framework that caps the duration of a leader's tenure. These limits typically restrict the number of times a president can hold office, usually to 2 terms, in order to prevent the concentration of political authority in the hands of a single individual. This introduction of term limits serves multiple purposes in democratic governance. First, it fosters political pluralism. Secondly, it promotes accountability. And lastly, term limits prevent a personalization of power and reduce the likelihood of authoritarian rule, which often stems from prolonged incumbency. In the case of Cameroon, if you look at the evolution of the Cameroon political system, you look at the pre-independence period and the colonial era, where there was a single party. Post-independence from 1960 to 66, Aejo operated. There was a multi-party system that Aejo ended in 1966. So we went now to one-party rule again in 1966. And by the time Biya came up, there was a one-party system. But when the wind of change blew all through Africa in the 90s, he was forced in one way or the other, or the country followed the trend of other countries to come back to a multi-party with more than 100 parties as of the last count. Cameroonians and the international community were very embarrassed with the amendment process that started in January 2008, when the ruling Cameroon People's Democratic Movement introduced a draft bill in the National Assembly aimed at abolishing presidential term limits established by the 1996 Constitution. The reaction of the public I mentioned, and this has serious consequences in that it promotes political stability. Yeah, the justification the government gave rather for the amendment was that they want Biya to stay for life, to promote political stability. They gave development arguments of that there are projects that he started, they must be, they want to complete it. There was also the so-called People's Call. Those who followed events in Cameroon could have seen the ruling party was publishing, general faking popular cause. They also claim that his remaining there will strengthen national unity and that, things will be better for Cameroonians. There will be stability. However, I join critics to see that the effects of removing the term limits, it weakens checks and balances, it brings the erosion of democratic governance, it undermines the role of law, it entrenches authoritarianism, and it has serious political and social consequences. A point is the strike and rampage that went 2008 after the change. Long-term incumbency has been linked to corruption, human rights abuses, and stifled political dissent in Cameroon. As to the appreciation of the public when these changes took place, yeah, analysis shows that it differs, let's say, from community to community. Certain local communities were, let's say, from the political elites, could believe in the stability to be achieved by him remaining. But the political, the educated elite, the mass, especially urban areas, didn't see it that way. In general, surveys that have been carried out shows that a majority of Cameroonians and the international community were not for that. So, in terms of comparative analysis,
Mr. Punka, you have 1
yes.
minute. 1 minute left, please.
Yes.
Thank you.
Yeah, we equally did analysis of the situations in other African countries, such as the perpetuation of power in Uganda, the controlled political landscape. That's where there is economic successes, but no human rights in Rwanda. We talk of Burkina Faso case, where there is really activism and fight for the democracy. So at the end, in conclusion, from these comparative stories, we see that there are a series of lessons that could be learned. And in terms of recommendation for Cameroon, we recommend and call on the Cameroon government to reinstate the presidential term limits, strengthen institutional checks and balances, promote political pluralism, engage civil society and citizens, and establish mechanisms for accountability. Thank you.
And last presenter, Prof. Karen, are you co-presenting? Or do you present? Oh, thank you.
Yeah, so while he's setting up the slide, just like to say in honor of Professor Fombat, I had to drive all the way from Lesotho to attend this very important gathering. Right, I had to drive all the way from Lesotho to attend this very important gathering. More so because I started teaching constitutional law last year, and so this gives us opportunity to draw inspiration from Professor Fombat, so that hopefully I can become as good as he has been. So the conversation, the conversation that I bring from Lesotho is on Lesotho's model of conservative constitutionalism. It's a paper that I put together with Lerato Molati. She's my student, and just to follow in the tradition of mentoring the younger ones. So Molati is attending online. Right? So for those who have known the story of Lesotho, Lesotho is one small country that has very big political problems. You know, right from independence in 1966, the history of Lesotho has been characterized by political instability, either military coup d'etats or very antagonistic partisan politics. Right. It has become very recurrent that in 2017, SADC had to intervene to ensure that some stability is brought to the country. And that intervention by SADC led to nationwide consultations and a national reform process, which included carrying out constitutional reforms, but unfortunately, that reform process collapsed in 2022 while I was in Lesotho, and I observed, how the process went until it came to an end. At one point, they actually wanted me. They wanted me to do some consultancy to, to advise the reforms authority on the necessary constitutional reforms to carry on. but unfortunately the process did not go through, and so we are back to the same dispensation of that instability and uncertainty. So, looking at the political situation in the country and reading what other constitutional law scholars have written about the problem, and looking through the Constitution and other legal instruments, other legal documents, we diagnose that the problem is embedded in the model of conservative constitutionalism that is in practice in Lesotho. The notion, the concept of conservative constitutionalism is our coinage. We are the ones that have, coined this term to describe, the system of constitutionalism that is in practice in Lesotho. So central to this problem is the fact that Lesotho was colonized by the British. When they got independence in 1966, they inherited an independence constitution that was crafted in London and imposed on them. So they inherited the Westminster parliamentary system that was in practice from 1966 right up to 1993, when they decided to adopt a new constitution. So the new constitution actually makes provision to the fact that Lesotho is a constitutional democracy. Various provisions in the constitution actually speak to the fact that Lesotho is a constitutional democracy, and other scholars have actually also described the political system in Lesotho as a political democracy. So constitutionally speaking, Section 1, Sub 1, and Section 2 of the Lesotho Constitution really qualifies Lesotho as a constitutional democracy. Section 2, for example, says that the Constitution is the supreme law of Lesotho. Any other law that is inconsistent with the Constitution is void. Right? Now, being a constitutional democracy means that the state subscribes to and ought to adhere to the principles of constitutionalism, right? Entailing supremacy of the Constitution, the idea of a limited government, the fact that sovereignty resides with the people and their rights need to be respected, protected, and fulfilled. So constitutionalism, the way it is framed in Lesotho, it ought to define or shape governance in the country. So it's supposed to have implication on how the country is governed. So being a constitutional democracy implies that governance in Lesotho ought to be regulated by the tenets of the Constitution. Constitutionalism must, in this instance, envisage to achieve a specific governance outcome and thus create legitimate expectations of a minimum threshold standard of well-being and aspirations for better quality of life. On the contrary, governance in Lesotho has been mired in dysfunctionality and uncertainty, which has had negative bearing on the country's development landscape. When you read about Lesotho, Lesotho has consistently been classified or ranked as one of the least developed countries in the world, which is not a good thing for the country. So our argument for describing the constitutional system in Lesotho as conservative is based on the fact that the constitutional dispensation is strongly resistant to transformation. It does not favor advancement of the country. It operates on a religious affiliation to the inherited Westminster model, even though that model contradicts with or conflicts with the Constitution that was adopted in 1993. It thrives on a confused allocation of powers that revolve more on antagonistic partisan interests. For example, the Constitution of Lesotho, there are several provisions in the Constitution that actually allocate powers to the king. There is no provision in the Lesotho Constitution that allocates power to the Prime Minister. But it is the prime minister that governs the country. He's referred to as head of government, but there is no provision in the constitution that allocates that power to the prime minister as head of government. So it is just, based on that Westminster system that was inherited from the UK. So through a socio-legal analysis and use of the outcomes approach, we reiterate the proposition for the adoption of a new constitution in Lesotho, right? Many other constitutional lawyers have actually made the argument suggesting that the Lesotho constitution needs to be, put aside and a new constitution drawn altogether. Right, so in our proposition for a new constitution to be drawn up for Lesotho, we make the suggestion that it needs to take, a developmental approach, and in that sense, the model that we recommend for Lesotho is what we describe as developmental constitutionalism. Dominique Dabanja, has written on this the issue of developmental constitutionalism, where he says that developmental constitutionalism, has been adopted in many African countries, right? Where many countries in Africa are beginning to adopt constitutions that are development-oriented and, focus on the constitutional right to development. So we have a number of constitutions in Africa, like the Constitution of Malawi, the Constitution of Ethiopia, the Constitution of the Democratic Republic of Congo, the Constitution of Benin, that actually enshrine a provision on the right to development. So on the basis of that, we make the argument that it is a recommended model that Lesotho can, adopt in order to redress the political instability that the country has been going through. And the reason why we make this argument is because the right to development is enshrined in the African Charter, in Article 22 of the African Charter, which Lesotho has ratified. Lesotho ratified the African Charter in 1992, just a year before they adopt the 1993 Constitution. And by virtue of ratifying the Charter, Lesotho has an obligation to ensure domestic realization of the right to development. And so our suggestion is that if Lesotho can, go by the proposition to adopt a new constitution and, to ensure that the constitution is developmental, is development oriented, it will be able to address a lot of the challenges that the country has gone through. So in conclusion, just a day or two before we submitted our draft paper for this conference, it came to our notice that the Parliament of Lesotho has adopted the 10th Amendment to the Constitution. And, the 10th Amendment actually speak to some of the issues that we raised in the paper, some of, the constitutional issues that we raised to the paper. But when you read through the 10th Amendment, it raises more questions than it actually, provides answers to some of the issues. For example, just like I explained, that there is no provision in the Lesotho Constitution that grants the Prime Minister the kind of excessive powers that they exercise. But the 10th Amendment says that there is a provision in the 10th Amendment that says that speaks to reducing the powers of the Prime Minister. So the question I ask is, how do you reduce the powers that did not exist at all? The Constitution does not grant the Prime Minister those powers. So for the 10th Amendment to say they are reducing the powers of the Prime Minister, meanwhile, those powers were actually not, provided for by the Constitution, raises concern. So as we speak, even just a few weeks ago, after they amended the 10th Amendment to the Constitution, we learned that there is an 11th Amendment that is underway, that is being deliberated in the Lesotho Parliament, and that 11th Amendment will be adopted anytime soon. And we don't know yet We don't know yet what issues it is going to address, but just like all the other amendments that have come up to this point, the amendments are actually not addressing the issue. So, in spite of the amendments, the political issues continue to exist, right? So, just like constitutional law experts, including Professor Combat, has described the situation where a country has a constitution but no constitutionalism. So virtually that is what the kind of dispensation that we have in the Lesotho. There is a constitution that speaks to constitutionalism, but in practice it really doesn't exist. I'll end my presentation at that point.
Thank you to all the speakers. We've kept time, but in the interest of time as well, I think we have about 30 minutes for questions and answers. And we'll take 3 questions per round, directed at either all the speakers or individual speakers. So we'll take 3 at a time. Yes, because you are at my line of sight. One, then yes, Elizabeth, then we'll take the rest. Yes, we'll start with you. Please, can we make it brief and straight to the point? Yes. Who's the first? The first, yes, he's the first. Then she's second, and you start.
It is. So my question is directed on the constitutional democracy and electoral processes. So it's fair to state that the key issues affecting the Cameroon electoral processes includes the lack of transparency, electoral manipulation, restrictive laws, and limited resources. So my question is what reforms are necessary to ensure the transparency and fairness of the Cameroon electoral processes? And the second question is, how can the international organization and local stakeholders collaborate to strengthen the Cameroon democratic institution and the electoral process?
I'm Dr. Elizabeth Achanjo from the Center for Human Rights, University of the Free State. I'm humbled to be here today to see the Prof. from that scholarship. My question cuts across most of the presentation today, beginning from those we had in the morning. I was trying to gather all my points together before I asked my question. So today we have been busy with unconstitutional change of government and selected case studies of African constitutionalism. Particularly worried with the use of the phrase unconstitutional change of government. Should it not rather be unconstitutional change of constitution? Because I'm motivated to say this because our leaders, or I should rather say, rulers change the constitution to suit their political motives. When citizens are not free to voice out their grievances, citizens are not actually free to voice out their grievances, and when they do this, the gun is used to repress them. We also have what we call in most of these case studies in these countries, what we call freedom before speech, but freedom after speech is not guaranteed. And when the powers that be manipulate elections to maintain the rulers in power, I am questioning the legality of our constitutions and their implementation. And my last part of this question is, when we talk about democracy, are we talking about Western democracy or African democracy? Because Western democracy has never worked in Africa. The people's voices in Africa have always been suppressed. Thank you.
Thank you very much. My question is for William Anthony, and I would like to find out if they have extended digital platforms whether they have been considered to be used for addressing access to legal identity for those who are stateless in Kenya, the digital activism.
Okay, let me, I just want to attend that question of Sergio, give you deeper insight. All right. I'm glad that you talked about the lack of transparency is actually needed. I'm not just going too far. The reforms that can be made to help cut the electoral process in Cameroon. It's actually, Cameroon is a very complex political terrain in terms of its colonial history as a whole. So any reform that does not begin with the reform of the form of the state and the reform of the political culture will not bring a transparency in the electoral process that one may applaud. This is my own opinion, but Prof is going to go deeper.
I want to respond to the question. Yeah, to the question that Dr. Janjo asked about unconstitutional changes of government and the idea of Western democracy and African democracy. Let me start with the concept of democracy. Is there an African democracy? I know scholars have written about that there needs to be, but I don't think that we've yet conceptualized an African democracy that we can, convincingly talk about that this is a different model of democracy that is very different from Western democracy or, well. So it is difficult to answer that question because, yeah, I know that it is the wish that we should have a different model of democracy that is more relevant to Africa. But we haven't yet conceptualized the African democracy. I don't know if there is, I don't know if any of the scholars here have come across any literature that really talks of an African form of democracy. Okay, maybe you can do some light on that. I think maybe you can do some light on that.
Saying the unique case of African democracy, that we cannot conceptualize African democracy outside of bread and butter. We pay serious attention to those economic rights. There is no distinction between political rights and the politics of the story.
That's very interesting. I've not read Florida on that, but I just wanted to add that I have conceptualized a model which is not really a democratic model, but I think that it is a model that is relevant for Africa, right? It speaks to issues relating to democracy, it speaks to issues relating to politics and development and human rights, and in short, everything in one basket. So, in my view, in most of my papers, I incorporated that idea, even in this one, right? I made the argument that African constitutionalism needs to take a developmental approach. It needs to incorporate the right to development. There is a paper that I published with Dr. Wanki in 2019, where we made the same argument that African constitutionalism needs to be informed by the idea of the right to development. People's right to development needs to be, foregrounded, and incorporated in constitutions across Africa. So maybe we can start to develop the idea of African constitutionalism from that angle. That was just my submission.
I think there was a question for William, the Kenyan presentation. William, can you hear us? William? Oh, then while we're still waiting for that, we take the next 3 rounds, 2 here and then one more. Oh, this direction. Apologies. So we start here with you. Okay, 2, then Bonolo. Yes. We take 4 now. I'm exercising my dictatorial powers. Yes, please start.
Thank you very much for giving me the floor. I'm Stella Anyangre, Professor Stella Anyangre. Probably I'm the only one not in the law discipline here. I have a lawyer and I have been for 45 years, but it has dropped off. And from yesterday, I think I've learned enough about law to even ask questions about it. I'm a medical doctor by training and an epidemiologist by specialty. We deal with evidence. We've provided enough evidence here that something is wrong. Constitutionalism is good in some places, faulty in others. We've heard all of this. My question is, now what? I know many of the papers and many of the research, much of the research that has been done is for papers, you publish things. So what? How do we hold African countries responsible for not having constitutions that meet the needs of the people? We know that the AU is, I worked for the UN for 18 years, totally toothless. They've not been able to hold anybody to account. You can see what's happening in Israel. You can call Russia and others. The UN, that is. We know that the AU, there's all kinds of conflicts in Africa, totally toothless. How do you hold countries to account? Can you name and shame and point fingers at people who are not doing the right thing? I think when we academics start putting this together, there might be some traction. Otherwise, the papers are beautiful. You read about them. It's there. After that, now what? That is the matter. Thank you.
Greetings everyone. My name is Sikiti Bapela, a law student from UNISC. Legal barriers prevent dual citizens from being fully engaged in national politics, which raises questions about constitutional inclusivity. The Cameroonian diaspora, especially those with dual citizenship, feel marginalized, which could impact national unity and the legitimacy of the electoral process. This exclusion might reduce voter participation and lessen the political influence of the diaspora. So my question on that is, how does the exclusion of the Cameroonians with dual citizenship from the full participation in the electoral process affect the integrity and inclusivity of the Cameroonians? The second one is, what reforms are needed in the Cameroonians' legal and constitutional framework to ensure that the diaspora, especially those with dual citizenship, are given full rights and recognition in the electoral process?
Greetings. My name is Skeleton Okuela, a law student here at the University of Pretoria. My question is directed to the rules amongst the thorns. African beyond philosophy, it's a good philosophy and it's welcomed. Do you think that the incorporation of legal pluralism is beneficial in the contemporary society? Is putting control of minerals in the hands of traditional leaders who are known to shy away from education a wise decision given the technological advances we have today? Historical, traditional leadership has been associated with nepotism and corruption. How do you view this issue? What measures can be implemented to curb and monitor traditional leadership as they are known for being arrogant? How can we ensure that traditional leadership reflects the best interest of the general populace? Thank you.
Thank you. This question is directed to the presenter that spoke about constitutional democracy and electoral processes in Africa and selection. You spoke about manual voting, digital voting, arguing that digital voting will prevent manipulation of the electoral process. Well, we can debate that later because I think even machines can be manipulated. But that's a different conversation. What I do want to ask though is that how do we ensure inclusivity given that the digital landscape presents everyone concerned or rather one bit about inequality in Africa. We are a continent of multiple economies. People may not have access to reliable internet in rural communities, for example, or even digital literacy in different communities in Africa with different socioeconomic statuses. So how do we ensure that while we speak about digital democracy and even using creative methods of voting using digital machines, we don't leave marginalized groups outside of the process?
Thank you for that question and for calling me the rose amongst the thorns. Thank you. Yeah, I think you draw from my presentation that actually indicated that despite the good things that pluralism can actually bring, we do have challenges in that regard. I pointed out the issue of corruption that you are raising, but also the fact that I think in the context of Zimbabwe, we have seen that traditional leaders are often manipulated to participate in partisan politics, which at the end of the day hinders their ability to carry out their duties and say should. And I think some of the challenges that you have raised about them being big-headed and not collaborating or cooperating with communities is because they are now departing from the original role that they should be playing as traditional leaders, which role often entails them engaging with communities and ensuring that when decisions are made, they are not made by an individual or the traditional leader or his or her own, but that communities are involved in the process. In the mining sector, for example, we know that most of the time when investors come and they need permission from government to invest or to mine in a certain area, the issue of consulting with the communities is key. But what we've seen is that most of the time that consultation effectively means just engaging with the traditional leader and getting the permission of the traditional leader. And sometimes that engagement actually involves, exchanging some kinds of tokens with the traditional leader in order to get their consent to undertake mining activities in their areas. So I think yes, those challenges exist, and the solution to that is to make sure that we allow our traditional leaders to carry out their roles as they should in terms of the law, because we now have in most of our countries laws that are in place to guide how traditional leaders should be carrying their duties, but also in terms of our traditions and customary practices, which most of the times entail consultations with their councils, but also with communities to make sure that at the end of the day, they're able to make decisions that benefit the communities as opposed to benefiting individual traditional leaders or benefiting politicians in most instances. We've seen, I think, also even our governments in most cases coming up with some kind of incentives to buy the support of traditional leaders, so that when it comes to the time to vote, the traditional leaders can actually coerce or force or convince their communities to vote for certain political parties. And all those, I think, shenanigans, if I call them that, they've actually made the traditional way of dealing with issues, of dealing with disputes, of managing the environment, natural resources, depart from how it should be done to processes that are actually, I think, contaminating the way that we should be able to manage all those issues. So I think that's where the problem is. We need to stick to the proper way of managing communities and the roles of traditional leaders, but also observe the laws that are in place to direct or to guide traditional leaders when they are undertaking their education. Thank you.
Let me attempt a response to the question by Professor Stella Anyangui. A very thought-provoking question, and I think a similar question was asked yesterday by someone who was sitting around this position. The question he asked was, where are the politicians? Because I think his estimation was that this conversation should have been speaking to the politicians and the policymakers. So, just to relate that to the question, I think that we should start to think of, the strategy of when we have academic platforms like this, we should consider, inviting the politicians and the policymakers so they come and sit and listen to the discussions, and maybe we throw some of these questions to them and, get them to, tell us what they intend to do about the issue that we have raised. I think in that way we might, make some progress. And importantly, because most often when we advertise conferences like this, we always indicate that it is to bring together scholars and policymakers, but most often it is only scholars that come together. Most often the policymakers are not amongst us. So I think that is something that we really need to take seriously into consideration.
Thank you. Let me say, 10 minutes, it's not enough to put context in every content that one may want to expand in a meeting like this. For the first question that says, how does the exclusion of Cameroon diaspora affect the integrity of the electoral process? What I can mention is that Cameroon diaspora, actually, you find some exiles and semi-exiles who have tend to become very critical of the government, such that their exclusion is probably because mentally one may think that they will vote against the government. Now, when you look at the role of the Cameroon High Commissions overseas, except the one in South Africa, sometimes there is a lot of intimidation that come from the officials against the Cameroon diaspora. I know there is a popular saying in Cameroon today that Jibekwa is avant-garde. It just means that people are very careful of what they say. But this is a platform where we are trying to engage to see that we make meaningful contribution. So the fact that they are not included because of these sentiments that they are of the opposition wing, then just question the integrity of the entire electoral process. And for the other question that talks about digitizing the electoral process so that it does not keep away people from marginalized community. Like I said, Cameroon is a complex state, but it does not mean that things cannot be done, cannot be possible. One of the issues that we must know is that the Election Commission does not have any form of independence, so that even if we do the best form of digitization in the electoral process, there will always be lapses, because as academics we understand that the challenges are always there. Hence, we improve upon the challenges as they arise. At 6 times, whatever we work in terms of the electoral process in Cameroon is a total information of the entire Cameroon. I will bet with you to say that must start with the form of the state, that must go to the political culture, because one thing, dynamics that is very common in Cameroon politics is that, politics is so strong across ethnic lines. If, for example, an opposition comes from a particular province, you find that a lot of his supporters will be people from that province. Even though he makes a lot of sense and his contributions and probably his political project is one that can take the country to our next level, you find that just because of ethnic sentiment, people will just discard him. So it's basically that it can be done. There are different ways that electoral process can be, digitized. You can make it in such a way that it's easy even for the uneducated. I believe if somebody stands close to a machine and tells somebody this is this, one of them will be able to even just catch something to make a result. Thank you.
Thank you so much for the opportunity. I would like to perhaps touch on the question regarding exclusion of diaspora. But election means participation in the government of your country. If from the moment when we talk of election, think of participation. Now, what makes you who stay in the diaspora not appropriate? Why should you be taking away your right to participate? This is simply completely inappropriate to do that. It's incorrect. It should not be done that way. In the presentation, we said Cameroon complying normatively by signing all international treaties. But on the ground, you find yourself in a situation where the reality is completely different. People like Simon Wade here, I don't know if you can go to Cameroon, but this is not fair. Yet he's a Cameroonian, simply because he has a view that calls for his participation. In Cameroon, you asked an earlier question asking what reform can be made. Everywhere we will say engaging in dialogue with the state. But in Cameroon, when that dialogue happened, many people who were supposed to be at the table were not at the table. So this is something to say, now you are in a country where the president was not in the country, then the minister just stood up and said, henceforth, do not question the whereabouts of the president. Now, how do I participate to the government of my country if the president is away for 47 days? And on television, everywhere on media, you are not allowed to just reflect. If you dare, you will be arrested, and you are told that in public television. How do I participate? I've elected someone. That someone disappears with no signal. And then I cannot ask. This is to say there is a need to an overhaul of the system. That system is not working. It's not really a pro-participation. And elections is about participation. I don't even want to talk about the independence of the Constitutional Council. When people that are sitting on that council and they are appointed by the president, the ELECAM, the National Commission for Elections, many of their members are appointed by the executive. Again, And by law, the Ministry of Technical Administration is directly involved in organizing elections. How do you have free and fair elections in such cases? Last election in Cameroon, you had a so-called Transparency International officers who appeared on television to validate the elections. But a few days later, the director of Transparency International came on media to say, we don't know those officers. We never saw them. Who are these people? With these few questions, you can see that the system really needs to be revised. I don't know if this can be done under the current government, but given that the president is old, his legacy, the real legacy he can give to Cameroonians, is to try to change these things so that one day one can say, at least when he was old and about to retire, this is what he brought to the country. That's my view on that.
Monica, can you hear us? No, I just wanted to see if the online, I'll come back to you. Online presenters. Seems nobody is there. But anyways, we can take the last round of questions. Prof? Yes. Yes. We are not. It's Prof 1. We just take 2 more. No. We take fresh ones. Okay, just 1. Okay, 1. Yes, Prof. Yes. Okay. Yeah. No. Just one last question.
Thank you very much. I have just 2 brief questions. One is to Dr. Makonese, and the other will be to Professor Lan. Doctor, my question relates to this whole thing about traditional leadership. I know we all take the view that they should not be involved in politics. But I think we are kind of exaggerating. These guys cannot be political eunuchs. And their role as traditional leaders is essentially political as well. And I do believe that political involvement may actually be positive, because they will enable their communities to derive certain goods from the government, which otherwise they would not have. But my question is, since we are all very critical about that political involvement, is there any framework that protects them and ensures that they remain what we call neutral? My second question is to Professor. I know this whole thing about right to development. You know that even at the union level, the Declaration of Right to Development has stagnated where it is. It has moved to the level of a convention. Why? Because 1, it is imprecise. 2, nobody knows what they're talking about. And 3, the rights are owed by who to whom. They're not been said. So confusing. And that's why states have been refused to move forward with that UN Declaration of Right to Development. Now, given the confusion even at that international level, when you advocate the constitutional right to development, what concretely are you saying within the nation states of Lesotho? That right is owed by who? Towards who? How do you make it effective within Lesotho? Thank you.
Thank you, Prof. Very interesting questions. So, in the context of Zimbabwe, where in which my paper is based, the system that is in place to protect them is the Constitution itself, because it clearly states that traditional leaders are not supposed to participate in any partisan political activities or further the interests of any political party. And I think that is a good provision, because what we've seen when that provision is not followed is that they actually force their subjects to vote along certain political lines, and therefore at the end of the day, the citizens that they preside over do not have the freedom to choose their own leaders, because the traditional leaders play the role of ensuring that citizens or those that they preside over further the interests of a particular political party. And in the context of Zimbabwe, it is of course the interests of the ruling party. And they have openly, I think, indicated, especially the leaders within the traditional leaders, have openly indicated that they do support the ruling party. When it comes to access to resources, yes, it is their duty, it is their responsibility to ensure that their communities do access those resources. But again, because they are partisan, what we've seen is that when the resources come, those resources are also distributed on partisan lines. They are not distributed to everyone within their communities. So that is where the challenge comes, in that in participating on having their political rights, they are not addressing the needs or protecting all their people that they preside over, but they only protect those that align with their political views. And I think that is where the challenge actually comes.
Yeah, the issue of the right to development has been a very controversial issue. Professor can talk more on the controversy around that. He experienced, he actually experienced the controversy on the right to development because his research was based on that. Right? But I'm not going to talk on the controversy because to me, there is no longer any controversy about the right to development. Right? If something is imprecise, we have the responsibility to make it precise. And the commitment that we have as scholars is to provide conceptual clarity to the right to development so that it eliminates that aspect of imprecision and the controversy around it. Right? So from the time the right to development emerged or was conceptualized, it has evolved progressively. And at the stage at which we are, there is a covenant on the right to development that has been drafted. It is currently being debated at the level of the UN General Assembly. And by virtue of what is contained in that draft international covenant on the right to development, there is very high likelihood that it is going to be adopted at the UN General Assembly. The reason is the countries that have championed this idea, the concept of the right to development, are mostly developing countries, G77 member states, and they have the majority in the General Assembly. So it is very certain that most developed countries, like the US, European countries, many of those, they will not adopt the charter, they will not vote for it. But the hope is that the developing countries, the G77 member countries that form a majority in the General Assembly, about 136 countries that make up the G77 group, right? They are likely going to vote for the International Covenant on the Right to Development. So eventually it is going to become a binding international treaty. And good thing about it is that when the drafting was still going on, it started as a covenant on the right to development. But later on, just at the tail end of the drafting process, they changed the name to International Covenant on the Right to Development deliberately. And the idea is that when the covenant is adopted, it's going to have the same status like the International Covenant on Civil and Political Rights, International Covenant on Social, Political, and Cultural Rights. So it is going to become an integral part of the International Bill of Human Rights. That is the idea. So it is going to happen. I am very hopeful that that is going to happen by virtue of the fact that the 136 G77 member countries are going to vote for it. We know a number of developed countries that will not vote for it, but that is not going to tell the covenant from coming into action. Coming to the other part of the question, with those of us who have been researching on the right to development, we've done the best that we can to give clarity on what the right to development actually means, what it entails, who are the right holders and who are the duty bearers. Like every other human right, the right to development belongs to individuals and peoples. That is the important thing about the development. It is unlike other human rights, which are mostly individualistic. The right to development has been agreed that it is a right that can be claimed both by individuals and also by peoples, as groups of people that identify themselves as peoples. Right? There's already jurisprudence on that. The African Commission on Human and People's Rights, the African Court, they have actually passed judgment, clarifying the idea of peoples and what it means by people being the right holders of the right to development. Professor Kunde Feta, who has been one of our leading scholars on the right to development, unfortunately, he passed on last month. We have a book project that we are doing currently, and he was one of the contributors to that book. He was the first person to actually submit his chapter. And his chapter was on the holders of the right to development. And he did a good job in really specifying the various holders of the right to development. So with this literature that is becoming available, it speaks to this issue of imposition about what the right to development is all about, who the right holders are, and who the duty bearers are. So obviously, like every other human right, the duty bearers of the right to development are states and the international community.
Thank you. Another round of applause for our panelists. This brings us to the end of the panel discussions, and thank you. Thank you.
Thank you very much, moderator of that session and panelists for that session. May I ask just Saraj and Elvis to just join us here. I do understand that this is a late hour, and I've been reliably informed that I think the word is honorandus. The person who needs to be honored, like promovendus, right? Honorandus, also has some other commitments. So we don't want to continue in his absence. So I think we'll be very brief in this last session. The idea is just to extend words of thanks and also to say something about the way forward, so to say. So I will perhaps just say about the way forward. I think we take on board also the challenge, as it were. How do we take the scholarship forward? I think the response that I would have to that is just, as much as scholars, we have different outlets. One of them should also be to influence public dialogue, to break down what we do here, maybe in fora that are not so accessible, into ways that speak more specifically to those that are affected by what we do. And I think that we can also think in terms of the project, how do we package it, as it were, in different formats. But as you know, 120 plus people submitted abstracts for this conference, testimony to the interest that there is in the work that Professor Fombat has generated. And we were only able to have a limited number. If you look at the program, 38 papers were scheduled for delivery here. And we asked people to submit the full versions of their paper, not only those who've been selected to participate here at the conference, but clearly there are others whose papers are also, the abstracts were accepted. And of those, I can say that by today we've received 27 full papers that have been developed. So that's very good. That's already a very fine publication. But the idea is those people who presented here and anyone who listens online, you are welcome to take your paper now and revisit it in the light of comments, maybe to your own paper, but also general comments that you may have been made aware of. I think we all got food for thought, certainly challenges, interesting perspectives. So we hope to receive all the rework papers by the end of January. That's a long time, we know, but it does allow people adequate opportunity. We will communicate this to all those whose abstracts have been accepted again, and that will be then the task of those involved in taking the publication forward to make out of that publication that at least will not be a doorstop for many thick doors, but will be selected, peer-reviewed, but I think it will certainly be quite comprehensive in its scope. And I think just to reiterate for those, and I think the most valuable aspect for me of the conference was how many people linked the perspectives they have, the novel insights, the analyses to the work of Professor Format. And that was very much the idea, right, of the conference itself. Constitutionalism in Africa, but in the light of Professor Format's scholarship. So that will very much also hopefully be the perspective of the publication that will come out. We encourage people to even take to a deeper and more profound level the engagement of your particular analysis, your development of scholarship, linking it back to and engaging specifically, critically, and otherwise with the work of Professor Format. So those are just some small thoughts. I don't know if my colleagues would want to add anything to that. Before we say thank you.
Yeah, for me, it's just a very thank you. Hello.
Yeah, that one.
So just a very quick one, and that is the fact that we will not have this conference again. We'll maybe sit here for the next 2 days. But then as we take the experience that we've shared from here, everything that we've discussed, it is very important that we get this implemented in our work and the things that we do. So the conference should continue that light. And the light, the point where those of us who are in practice, those of us who are in academia, that we take this very good spirit to continue that same conversation, because constitutionalism does not end here. It has to continue with the same spirit as we've been led by Professor Format. So that's what I want to say, and it was a great time having all of you. You will see me again. I think you will see us again, right? Many times. Thank you.
Thank you. Yeah. Thank you. Simply to say a big thank you, and for everyone who submitted the papers, as Prof. Franz said, please rework the papers. We all add the paper. I try, because they say all the good things. So I'll simply encourage you to rework the papers. And we were actually approached by a very good blog. They wanted to take some of the papers on the blog, but we thought it wasn't necessary because we want to publish those papers. We will get them peer reviewed, so that we give them the academic value, the rigor of research that is required for a work of this nature. Perhaps in the interest of time, I will simply give the mic back to Professor Franz to say a final word. And thank you again for coming. We want to publish the book through POP. I think it would just be the right thing to do. Pretoria University Law Press, as Professor Format has been submitted, so it'll be open access and certainly peer reviewed for those to whom that certainly is also important. So allow me then to just say finally a few words of thanks. Thanks. I think I'd like to start with our keynote speakers. Professor Judge Malife is still here. Judge Ribeiro unfortunately had to leave with the assistant. We really thought that set a very wonderful tone for the proceedings, and thank you for bringing yourself here at your own cost and being with us for these 2 days. And for your words, we will certainly give great exposure also to your speech. We will make it part of our dissemination of information after this event. Thank you very much to you both. Thank you very much also, I think, to
all of you who submitted abstracts, also people attending online, all the participants, among them those who submitted abstracts, those who prepared the papers and presented at this conference these 2 days. Thank you very much. For those of you who were part of the program in other ways, who served as chairs and helped in other ways, I would like to just also emphasize and single out perhaps those that were particularly involved in this. I think at the Faculty of Law, maybe in the SACHI chair, so to say, we have Pumeza, thank you very much. Also those involved with the SACHI chair, we have Cassius, Asane, Jesse, and then also Quilleen, who is, I think, well, not here, but she's online, and she has done her contributions online. At the Center for Human Rights in particular, the Democracy and Civic Engagement Unit, Bonolo, and also Tariro, I think they were really the ones who, particularly in the last period, did most of the heavy lifting, the logistical issues moved so swiftly and smoothly ahead, and thanks very much to their efforts and their professionalism. We can never leave out our communications team. Vicky is here, and also together with Simpiwe. We really appreciate your helping us. We, in the absence, maybe say to the staff of Future Africa also, thank you very much. We want to again say thanks, as I think from my point of view, to the co-organizers, to the African Network of Constitutional Lawyers, with the president here, to the wonderful collaboration. I don't even think we should single out any one of us. I just happen to be the one who's doing the words, but Professor Saj and ourselves, we were really there from the very beginning, together then joined by the network. It's really an event that many years in the making, right? We planned it in a way for an earlier time, and things happened, and the time was postponed, and it really is gratifying that eventually we could be here. Thank you very much. Then lastly, also to the honorandus, the person who brought us here. I think, we celebrate your scholarship. The dean said we should not speak about legacy. We speak about the present. We looked at the past, but we certainly also look into the future together with you. I saw you copiously taking note. And someone mentioned that there are many incomplete articles, ideas for further research, and I could see how your eyes sparkled continuously with the idea of where these thoughts that were expressed in this forum could take you, and hopefully could take all of us. So thank you once again for everyone who helped us to make this event, I think, the very important, memorable event that it became. And we wish you all the best. We wish you, Professor Fombat, all the best. We are proud to have been part of this, and I think all of us are enriched for having spent these days together with you and with ourselves too in this space. Thank you very much. Safe journey back to everyone, and